Colonels.
Division bench for orders. Item number 1.
Item number 1.
In view of the above considerations, we deem it fit to refuse the petitioner's prayer for bail. Accordingly, CRM DB 1205 of 2024 is dismissed. Urgent certificate.
I'm grateful, madam.
May I seek your lordship kindly to non-prosecution?
Yes, yes, please. Extension, non-prosecution, please hand over.
My lord, for non-prosecution.
Yes, please hand over. Yes.
Lord, may I permitted to paying a leave, my lord? My lord, the urgency is...
No, file it in due course. Colonelist.
Do we mention item number 1 and 2 for written notes of arguments?
Yes. Written notes.
Lord, unfortunately, I don't find my advocate on record. Notes are ready.
Item number 1,
I'll
lordship.
to your lordship.
I'll record that you will file it in the during the course of the day,
I'm
and I'll
much,
much,
much obliged.
May I file
Lord,
my,
just
my written notes? of
one
Yes,
fact.
lordship. Lordship, I'm for the...
Amnagar District Cooperative Bank's judgment, which my learned friend has relied,
yes.
that has been stayed by the Supreme Court.
Have
Last
you
night,
indicated that there?
Lord, notes were ready, Lord, before that. This
Achha.
morning, Lord, just while casually...
This is the stay order.
Stay order. There are two orders. First order is the stay, and second order is that it will be taken up in usual course because the parties did not comply with some directions.
The petitioner cited that you cited Bhavnagar.
No, no, I'm in the Mumberiya matter, in the second matter. Item number 2.
No, first matter. In the first matter, the petitioner cited this.
Lordship, first matter, lordship,
Yes.
first matter, I am for the petitioner, lordship. Lordship, my written notes of argument is ready, lordship. And my associates is on the...
But there is some disruption in the, I believe.
Yes, yes, absolutely. I'll get Mr. Shaha, Mr. Kaur has already got that leave, and I'll give you the leave
Yes.
to file in the course of the day. The synopsis of arguments filed on
Lordship.
the petitioners in WPA 10270 of 2024 be kept on record. First up, learned counsel for the other parties are permitted to file the written notes of arguments during the course of the day. First up, hearing is concluded in the matter, and the
Yes, lordship.
same is reserved for judgment.
Lord, my written submission has come behind us.
Lordship.
Is given the this.
Lordship. Very good.
Much obliged. Item number 3.
Lordship, Mrs. Shongita Rai, my senior is...
What is the correction?
Lordship, the name has not been recorded, Lordship. She appeared, Lordship, but the name has not been recorded, and she's...
For these reasons, don't mention. The name of one of the learned counsel apparently was not recorded in the previous order. Full stop, however, comma, that cannot be a ground for mentioning the matter for the purpose of correction, since there is no correction intent required in the order itself.
Lordship, she appeared
Let the
in
matter
the
go out of the
Lordship.
list. Next one. Be careful in your slips, the slips you give. Yes.
Item number 4, fixed matter.
My lord, I'm for the petitioner, my lord. Your order, lordship's order was tested in appeal, my lord. This is the order, my lord, that
My
was
lord, that
passed
was
by
the
the
rule
Honorable
made.
Division Bench. My lord, the Division Bench are directed to comply your lordship's order within a period of 6 weeks.
So I'll give them that.
My lordship.
6 weeks.
And my lord, there was a rule, my lord, issued against the Chief Medical Officer of Health.
They are
my lord.
present.
My lord, he is present, lordship, with full and hats, lordship.
For the time being, I'll dispense with personal appearance.
Lordship.
It is pointed out by learned counsel for the petitioner in the contempt application that An appeal was preferred against the order of this court, which has since been dismissed by an order
No.
dated,
No, stay application.
Appeal admitted.
Section, yes.
which has been admitted by an order dated April 29, 2024, full stop. However, comma, the prayer for stay made by the appellants therein was turned down, full stop. The appellants stroke alleged contemners were directed by the division bench
Para 8, Lordship.
to comply with the order of this court within 6 weeks from that date. Full stop. In view of the said timeline having been granted by the division bench, comma, let the matter stand over till June 14, 2024, when it will be listed under the same heading. Full stop. The alleged contemners shall file a compliance report with an advance copy to the learned advocate for the petitioner on the next returnable date.
No, personal appearance.
Achha. Personal appearance of the alleged contemners is dispensed with until further order.
I'm deeply obliged.
Please remind me, Mr. Galib, when it is complied with, finally I'll make it absolute. I mean, this.
Contempt application item number 5.
My
না, না,
application.
এখানে সোজা দূরে করে সোজা করে তারটা হ্যাঁ হ্যাঁ
First
thank you.
time.
My application for
Well,
contempt.
this is the first time. Let a copy be served because
Very Uh,
so that I can take instructions. What
Very
has happened.
the petitioner, learned counsel, having instruction to appear for the alleged contemner.
Lord, I
speak-
don't think, Lord, he's a contemner here.
Oh, you are not a contemner.
No, no.
Anyway, copy will be given.
Lord, will
What
be
is
Lord,
the contempt, Mr. Rai?
My Lord, your Lordship, Lord, had directed, my Lord, inspection to be held and, my Lord, steps to be taken thereafter, my Lord, in respect of a connection, my Lord, sought for. My Lord, inspection itself was not allowed to be held. My Lord, and,
No, they did not take police help.
my Lord, if your Lordship sees, my Lord, police also, my Lord, was there, but this, it could not be taken. My Lord,
Why
Lordship-
not implead them also as contemner? Why only the private respondent?
Lord, because, my Lord, Lordship kindly sees, my Lord, page 25. In fact, Lord, police also.
No, no, WBSCD cell did their duty.
Yes, yes. Police,
Anyway,
my Lord,
let,
should-
we'll consider that.
only one more thing, my Lord, the contemner number 1, my Lord, has died in the meantime. My Lord, his name has to be expunged.
Learned counsel for the petitioner, comma, at the outset, comma, submits that the alleged contemner number 1 has met his demise in the meantime. So accordingly, the name of the alleged contemner number 1 be expunged. Full stop. Next para, the learned advocate on record for the petitioner is granted leave to carry out the necessary consequential corrections to that effect during the course of the day. Full stop. In view of a prima facie case of willful and deliberate violation of the order dated September 5, 2022 passed in WPA 16720 of 2022, having made out inasmuch as the connection was registered to be given to the petitioner, comma, the petitioner shall serve copies of the contempt application, serve a copy of the contempt application on the alleged contemner, indicating that the matter shall be listed under the same heading on May 17, 2024, when the petitioner shall file an affidavit of service. Mr. Rai, you can give an extra copy to Mr. Kole also
If we
I'll
if
give-
we are
if
not,
they have anything to say, because
Yes,
then
yes, my Lord, because our allegation is not against them.
not
Lord, and
against them,
Yes,
not against
sir.
the police.
then it's not required.
Then
because it's not required because I think we'll
I'm
have
not
to think
police,
WP
there
if you want, Mr. Kola, I can implead you as a party to the contempt application.
if required because since I was appearing in the writ petition, my lord. No, my lord. I am not at all.
If required, definitely I will.
I do not know whether we have been made party.
No,
That's
no.
why I'm grateful to you.
Court.
Item number 6.
My lord, I am extremely sorry, my lord. Item number 2, my lord. May I produce the notes of submission?
I have given that liberty.
Thank you.
So apology is accepted. This is item number 6.
6.
6 is for the petitioner.
Time for the prisoner.
Yes, Ms. Patro, what did they do or not do?
Direction Lordship, immediate response, contemner has been served.
Lord,
No, service cannot be. There was a direction by court.
Lordship, for
Oh, acha,
impleadment of
for impleadment, my Lord, of, my Lord, initially the contempt was against us. My Lord, my Lord, we showed your Lordship, my Lord, the direction.
What is the order, the direction which has not been complied?
The Lordship sees, my Lord, the order is. at
Ms.
page-
Patro, what is the Contemptuous Act?
Lordship not affected the electricity connection within fortnight as per your Lordship
Yes.
direction. in
What
the
do you say,
deputation
Mr. Rai?
notice.
My Lord, your Lordship, my Lord, had directed in terms of the order, my lord, of the Honorable Supreme Court, my lord, to be direction to be given. If your lordship takes, my lord, page 50. Page 50. No, not of the supplement.
Of the writ?
No, my lord.
50 of what?
I'm telling my lord, I'm handing the wrong brief. Lord, if your
Ah.
lordship takes, your lordship will kindly take page.
This was that stepping down of the high tension thing.
Yes,
Yes, lordship.
Yes, my lord, the
Still not complete, Mr. Rai.
No.
No, my lord, there was a direction, my lord, in terms of the order of the Honorable Supreme Court.
Yes.
Lordship kindly sees, my lord, page.
Yes, it was.
Yes. Now, my lord, the Honorable Supreme Court had directed us to give them connection either through ourselves or through our agent. My lord, Cityscape Developers, my lord, who has now been added as a contemner, my lord,
Achha.
is our agent, who is, my lord.
Oh, you said that they are doing the mischief.
Yes, my lord, because they have, my lord, there is a step down transformer. It's a place, my lord, where high tension electricity is supplied.
Yes.
My lord, high tension electricity, my lord, cannot be supplied directly, my lord, to the inmates. It has to be stepped down to low tension.
Supreme Court order was also that it can be given either directly
To
or
an
through.
agent. Yes, yes.
All right.
My lordship kindly sees, my lord, page 15 of the.
So Cityscape, nobody's up here. Yes, what is your defense?
Kindly see the Supreme Court order and your lordship's order of 9th of August 2020. The Supreme Court order is annexed to the writ petition that was filed, page 38. 9th August, page 14. On page 38, Roman 1, 2, and 3.
Yes.
Yes, the first paragraph says, appellant is CAC. Appellant hearing shall supply high tension electric energy to the respondent by itself or through its contractor or agent. Next is, respondents would be charged and billed for consumption of electricity on low tension supply rates. Now, Lord, the order that was passed by the Supreme Court was while entertaining a special leave petition from an order passed by this Honorable Court in a writ petition filed by the petitioner itself. Now, the Lordship's order of 9th of August, the Lordship directed CESC, the internal page, the running page, the 19 of the contempt petition. Internal page 6 of your Lordship's order of 9th of August 2023. The second paragraph, a pragmatic reading of the said order leaves two options for CESC. It's only for CESC. Number one, first is to supply HT electricity to the petitioner, keeping in view the existing arrangement at the reconstructed premises at the rates of low tension electricity as per the terms and conditions by which the petitioner had been enjoying electricity previously. This is the first condition. Second is,
Let us come to the ordering portion.
yes.
Liberty, it was made
Yes.
the CSC Limited to give electricity connection within a fortnight under the same terms and conditions as was done. It is made clear that CSC Limited can either give a high tension electricity connection to the petitioner, yes, give a low tension. Liberty is given to the parties to file a further writ petition in the event the order of dismissal in default, in which event the petitioner shall also be entitled to seek an implementation of the order of the Supreme Court in an appropriate writ petition. So this second writ petition you say was not filed.
The second writ petition has not been filed. Now, the appeal that was dismissed has now been restored. Because the question in terms of the Supreme Court's order as to what will be the rate of consumption, that will be.
So Supreme Court directed to give them directly or through agent.
Yes, but if Lordship sees page 39 of the writ petition, internal page 2 of the Supreme Court's order, Roman paragraph 3.
Yes.
The payment by the respondents towards consumption of electric energy on low tension supply rates shall be subject to the decision in such and such filed by the appellant and pending before the Calcutta High Court.
Is there a decision in the misappeal? Then this order prevails.
Yes. The appeal was dismissed. Now the appeal.
Give the connection. Please give the connection.
Even your Lordship's order, my lord, clarify.
Give it within a week. I'll take it up next
Lord,
week.
even your Lordship's order, my lord, clarify.
TSC gives me HC connection, but I step it down for them to consume and then I supply HT. Now the existing arrangement was that suppose I buy it for 10 rupees, but I am also supplying or providing it for 10 rupees. Now if I tone it down or if I decrease the intensity and if I supply at LT rates, for every unit I will suffer a loss. So that is number one. And second, this is for New Alipur market complex. There are other existing occupiers, but you can see that I am reducing the intensity, getting HT from CFD, and thereafter I am providing HT. But everyone will come and they will ask for the same rate. But kindly visualize how much loss that I will suffer. This is number two. And third, I am told, I am not carrying a document to that respect There is the community hall of the Kolkata Municipal Corporation, where I am told that CSC is providing direct LT lines to the community hall. If CSC can provide directly LT hall to a community hall, CSC can provide a direct LT line to the writ petition itself.
Well, I'll give you 2 weeks time to file your opposition, both of you.
Very good.
Learned counsel appearing for the added alleged contemner submits that the appeal in connection which that the parent order, of which contempt has been claimed, directed the CSC Limited to give electricity connection to the petitioner at low tension rates, directly or through its agent. First of next para, it is contended that although the added alleged contemner is the agent of the CSC Limited, the direction of the Supreme Court, which was the premise of this court's order, inter alia recorded that the payment by the respondents therein towards consumption of electric energy on low tension supply rates shall be subject to the decision in MAT number 1633 of 1977 filed by the appellant and pending before the Calcutta High Court. First up, it is sought to be argued that in view of the said appeal bearing MAT number 1633 of 1977 having been restored in the meantime, the added alleged contemner ought not to be directed to give such connection. First up, next para, moreover, the added party submits that the said party will run at a huge loss if electricity connection is given in terms of the direction at low tension rates. First up, moreover, it is argued that the said connection shall create a precedent. First up, next para. However, from a bare perusal of the order of the Supreme Court, which was the premise of the parent order of this court, it becomes clear that only the payment of the respondents therein towards consumption of electric energy at low tension supply rates was to be subject to the decision in the appeal, concerned appeal. Full stop. The giving of the connection was not the subject matter of final decision of the appeal, and there could not have been any option in that regard. Full stop. Moreover, the appeal having merely been restored, it cannot be said that it has been finally disposed of for a merger to occur with the said final disposal. Full stop. Thus, neither the CSC Limited nor its agent can absolve themselves from the responsibility to give electricity connection to the petitioner. Full stop. However, since an internal conflict of interest has been raised by the added party with the CSC Limited, in order to bring a clear picture of the issue, the respondents / alleged contemners are directed to file their affidavits in opposition within a fortnight from date. Full stop. The matter shall be listed on reply, if any, shall be filed by June 14, 2024. The matter shall be listed under the same heading on June 14, 2024 itself.
Lordship, in the meantime, Lordship, the connection to be effected, Lordship.
First up, next para. It is made clear that in view of the above observation of the court that the order of the Supreme Court cannot be an impediment in giving connection to the petitioner, nothing will prevent the added alleged contemner to give the connection to the petitioner in the meantime. So, please come prepared. I mean, if I am not satisfied with your internal disputes, then I'll haul up both of you. I'll issue rules of contempt against both of you, CSC as well as you.
For a long time, Lord.
You have to meet your internal disputes, but the direction there that could not be a rider for you to take a defense. Only the rates were to be subject subject matter of the final disposal.
Lord, in that
but the giving of electricity connection cannot be.
Yes, my lord, in
That
fact, in
cannot
that
be
view of
denied,
the
Lord.
matter,
Please ensure that the connection is at least given in the
Yes,
meantime.
Lordship.
even the loss is subject to that.
It's hot situation, Lordship.
I'm telling you, I'm being
Connection-
very clear. Whatever are your internal disputes, if I'm not satisfied, I issue rule of contempt against both CSC and your client. So there won't be any, your egalitarian approach will be satisfied then.
Item number 7.
My lord.
7 who is appearing?
Yes, my lord.
Yes.
My lord, there was a direction from your side to give the information according to your terms of query
Yes.
regarding the government service examination. I gave for the post of sub-inspector within a week from the date. Though the time period passed out, they did not give me the information
Right.
according to the terms of query. After that, I filed a notice on them. I gave them some time for reply and objection from their side. When no reply and objection came from their side, I filed a contempt application.
Ultimately, what has happened?
My
They have
lord,
not yet given that reply.
no, I did not get my answer scripts. I did not get my marks in my.
Where is your query? Show me your query in the first place. What
my-
was your question to the information sought?
Wait, just a minute, my lord.
Page 25.
It also appears in the writ petition. Come to page number 3.
No. Come to your query. The information is sought before the commission, the SPIO.
Yes, my lord.
Page 25 probably.
Yes, my lord. Page 25.
Yes, Mr. Shen, what happened?
My lord, first, my lord, let him apprise your lordship about the queries. Now, my lord, me I tell now. Now, my lord, the queries were that in the year 2009, 2012, and 2013, my lord, 3 examinations were held separately. My lord, for the my lord, the recruitment by the recruitment board for my lord recruitment in the my lord the police force, either SI or my lord another post. Now, my lord, he sought for my lord the queries in his my lord the representation. Lordship that give me my answer scripts first, no problem otherwise if it is possible, and my lord give the answer scripts of the others, and then how much bribe was given to the my lord the members of the recruitment board, and these are total 8 numbers. Now, my lord, kindly see, my lord's order was dated 13th of July 2023. And my lord, it was directed by your lordship that within a specific period, my lord, the reply should be, in fact, my lord, the what should be reply, that is not the my lord, the order. We should respond to his queries. That is the my
So
lord.
the direction was to furnish the information in terms of the query.
Yes. Now, my lord, in terms of my lord, may I tell one thing before?
So have you given a reply?
Yes. I am coming to that. Then now, my lord, kindly come to page 37. Page 37.
Of what?
Page 37 of my affidavit. An affidavit filed by the alleged complainant. My lord, kindly come to page 37. Now, my lord, this was the my lord, the matter arising out of the information sought for under RTI Act.
Yes.
Now, my lord, kindly come to this was the reply. Now, lordship, kindly that this is the already it was provided with you. Now again, this is being supplied to you in terms of court's order.
What is the information?
Yes. Now, my lord, kindly come to page number 39. These are all the annexures to that intimation. Page number 39. From Central Reserve Officer, Kolkata Police to report section, and this was communicated to. With reference to the above, this is to mention here that examination for recruitment for the Kolkata Police in the year 2013, but similarly 2012-19 also informed, was conducted by Kolkata Police Recruitment Board, and the said board has been dissolved by government order number such and such dated 27th of May 2021. Hence, no record regarding the above mentioned examination is available at this moment, and government order is enclosed. Therefore, answer for all the questions except question number 8 could not be provided. Now, question number 8 was that the number of vacancy. Now, for question number 8, this office maintains the vacancy position periodically, like month-wise, year-wise. But in this case, there is no mention of any particular point of time. So this office is unable to provide the vacancy information at this stage. Now, my lord, the next page is, my lord, page 40. Page 40 is, my lord, that is the, my lord, the government memo dated 27th of May 2021. Now, here, this, my lord, the caption is dissolution of Kolkata Police Reservation Recruitment Board. Now, my lord, after having been dissolved, now, my lord, this particular officer, who is now the Joint Commissioner of Crime, Now, at that time, he was the, my lord, when the sought for the information, he was the information officer. Now, my lord, kindly, my lord, just, my lord, for my lord, my satisfaction, if your lordship kindly come to, my lord, section 2,
Mr.
subsection.
Sen, I cannot reopen the merits of the order at this
I'm
time.
not on
No.
that. I'm
There
not
was a
on that.
specific direction to give information where you represented at that point of time. Let us see.
Yes.
No. Why didn't you prefer an appeal then? Specific direction was there to furnish the information.
My lord, kindly
If you are
have a look.
represented, Mr. Sen, you are guilty of contempt.
My lord, kindly
You
have a
cannot
look.
bypass this. No.
My lord, kindly have a look.
Whatever was dissolved, whatever was
Kindly have a look
resolved,
to
no,
section
we cannot look
23,
into that.
subsection 5.
No, no.
Now, the
You are
information
directed to give
means-
the information, Mr. Sen.
Yes. Information means, lordship, kindly have a look.
Dekhi?
Under the RTI Act, lordship, kindly have a look.
Yes.
Because the expression information has been defined under the Act itself. And information means that I should have the access to that particular, my lord, the data, papers, documents, I should have access to that. Here, my answer that I have no access to that. But yeah, actually, that is a reply.
No, access, the
Lordship, kindly have a look.
please,
Section
please
23,
let us see the section. Can be accessed and information relating to any private body which can be accessed by a public authority under any law for the time being in force. So what law prevents you from having access to that?
Now, my lord, we sought for information.
Why didn't you say that at the
From-
time of hearing
from
of the
from
no?
the central reserve officer? My lord, this was communicated. My lord, lordship, kindly have a look. This was communicated earlier also before initiation of the writ proceeding. All this, my lord, the communication had been exchanged between the, my lord, the parties. All this communication.
Mr. Sen, there was a specific direction. You were represented. There was an argument. The direction was directing the respondent to furnish the information in terms of the query of the petitioner at the earliest, positively within 1 week from date. This was the specific order. If you have not given the information, whatever may be your defense, I'll issue a rule of contempt. Learned counsel for the alleged contemner, comma, by placing reliance on the definition of information in section 2 within bracket small f of the Right to Information Act 2005, comma, seeks to impress upon the court that the alleged contemner did not have access to the information. Full stop. Next para. However, comma, the order under contempt was very clear. Full stop. Thus, in the said order dated July 13, 2023, passed in WPA 14742 of 2023, comma, it was specifically directed that the respondent therein would furnish the information in terms of the query of the petitioner at the earliest, comma, positively within 1 week from that date. Pushed up. Next para. Learned counsel appearing for the alleged contemner seeks to take the court through the replies given by the alleged contemner. Pushed up. By way of an example, comma, the reply dated September 20, 2022, annexed at page 39 of the affidavit in opposition, merely says that the examination for which the petitioner had sought for the information was conducted by the Kolkata Police Recruitment Board, and the said board had been dissolved on May 27, 2021. Full stop. Hence, comma, a plea was taken, comma, no record regarding the above mentioned examination was available at the moment. Full stop. Next para. It was further stated therein that therefore, comma, answer for all the questions within bracket except question number 8, bracket closed, could not be provided to the petitioner. Full stop. Next para. For question number 8, comma, the alleged contemner disclosed merely that the office maintains the vacancy position periodically within bracket like month-wise, comma, year-wise, etc., bracket closed. But in the present case, there is no mention of any particular point of time, so the office was unable to provide the vacancy information at this stage. Full stop. Next para. The state was represented by counsel at the juncture when the order dated July 13, 2023 was passed. Full stop. Upon such contested hearing, comma, the unambiguous direction was passed on the respondent to furnish the information in terms of the query of the petitioner within a week. Full stop. Next para. It is palpable that the reply dated September 20, 2022 is a mere eyewash to furnish defense to the alleged contemner to the present contempt application. Full stop. Next para. The said reply discloses precious little about the information asked for by the petitioner. Full stop. If the alleged contemner was aggrieved, comma, there was every option open to the alleged contemner to move up in appeal, which having not done, comma, the said order has attained finality. Full stop. This court, comma, thus, comma, is of the opinion that the alleged contemner is guilty of contempt. Full stop. Accordingly, a rule do issue calling upon the alleged contemner to show cause as to why punishment shall not be meted out to the alleged contemner in terms of the prayer in the contempt application for the clear contempt committed by the alleged contemner in not furnishing the information in terms of the query of the petitioner. Full stop. The rule is made returnable on June 14, 2023 at 10:30 a.m.
Malad, may I tell one thing? Only one, Malad, one opportunity. May
No.
I tell?
No.
Malad, may I tell one?
No.
Thank you for the Lord for justice, my lord. Instead of my lord issuing rule, just my
No, no, no.
Normally, I do not.
Mr. Shen, this is becoming a habit of the government
Malad,
officials.
I'm not.
Let him come. He'll explain.
Yes,
He or she will explain when she comes. Yes. Next.
Item number 8.
Malad, may I tell? Lordship?
No, Mr. Shen. Nothing.
Malad, may I come?
No,
and
Mr. Sen, nothing.
develop the case on the next
You won't
day?
develop any case. Yes.
Normally come.
Who is for the petition in the
And for
next
the
matter?
petitioner, my lord, order was passed by your lordship on 29th of September 2023.
What is the order?
It is at page 15, my lord. Operative portion is at page 15. In view of the limited prayer made by the petitioner in WPA number such and such, is disposed of by directing the respondent number 6, the divisional forest officer, to consider the representation of the petitioner dated February 2, 2023 as expeditiously as possible, preferably within 3 weeks from the date of communication of this order to the said respondent.
No consideration.
Not yet, my lord.
A prima facie case of contempt has been made out inasmuch as the alleged contemner, comma, in defiance of the order dated September 29, 2023, has apparently not considered the representation of the petitioners and communicated the outcome of the said communication to the petitioner. Full stop. Accordingly, the petitioner shall serve a copy of the contempt application on the alleged contemner, intimating that the matter shall be listed next on May 17, 2024, when the petitioner shall file an affidavit of service to that effect.
Only one thing, my lord, the incumbent has changed. It has.
Then you will have to serve another copy. No, but you have. Acha, I'll give you leave. You immediately do it. প্রথম লাইনে যেটা বললাম একদম প্রথম প্যারাগ্রাফে learned counsel for the petitioner submits that in the meantime, comma, the incumbent in the office of the contemner has changed. Full stop. Accordingly, the petitioner is directed to implead the present incumbent in the contempt application. Full stop. Liberty is given to the learned advocate on record for the petitioner to carry out the necessary consequential amendment to the cause title of the contempt application during the course of the day.
Grateful.
Item number 9. Yes.
My lord, I am the petitioner.
Yes.
My lord, an order was given by you to give a lawful response to me within a week from the day of order.
Right.
So I should get everything that I have asked for in accordance to the law. I asked for my own answer scripts, though they did
Any
not,
reply was given to you?
they give me a reply that those answer scripts are not available.
Yes, I kept it open for you to prefer a first appeal against the if you are not satisfied with the reply, you have your opportunity open by preferring a first appeal. That leave was given. Prefer a first appeal. No contempt lies.
We have given all the replies.
Yes, no contempt lies. The petitioner appearing in person submits that the alleged contemner, comma, in violation of the order dated July 14, 2023, passed in WPA 14753 of 2023, comma, although has given a reply, comma, but not furnished any information to the petitioner, whose it is submitted that the petitioner is entitled to such information. Full stop. Perusal of the order dated July 14, 2023 reveals that the direction passed on the respondent stroke first authority was to give a response to the query by the petitioner under the Right to Information Act 2005. Full stop. Next para. Since such reply has been given, comma, it is now open to the petitioner to prefer a first appeal under the said act since the petitioner is apparently aggrieved by the reply. Full stop. In fact, comma, in the order dated July 14, 2023 itself, comma, such liberty was given to the petitioner. Full stop. However, comma, no contempt lies in view of a reply having been given by the alleged contemptor. Full stop. Accordingly, WBCRC WPCRC 37 of 2024 is discharged by giving liberty to the petitioner to prefer an appeal against the reply given by the alleged contemptor before the appropriate forum, comma, if the said appeal is otherwise maintainable in law. Push-up. Acha, did I direct any personal service? Personal appearance?
No, previously your lordship directed,
I had
that has been
dispensed.
complied with. Thank you.
That has been dispensed with.
Dispensed with.
And my lord,
Needless to say, comma, since personal appearance has already been dispensed with, comma, such dispensation is hereby made absolute.
Extremely grateful.
Thank you. The contempt application be deemed to be disposed of in terms of the above order.
Item number 10.
Yes.
The alleged contender, my lord.
My application, my lord.
What is the
Lord,
act of contempt?
my lord, in the order had directed me to apply for some certified copies through an application, my lord. The order is at page 19 and the application is at page 22. I had sought, kindly comes to page 22. I had sought for these documents, my lord. 1, 2, 3, my lord, they're numbered. My lord, 112. I'm seeing 11. There are two analogous matters.
Yes.
I'm sorry. Exactly same matters, both the cases. They were being heard analogously.
না এর কন্টেম্পটা কোথায় এর কন্টেম্পটা WPA দেখছি একটা সিপিএন দেখলাম আর একটা সিপিএন কোথায় এইটা প্রথমটা এটা ফটোকপি কেন এরকম ফটোকপি কেন এইভাবে কি ফাইল হয় নাকি এখন which CPN
112, my lord.
Page 22.
Yes, my lord.
22, yes.
Yes, my lord. The certified copies of the document marked, my lord, 1, 2, 3, 4, 5. My lord, 1 and 2 have been given. 3, 4, 5 has not been given till date.
My direction was
The direction is in page 19. But the operative part is in page 20, first paragraph and the second paragraph.
Yes, why didn't you give them?
We have given, as per your lordship's direction, we have supplied the information. Kindly see page 20 of the contempt review. What was your lordship's direction, my lord?
Yes.
My lord, the second paragraph, my lord.
Right.
Accordingly, WPA number such and such and are disposed of by granting liberty to the petitioner to apply for the relevant extracts of the order, as well as the relevant copy of the order of vesting pertaining to query number 8 and 9 of the petitioner, which relates to the 0.52 acres of land of partisan plot number such and such, my lord, as well as to apply for certified copy of the order as per query number 1 of the petitioner, which also pertains to the same property, my lord. You know, kindly see, my lord, what was the, my lord, query number 1, 8, and 9, my lord.
Right. Let us see that.
My lord, next page, page 22, my lord.
22, yes.
The certified copy, plain copy of all documents and orders in connection with
this you have given probably.
Yes,
1 and 2 has been given.
Yes, no, we have given, my lord.
Right.
But the 3, my lord, which they are saying, my lord, that was not the direction, my lord. But can you see what is the, my lord, query number 3, my lord?
Let me just check.
Certified copy, plain copy of all documents and orders in connection with
Not orders, but apply for the relevant
Certificate
extracts of
plain copy of
records.
all documents and orders in connection with such and such.
mediation case number by which the name of Ramchandra Malu was recorded as Rayat with respect to
But
0.52 acres of.
It's the fourth line.
No, I had directed you to give them relevant copy of the order of vesting pertaining to query numbers 8 and 9.
Yes,
what were the query numbers 8 and 9? Where are 8 and 9? Those are not annexed here?
No, my lord.
But we have annexed in my report, my lord. May I hand
Yes, fine that. Give a copy to them also of the report.
Kindly come to my lord.
The first page is this?
No, my
No,
lord.
no, not that.
Page, my lord. Page, my lord, 31, last. Annexed age.
Yes, yeah, sorry. 8, let us say 8 and 9.
Yes.
Eight and 9 at page 33.
33, my lord.
So 8 is
informed whether the 0.5 acres of land at RS plot number such and such was vested in favor of the government. If yes, please provide the copy of
yes.
the notification.
Have you provided extracts of this?
Yes, my lord.
What?
This and 9, 8 and 9, both.
Yes, my lord. 8 and 9, my lord. We have.
No. Kindly says.
I have, my lord, annexed compliance report.
Kindly says page, my lord, page 23 of my contempt application, item 4.
No, this is not the query. This is a fresh application by you.
My lord,
So we cannot look into this. Why should I look
my
into
lord
this?
directed us to make a fresh application to get the certified copies. My lord, at the point of time of disposing of the writ application.
Certified copy of the order as per
Yes.
query number 1.
Yes, my lord directed us in the order to apply.
You
for
say that
reply.
has been given.
No. My lord, certified of the gazette, no. Item 4, my lord. My lord is looking at page 23 of my contempt application.
Yes.
Yes, my lord, in the writ application, what had happened, I had asked for documents through RTI. My lord had directed that since you can get them through applying for certified copies, please apply for certified copies and those will be handed over to you.
No, the order was to apply for relevant extracts of the records as well as a relevant copy of the order of vesting pertaining to only to query numbers 8 and 9.
Yes.
Which relate to such and such.
Yes. My lord,
as well as to apply for certified copy of the order as per query number 1. Query number 1 has been given to you, you say. You are entitled only to 8 and 9 extracts.
Yes, my lord.
Not extracts, extracts as well as relevant copy of the order regarding 8 and 9 only.
Yes, my lord. 8 and 9 only. My lord,
8 and 9 pertain to
vesting order.
Yes, but we have given the
8 and 9 pertain to 0.52 acres of land, which has also been mentioned here. You sought, if yes, please inform whether those were vested. If yes, please provide the copy of the notification of details of such vesting and the date. They have not given you these notifications.
No.
But if the order of vesting has been given, my lord.
No, it has not been given. I have the documents that have been given to me.
Show me that communication of order of vesting to them. You must show that. You must have records of that.
And I'll just indicate, my lord, what had happened. They are saying that in 1970 the land was vested. In 2000.
Whatever. We are not.
I'll just.
They have to only show that they have given this to you.
Yes, my lord, 1970s vesting. They will show 2000. This order dated 2022, in which the land was recorded in my name. They again changed the nature. Recording in the land record document saying
you
that
have only asked for copy of notification or details of such vesting and the date on which. That vesting order has to be given by them.
Page 19, my lord. Annexure, my lord. Key of my report, my lord.
Put this by way of an affidavit, please.
Yes, ma'am. This report is also not satisfactory, my lord. This report is also not satisfactory. Yes.
You personally satisfy yourself,
yes.
And if it has not been complied with, do whatever. I wouldn't advise you. It put a
Yes, my lord. Also, point 9.
8 and 9, both, yes. They have to satisfy me on that. Yes. Learned counsel for the petitioner submits that although the certified copy as per query number 1 was given to the petitioners in terms of the order dated August 29, 2023, passed in WPA 1850 of 2023, the relevant extracts of the records as well as copy of the order of vesting pertaining to query numbers 8 and 9 of the petitioners as stipulated in the said direction of this court, have not yet been furnished. Full stop. Learned counsel appearing for the alleged contemnor submits that the copies of the orders have been served on the petitioner, but I do not find anything in the documents sought to be produced by the alleged contemnor to show that such copies were actually handed over to the petitioner or sent to the petitioner in terms of the order under contempt. Full stop. The alleged contemnor is directed to file an affidavit in opposition annexing all documents pertaining to such service, if done by the alleged contemnor. Full stop. Such affidavit shall be filed within a fortnight from date. Full stop. Reply, if any, shall be filed by June 13, 2024. The matter shall be listed on June 14, 2024 under the same heading for hearing.
May I make one request, my lord, in the affidavit in opposition, my lord directed only regarding to the service. My lord, may he, my lord, in the affidavit of opposition, my lord directed to provide the evidence regarding service. My lord, all the documents may be also annexed in that opposition.
No, they have to show that they have given those copies to you.
But if not given, they may serve.
Whatever. They'll explain in their affidavit. If I'm not satisfied, I'll issue a rule of contempt. The same order should be passed in both.
Both. Similar is also same.
Both. আচ্ছা, দুটো একসঙ্গে অ্যাপিয়ার করবে। The order passed above shall govern both CPAN 112 of 2024 and CPAN 113 of 2024. Thank you. ওটা affidavits করে দিও। Affidavits in opposition, affidavits in opposition. Separate affidavits in both.
Yes.
You please satisfy yourself first and have a talk with your officers. If you're not satisfied, ask them to do whatever. Because you will have to face me on the next occasion.
Yes, yes.
Item number 12.
Yes. পড়ে যেও না এই করতে গিয়ে এটা কিন্তু একটু লগবগ হয়ে যাবে। Yes, you're the alleged contempt now, obvious. Yes. Affidavits have been exchanged in this matter.
Yes.
What is the contempt?
Well, the contempt is all about there was a order upon the competent authority to act upon the allegation of
Please
the.
file your reply first. Your reply.
Fine.
Yeah. What is the violation?
Well, I will indicate the, the order which was passed to look into the allegation of the petitioner.
Show me my order which is under contempt. First that, then anything else.
Well, the order starts from the page 25 of the contempt application.
Who is the alleged contempt? The competent authority?
Competent authority.
Let me see the direction. What was given.
Well, the direction.
Page 29, last paragraph onwards. Yes. So to look into the complaints, hold preliminary inquiry.
My lord. Para 36.
Yes, and outcome to be communicated.
Yes.
Up to what stage they have done?
They have communicated us with an order which is nothing but an IUASH, a 2-page order. My lord, that is at Well, I am troubling my lord with the writ petition. It is over there.
Yes, which page?
At page 170.
No, writ petition could not have contained their communication.
My contempt application.
My order was passed in the writ petition.
Yeah.
It could not have been annexed to the writ petition.
I am indicating the
Contempt application. Oh.
Page number 170.
Page number, I'm sorry,
170.
Yes, Mr. Ganguly.
My lord,
If you are satisfied that it was complied with, this is a consideration as directed, then I am satisfied.
my lord,
Come to page 171 once.
yes.
You can read out also Roman 1. Not in all cases we shall direct a fresh writ petition to be filed. This is contempt.
My lord, may I just indicate two issues, my lord?
There was a
The
specific
order that
direction,
has
Mr.
been passed.
Ganguly, that you have to look into the complaints of the petitioner. None of the complaints are adverted to even.
My lord, yes, my lord, the order is not that specific, my lord.
That
I have,
specific?
my lord,
What do you mean by that?
my lord,
It is not an order at all. The direction was to look into the complaints of the petitioner, hold preliminary inquiry. inform them.
Well, all the
So
three
the
has been
first
done, my
component,
lord.
all the three has been done. Look into
My
the
lord,
complaints.
I'll show.
Which complaint has been dealt with?
My lord, it has not been written. My lord, no details are there, my lord, that I have
I'll issue
already
a
done
rule,
to, my
Mr.
lord. My lord, kindly bear me, my lord. My lord, kindly.
This attitude has to go, Mr. Ganguly. This attitude has to go.
My lord.
Election or no election, you spend your election behind the bars.
My lord, my lord.
You may not do anything else.
My lord,
Yeah,
may I
I'm
indicate
sufficiently
what I
satisfied.
have stated?
This is palpable and deliberate.
The report will show, my lord. My lord, let me give only 5 minutes. I won't.
Both of us cannot speak together. Please take a seat. It's not a running commentary I'm asking for you. Yes.
My lord, not more than 5 minutes, my lord. Kindly.
No question of 5 minutes, Mr. Ganguly. Read out this order first and say one of the complaints of them has been dealt with here. Even one.
I have, my lord, I personally, before filing this affidavit, my lord, I have checked that what have you done in this. My lord, what they are saying, my lord, I have stated in the affidavit also that I have considered all their documents as because a reply has been sought for and that explanation has been given. My lord, kindly see my affidavit at page 47.
Where is their complaint? Let me see their complaint
Yes.
first.
The complaint is
it annexed to
the representation? Yes.
Is it annexed to the
My lord,
contempt application?
At page 25 of my affidavit, my lord, the order that has been passed by you, lord.
Which page of the contempt application, Mr. Das? Your complaint? Page 35.
The gist of
My lord, page 41 is there. My lord, already I have annexed there. My lord, page 41 of my affidavit will do. My lord, I have annexed all, whatever has happened.
You are prepared on your affidavit. I'll see, look into their contempt application. Now, yes, let us see those. There are at least
29.
29.
Yes.
Out of this 29, I leave alone 5 or 6.
No, my lord, all
the
20.
first one is annual budget dated such and such was circulated at my gate, conducted, notice published regarding the verbal declaration. No, these are not the complaints. Which are the exact complaints? 1, 2, 3 are not complaints.
That they have not provided sufficient time for a notice.
No, let us see. Mr. Ganguly, let us come to
Yes.
I will indicate
3, 4, 5, 6, 7.
Yes.
All of these are substantial complaints.
Yes, my lord, page 47. Kindly come to my affidavit, my lord, at page 47. We have sought immediately after getting this, the order itself. My lord, we have asked the president of that, the competent the authority asked the chairman and the president that, look, these are the complaints against you, provide your reply. My lord, at that date of hearing, we have given, my lord, on 3rd of December, my lord, it is
page 47.
47. Is the reply from the association, my lord?
This is respondent numbers 2 to 11.
Yes, my lord, they were supposed to give the reply.
So, you are respondent numbers 2 to 11 in the contempt.
In the contempt petition.
Contempt there.
I think I'm looking into the writ petition.
My lord, in the contempt.
I'm sorry, you gave it right now. Yes. No, my mistake.
Respondent number 1, the sole
My
contempt.
mistake. 47, yes, I'm there.
Well, they were my lord, were supposed to give the reply. They have with paragraph wise stated that what has been hold over there.
Where is your discussion on that?
Well, there is no discussion. I have admittedly, I don't know, but I have perused all the things. They have given a reply to that. We have taken a reply. We have given a hearing. And after that, we have come to a finding. My lord, the finding has been stated over here in the order, my lord.
This is contempt.
My lord, in that event, my lord, details of it, because details paragraph wise, it has been stated. My lord, we have perused all the things. And we have come to the conclusion because the only point is that whether the budget has been properly utilized. My lord, it is with respect to that one only. And my lord, that we have already came to a finding after going through all their, my lord, the opposition has been given. Thereafter, my lord, they have filed their reply. We have considered all, my lord. My lord, we have annexed entirety, my lord. If your lordship kindly takes up for a moment, my lord. My lord, the affidavit at page 10.
Mr. Ganguly, I'll give you a fortnight's time. Within that, pass a proper order, adverting to everything, give them a hearing.
Well, then on a detailed order, my lord, we'll do. My lord, we have considered those. My lord, my specific instruction, and we have written on the affidavit also, my lord. We have taken their affidavit, the reply, and everything.
Of no use to you to send the competent authority behind the jail. You have your work done.
My lord, my lord, from the order itself, passed by my lord, they for very inception, they are saying the private dispute. They are not at all keen.
No, that was the defense there. That was a valid defense.
Same, they have reiterated in the reply. My lord, kindly come to page number 15, 16 of the reply. Page number 15, 16, my lord. kindly look into
The order.
what.
Let me come to the no. Let me come to the order.
Their pleadings. I mean,
Their pleadings I'm not interested. What
they have
is the
said
order?
whatever has been accusation has been done, that is right. It was found that every action taken by the president of the said association was in consultation with the BOM and was always communicated. It seems
Mr. Ganguly, why do you say in the first paragraph of your order that already had passed an order on 5th
My
of
lord, with
August?
respect to that was a order.
Who cares
Earlier
about
there
that? Who cares about that order? I directed you to hold a fresh hearing. And
yes, that we have done. That is
why
exactly.
do you say I have already considered, already passed an order on such and such directing?
Only on that occasion they were saying that this was not acting in accordance with law. Therefore, we have passed a reasonable order at that point of time. And now after this order, my lord, we have made our entire exercise, my lord.
Learned counsel for the alleged contender places reliance on the annexures to the affidavit in opposition and argues that a detailed reply was filed by the private respondents to the complaint of the petitioner. First up, it is submitted that the alleged contender, the competent authority, had given a notice to the private respondents, and upon consideration of all the replies, by holding an inquiry, came to the conclusion as reflected in the in its order dated December 22, 2023. First up, next para.
The hearing was also given.
It is also submitted that a hearing was given to the parties as well. First up, next para, a bare perusal of the complaint of the petitioner as annexed at page 35 of the contempt application shows that the same contains 29 individual paragraphs. First up, out of those, at least out of those, most were specific and separate complaints lodged against the private respondents. First up, next para, even the reply annexed to the affidavit in opposition was rather detailed. First up, however, the order passed by the alleged contender on December 22, 2023 reflects precious little apart from the statement of the alleged contender that the said contender had already passed an order on August 5, 2023, directing the president of the association to administer the association in accordance with the bylaws and other laws applicable to the association, which is as vague as possible, and in clause small ii, that the association put the budget for within single inverted utsav and festivals, single inverted close, into the general budget of the association as a component which is extraneous to the powers and duties of the association in terms of the bylaws quoted therein. First up, the alleged contender also observed that the annual financial statements for the year 2021-2022 and 2022-2023 were duly audited and approved by the members of the association. Pushed up, next para, such order is absolutely cryptic. Pushed up, next para, the specific direction given by this court was for the alleged contender to look into the complaints of the petitioner as to the alleged irregularities and malfunctioning of the association and its board of managers with regard to the association in question pertaining to the residential complex of Diamond City West, and to hold a preliminary inquiry for the purpose of forming an opinion under section 16 capital B within bracket 2 of the 1972 Act to ascertain whether there was any necessity to issue a show cause to the managers board of managers of the said association as contemplated under the said provision of law. Push up, next para. However, the order purportedly passed by the alleged contender, apart from being a totally non-speaking order, does not reflect how the competent authorities alleged contender dealt with each of the complaints made by the petitioner and the replies thereto given by the private respondents. First up, private respondents in the writ petition. First up, next para, that apart, nothing is reflected in the purported order as to what was the process of inquiry and exactly how the alleged contender proceeded about such inquiry, or the outcome of such inquiry. Full stop. The purported order dated December 22, 2023 does not even reflect anything about any inquiry having been undertaken by the alleged contemner, let alone dealing with each and every complaint of the petitioner. Full stop. Next para. Thus, the petitioner has made a concrete point insofar as the order of this court having not been complied with by the alleged contemner. Full stop. However, since there is an iota of doubt as regards whether the competent authority failed to understand the exact purport of the order of this court, for which, for the time being, a benefit of doubt is being given to the alleged contemner. Full stop. However, the alleged contemner shall, by May 17, 2024, give a further hearing to both parties and shall pass a detailed and reasoned order in terms of the order of this court dated October 12, 2023, passed in WPA 15463 of 2023, and file a copy of such order in court on the next returnable date, that is on May 17, 2024, with an advance copy to the petitioner as well as the private respondents in the writ petition. Post of next para, it is made clear that in the event the alleged contemner fails to do so, this time the court will be stricter in its directions against the alleged contemner. The contempt application shall next be listed under the same heading on May 17, 2024. আর প্রথম লাইনে একটা দিয়ে দিও, affidavits in opposition and reply filed to be kept under. Mr. Ganguly, impress upon your client. You may write the order also, but you look through the documents before doing that, because then I'll haul you up also. I'll understand the language if you write it. Next.
Item number 13.
Yes.
And for the petitioner, and on 19th of April, your lordship was pleased to give a direction to serve upon the contemners, my lord. But from the affidavit of service, I find when the contemner number 1 has received the petition yesterday, my lord, and apropos the contemner number 2, that he has not received the petition, when may I send him through email, my lord? I've got his email ID.
Who is he? I mean,
there are two contemners. One is block development officer, and another one is child development project officer.
Yes, you can send via email. I'll take it up next week.
Lordship.
You are filing that service now?
I can
file another affidavit.
I'll file.
Learned counsel for the petitioner files an affidavit of service. It is candidly submitted by learned counsel for the petitioner that the alleged contemner number 1 received the copy only yesterday, and proper service has not yet been completed on the alleged contemner number 2. Learned counsel for the petitioner seeks leave to serve the alleged contemner number 2 via email, which leave is granted to the petitioner. Upon such service, the petitioner shall file a fresh affidavit of service on the next returnable date. The matter shall be placed in the list under the same heading on May 10, 2024.
Grateful.
Item number 14.
No, I'm for the petition.
Yes.
But this is case contempt, new contempt application.
What is the violation, Mr. Ghosh?
Violation, my lord, your lordship, in terms of the direction of the Honorable Division Bench, the railway authority placed a cradle guard beneath my high tensile line in between my roof and the.
You are directed to remove the cradle guard and reposition it.
Yes, and reposition it, my lord, it fell down due to.
They have removed it.
No, my lord, they have set it, but it is now placed in on my roof. Your lordship, can you see your lordship's order, my lord, at page.
Sufficiently above the top of the roof, I
Yes.
said.
No, nothing. Lord, that was my complaint. I communicated.
They have not done it.
Not done. They have said I shall file review. They will file review application. As yet, nothing has been done. Lord, as back as it is dangerous matter, but in case of storm, it may affect the entire family any moment. Lord, kindly see their reply. That is at page 33. And Lord, my lord's order is based on the division bench order. Nothing new. Page 33. Has decided to file a review application.
The petitioner alleges that the order dated August 24, 2023, passed by this court in WPA 1055 of 2022, which relied on a previous division bench order passed in MAT 1793 of 2023 and directed the railway authorities to remove the cradle guard and reposition it sufficiently above the top of the roof of the petitioner's property as indicated in the sketch map annexed at page 28 of the said writ petition, and in terms of the order dated November 9, 2006, passed in MAT 1793 of 2023, has not been complied with. Full stop. It is alleged that the cradle guard has been placed immediately above the roof of the petitioner, thereby causing serious risk of life and limb to the petitioner and his family. Full stop. Next para. Since a sufficient prima facie case of contempt has been made out, comma, the petitioner shall serve copies of the contempt application on the alleged contemners, indicating that the matter shall be listed on May 17, 2024 under the same heading, when the petitioner shall file an affidavit of service to that effect.
Item 15.
Yes, Mr. Mukherjee, what is the contempt?
I am for the amendment page 17, paragraph 8.
First time.
The second time, my lord. First time it was.
Contempt application is appearing for the first time.
Second time, my lord.
Second time you have served.
Yes, my lord. Is Joshua get it? Over. Served through hand service.
I will be intervening in this matter.
Intervening in a contempt application. I'll issue a rule against you then.
This is my duty to bring the judicial notice about the order passed by your lordship, because this matter, your lordship, extend this time in my matter. Kindly see this order.
No, no, no,
The
no.
contempt.
No. I won't go into the merits of the order.
No, no.
It is for the contemners to know.
No, only one thing. No, your lordship, extend this time. This matter.
No.
Kindly see paragraph 7. Extend this time.
Extend time for what?
Your lordship, on the earlier occasion, granted time within fortnight. Thereafter, in my matter, you lordship extend the time to disposal within 8 weeks.
That 8 weeks has not yet elapsed.
No.
He was not a party in your matter?
No. Because, my lord, the learned advocate appearing from the government side, produce this copy of the order. Thereafter, after producing this copy of the order, you lordship pass this order. Can you see paragraph 7?
But the contemners should produce that. Help the contemners, but you cannot come in.
But this is my duty to bring the judicial notice. The time has not come as yet. That's all.
Page 17, paragraph 8, my lord. The order was passed, my lord, and I have communicated the order in person.
You are appearing for what is your client's name, Mr. Dotto?
My Movable Hasan.
You are handing over the copy of that order?
Yes.
Please give a copy to them also.
I am giving the copy of the order. Paragraph 7, can you see?
Give a copy to them.
I am giving the copy.
Give a copy during the course of the day. I'll keep it next week, but
No, can you see paragraph 7? Can you see paragraph 7?
no, you have to give a copy to him.
No, I will give the copy.
He was not a party. How can you know otherwise?
Because the learned government leader has produced the copy of the order.
Learned counsel, despite service, none appears for the alleged contemners. Full stop. Although otherwise, comma, in normal circumstances, comma, a rule would have been issued for the deliberate abstinence of the alleged contemners when the matter is called on for hearing, comma, Mr. Soumen Kumar Dotto, comma, learned counsel appearing, learned counsel who had appeared for the writ petitioner in a different writ petition bearing WPA number 25596 of 2023, comma, hands over a copy of an order dated March 5, 2024, whereby Mr. Dotto submits that the time for compliance in terms of the order under contempt in the present contempt application had been extended for 8 weeks from the date of the said order, that is from March 5, 2024. Push up next para. Even that time has elapsed.
No.
8 weeks since 2 months.
2 months.
That has barely just very well. A copy of the order handed over by learned counsel Mr. Dotto is kept on record today. Full stop. Next para. Mr. Dotto is requested to hand over a copy thereof to his to the learned advocate appearing for the petitioner in the present contempt application during the course of the day. Full stop. In view of such changed circumstances, comma, the petitioner is directed to take instructions in the matter and to give a further notice to the alleged contemners, indicating that the matter shall be taken up under the same heading on May 10, 2024. Please give the copy immediately and give the detail. Mr. Datta, give the details. You can take a printout, Mr. Mukherjee.
I'm giving the number.
If you can, please ask your learned junior to just ask your clerk to take out a copy and give
I'll
it.
give a copy. I'll give a copy. Where possible.
Consider this order, Mr. Mukherjee.
Item number 16.
I'm appearing for the petitioner, your lordship.
Petitioner, yes.
Lordship, the lordship's order dated, my lord, 6th of March 2024, my lord, annexed as page number 23 of my contempt application, your lordship.
This is appearing for the first time, Ms.
My lord, this is appearing for the first time. My lord, operative portion, page 24, my lord. Page 24, paragraph 8. The respondents are restrained from dispossessing the petitioners pursuant to the order dated January 29, 2024 till March 13, 2024.
What was done?
My lord, the possession was taken on that very day. My lord, the order was passed ex parte, my lord. My lord, on that very day,
They will claim that they did not have notice.
No, my lord, because, my lord, if may kindly comes to page number 27. My lord, I have sent a mail on that day. Order was passed at 3 p.m., my lord. At 3:08, I have sent them a mail.
Yes.
My lord, which is there as page number 27. My lord, thereafter, my lord, my lord may comes to page number 31, your lordship. Lordship will find this is the house, my lord. Possession has been taken. My lord, at page number 32, if my lord comes, my lord, the date will appear as 6/3/2024. My lord, in spite of my lord having the notice, my lord, thereafter, if my lord comes to page number 33, my lord will also see that I have sent them the letter. A hand copy was served to them, which was duly received by them on 7/3/2024. They ought to have, my lord, opened the lock and key of the premises, which they did not do, my lord, and instead of that, they are putting my property under sale.
Learned counsel for the petitioner submits that in deliberate violation of the order, in willful and deliberate violation of the order dated March 6, 2024, passed in WPA 6209 of 2024, comma, despite the petitioner having communicated to the alleged contemner by email at 3:08 p.m. on the said date of the order, comma, the possession of the property was taken from the petitioner on the same day. Push up next para. It is submitted that despite having been communicated again physically on the next day, comma, the alleged contemner refused to reverse the said action, comma, thus being guilty of contempt. Full stop. Next para. A prima facie case of contempt having been made out, comma, the petitioner shall serve how many contemners?
My lord, 4.
Copies of the contempt application on the alleged contemners, indicating that the matter shall be listed under the same heading on May 17, 2024.
My lord, if some preference be given, because my lord, my son is not being able to go to the school since all my belongings.
What class?
My lord, class 5.
How soon can you serve?
My lord, by Monday.
No, even then, very good. On May 10, 2024, when the petitioner shall file an affidavit of service to that effect.
I'm grateful to you.
10th May.
Grateful to you.
Served by several modes, Ms. Roy Choudhury, so that there is no doubt on that service.
Lordship, I will. Grateful to you.
Item number 17.
Yes, my lord, I will appear on
17. May I please your lordship?
Online, my lord.
Yes.
This matter is appearing for the first time, your lordship. Matter is appearing for the first time. My lord, kindly come to page 18.
For the first, what is the content?
Lordship, kindly come to page 18. Your lordship's order dated 6th March 2024. Kindly come to page 19, para 6, your lordship, operative portion of the order. Your lordship was pleased to direct the respondent number 2, DM Paschim Mednipur, to release to commence the disbursal of old age pension to the petitioner, your lordship.
Yes, not
it was
yet.
communicated. Kindly come to. No, 2 months have gone, your lordship. Still date, no commencement, your lordship.
A prima facie case of willful and deliberate violation of the order dated March 6, 2024, passed in WPA 27510 of 2023 has been made out to the effect that the alleged contemner, comma, in deliberate violation of the said order, comma, has not yet commenced the disbursal of old age pension to the petitioner, comma, thereby putting the petitioner to extreme difficulties. Full stop. Next para. Accordingly, the petitioner shall serve a copy of the contempt application on the alleged contemner, indicating that the matter shall be listed on May 17, 2024, under the same heading, when an affidavit of service to that effect shall be filed by the petitioner.
Grateful to you, Lords.
Thank you.
Item number 18.
Item number 18, Lordship.
Yes.
I am appearing for the petitioner led by Mr. Uttiora. Lordship.
Led by Mr.
Uttiora.
Yes.
Lordship, your order has been complied to the extent of the admitted dues. Lordship, and Lordship's order has given us liberty to approach appropriate forum in case there is any dispute. Lordship, it may be disposed of. Lordship.
Thank you. Leonard, what is your name? I will not record the name of Mr. Rai. What is your name?
Arnab Mandal.
Mr. Arnab Mandal, appearing for the petitioner, fairly submits that the order of this court has been complied with. Puts up insofar as the liberty given to the petitioner to approach the appropriate forum regarding the non-admitted dues, comma, the petitioner, comma, it is submitted, comma, is taking due steps in that regard. Full stop. Upon hearing learned counsel for the parties and being satisfied that the order of this court has been complied with, comma, CPAN 699 of 2024 is disposed of as infructuous. No arrest to cause urgency. Sorry. Okay, no arrest to cause urgency.
I am grateful.
Thank you.
Lordship, affidavit of service.
Yes. প্রথম লাইনে ওটা অ্যাড করে না এভিডেন্স সাইডস নেক্সট
Item number 19.
I am for the petition.
Well, I beg to appear on behalf of the CSC.
Lordship, I beg to appear for the alleged contempt number 2. Lordship, kindly seize the order. Page number 19 and 20 is the order in the writ petition.
How about a copy?
I mean, পাঠিয়েছি affidavit of service file করেছি.
You have served on all the alleged contemners.
I have served, Lordship.
You have checked up good service
Yes,
has been
yes.
affected because I'll issue a rule otherwise.
Everyone has been delivered.
Yes, what is your defense?
Lordship, may I submit one thing? Lordship, after the said order, we have also deposited the cost for the police assistance. That is, Lordship, page number 21. They have taken rupees 25,200.
Yes, police officer in charge is also the contemner number.
yes.
I've seen that.
My lord,
Yes.
we have written several letters, my lord. To
You are not the contemner, that's why.
My lord, the point
Implead him also as a party. He has an opportunity to appear then.
Yes, I have also made them a party. See,
You are also a
yes,
party,
yes.
good.
Second respondent.
What is their
my
role?
district engineer has been made a party, my lord. My lord, the meter room has not been constructed, my lord. If it is not, my lord, there is a specific direction from your lordship in the earlier order that the upon compliance of formalities, the line will be given.
Yes, what is
And
your
we have
defense?
raised,
Understand.
They are constructing the meter room on my property.
That cannot be reopened after the order.
Lordship, they have not also appeared in the writ petition.
There is a civil suit going on.
Maybe.
Nowhere in the writ petition, nowhere in the contempt matter, they were
No.
nowhere.
Then you should have filed either a review or an appeal.
They have
Having not challenged this order, you are a party to this writ petition.
I was a party to the writ
They have not
petition, my lord. My lord,
in spite of service, they have
in
not
spite of
appeared.
service,
Kindly
my lord,
seize the order, Lordship.
I'll issue a rule against you then. You are guilty of contempt.
Lordship,
You cannot say anything.
Kindly peruse the photographs first.
Why should I peruse any photograph?
Once, my lord.
No, I won't.
For my
We cannot reopen. You satisfy yourself outside court, Mr. Gangu.
my lord, kindly,
No.
my lord,
There's an order staring at your face. You have to comply.
my lord, the compliance will be done, my lord. There is no.
I'll issue a rule against you. Your client will present and explain.
I'm not standing on the way, my lord.
Insofar as the others are concerned, you and the officer in charge, your client and the officer in charge will be present in court and explain. And as far as they are concerned, since they take a stand that they have written to the police, they will be entitled to file a brief report or affidavit.
Them also, my lord.
File an affidavit.
My lord, point remains that, my lord, the meter room is getting constructed on my property.
Learned
My lord,
counsel.
ingress and egress will be
I'll
stopping,
record
my lord.
that. I'll record that. Learned counsel for the petitioner submits that in gross violation of the order dated November 16, 2023, passed in WPA 23683 of 2023, comma, the alleged contemners have not yet given electricity supply to the petitioner. Full stop. Next para. Learned counsel appearing for the You are for which alleged contemner?
মানে টু মানে আমাকে একটা ব্রিফটা দেন
আরে একটাই কপি কি
For alleged contemner number 2 submits that the CAC Limited wrote to the police authorities,
we have written to the
another
wrote to the petitioner asking the petitioner to construct a meter room, which has not been done as yet by the petitioner. Push up next para. However, comma, insofar as alleged container numbers, you are 4 and 5. Alleged containers 4 and 5 are concerned, comma. It is a stand.
It is 3 and 4.
3 and 4.
They are 3 and 4.
No, no.
4 contemners.
Achha.
3 and 4 মানে
My internal page 5 of
3 and 4 are concerned, comma. Learned counsel appearing for the said contemners take the stand that the meter room is sought to be constructed by the petitioner on their property. Push up next para. A bare perusal at the order dated November 16, 2023 indicates that despite service, comma, the private respondent stroke alleged container numbers 3 and 4 chose not to appear when the writ petition had been called on for hearing, which was recorded in the said order as well. Push up next para. Since the alleged container numbers 3 and 4 were private respondents and thus parties to the writ petition, comma, they are squarely bound by the direction passed therein and cannot now seek in a contempt application, comma, to reopen the issues involved in the said writ petition. Push up. As such, comma, the lame excuse put forward by the alleged container numbers 3 and 4 through counsel that the meter room is being constructed on their property, comma, having not been taken previously, comma, cannot now lie in the mouth of the said alleged contemners, particularly in the hearing of a contempt application. Pushed up. It is also not the case of the alleged container numbers 3 and 4 that they have ever filed any review application or challenged the order under contempt by way of any appeal. Push up as such, comma, the action of the alleged contemners 3 and 4 in deliberately flouting the order of this court prima facie raises a presumption of willful and deliberate contumacious act on the part of the said contemners. Full stop. Insofar as the alleged container number 1 is concerned, comma, he goes one step further in not appearing or being represented today when the contempt application is taken up for hearing, comma, despite being served, comma, which is reflected in the affidavit of service filed in court today. Full stop. Hence, comma, insofar as the alleged container number 2 is concerned, comma, the said alleged contemner shall file an affidavit in opposition to the contempt application within a fortnight from date, disclosing whatever submissions are sought to be made today by the said alleged contemner, whose reply, if any, shall be filed by June 14, 2024 by the petitioner. However, comma, inasmuch as alleged container numbers 1, 3 and 4 are concerned, comma, a rule do issue against the said alleged contemners, asking them to show cause as to why the penal measures as prayed for in the contempt application shall not be taken against them for willful and deliberate violation of the directions passed by this court on November 16, 2023 in connection with WPA 23683 of 2023. Full stop. The rule is made returnable on June 21, 2024 at 10:30 a.m. comma, when the contempt application shall also be listed along with the said rule for the purpose of hearing the parties. Full stop.
I'm grateful.
Grateful.
Affidavit of service filed to be kept on record. Yes.
Item number 20.
Lord, I am appearing, Lord, on behalf of the petitioner.
Yes.
The order, Lord, the violated dated 13th of March 2024, appearing at page 22.
Right.
Lord, the relevant page appearing at page 38, kindly have a look at paragraph 51.
Nothing has been paid, Mr. Dattu?
Nothing has been paid, Lord. The audacity they have shown, Lord, my learned junior is there, Lord. Mr. Sai is handing over a Lord communication. Kindly have a look at this. Kindly see, Lord, the no internal page number is there. Lord, the second last paragraph, fourth paragraph, page. The first paragraph. The GTC of the, my Lord, got it.
What has this? What is the statement made there?
Making that on the basis of the advice and the such and such, the authorities against the making payment, the petitioner and the contractor along with the applicable rate of the interest as per the consent order. This advice based on the following reasons.
No, I'm sorry. I opened the wrong page probably. I'll just check up.
Page number 4, Page number 4.
4.
Part 1, Milord.
Oh, yes, yes. I'm sorry. Yes. Please continue.
C Roman 2 of the GTC agreement. In this regard, the panel advocate Mr. Such and such, the learned senior counsel and they accordingly advised the ECL authorities against the making payment of the such and such to the petitioner contractor along with the applicable rate of the interest such and such. The advice is based on the following reasons. So the advice specifically has been given not to make the payment, Milord. This is unheard of.
No, because they were they read the complete sentence till the it is based on the following reasons that they are pursuing an appeal. Has it been filed?
Yes, Milord. Day before yesterday, Milord, we have received a copy of the appeal, Milord, and Milord, the application also. They are not pursuing it. Even Milord, they sent. They can give the advice. There is no difficulty. But Milord, the pending the appeal, it does not mean that automatically the order would be stayed.
At least serve a notice on them. I'll direct you to serve a copy.
My lord.
Learned counsel for the petitioner submits that the alleged contemners have, in willful and deliberate violation of the directions of this court dated March 13, 2024 in WPA 26622 of 2023, refused to pay the amount as directed therein to the petitioner. First up, learned counsel for the petitioner hands over a bunch of documents, including a communication made to the petitioner where it is indicated that the counsel of the alleged contemners advised them against making the payment in terms of the said order, apparently because the alleged contemners were to pursue an appeal against the said order. Full stop, next para. However, in order to give an opportunity to the alleged contemners to have their version placed before the court, the petitioner shall serve copies of the contempt application on the alleged contemners, indicating that the matter shall be listed under the same heading on May 17, 2024, when the petitioner shall file an affidavit of service. The bunch of documents handed over in court today is kept on record.
Grateful, Milord, accommodating me on the
thank you.
Online.
Item number 21.
If Mr. Chakraborty has got it, then no difficulty. Whatever it is.
Mr. T. Chakraborty.
Mr. T. Chaudhary. 21 and 22, right.
May I say this?
Kindly not the issue can be resolved here and now.
Yes,
please come to page 40 of the opposition used by my learned friend in the.
Mr. Chakraborty, is this a hairstyle deliberate or just to show the court that you were busy and running from some other court?
I don't.
I think the latter.
No, I was not busy. I was.
You use that as a mirror.
Yes. Not a habit of.
We also do it. Sometimes. Sorry, Mr. Majumdar. Yes. How can it be resolved? What is the matter?
We know one gentleman of our court who doesn't comb his hair.
That is deliberate.
Yes, that is deliberate. That's unkempt style. Then I look at page 40 of the opposition used by my learned friend in connection with my application.
Own application to the
First. There were injunction orders, not which still subsists, but that is with regard to nomination as we find now.
This was aware from 2021. No. This is going.
So what is the matter? I have completely forgot. Their opposition, let me find.
The legal heir had a succession certificate. She wants to operate certain FD accounts. Now, there are certain parameters, certain things which have to be complied with. The account has to be either closed on withdrawal of the entire amount, or if they want to be co-holders of the account, then there has to be a first holder, second holder, third holder. So there are certain forms which have to be filled up, which she has filled up, and there are certain documents which have to be signed in presence of the manager. Not everybody knows.
But they're not letting you do that.
No, please have a look at page 41.
Of the opposition?
Of the opposition.
41, yes. This is the opposition in connection with
899.
can 1 of 16,532.
899. 8999.
Oh, different. Already 8999, page 41. I'll open that. Yes.
But these are the documents, not which have to be signed in the presence of the manager for the purpose of his or her.
You have done it.
He has filled up certain forms. But these have to be signed in presence of the manager. That we have requested her kindly fix up a date here and now. Let Mr. T. Chakraborty give the time here and now.
I'll treat you to the manager and in your
Well,
presence.
today, my lord, mind kindly come to page 42.
That is the premise of the main writ petition also.
No, my lord.
That was for different.
My lord, premise was-
Unfortunately, the learned counsel the learned advocate representing the bank sought to justify the client's stand in not complying with the order.
Order from 2021.
That's
My lord, that
was an interim order in the writ
No,
petition.
no,
Writ is not pending.
Disposed-
Writ has been disposed of.
My lord,
Oh,
Petitions have been disposed of.
recalling after 3 years.
fair enough of Mr. Chakraborty.
Yes.
My lord, page 42, kindly see just page 42.
That's a symbiotic relationship we have. We didn't have the occasion to ask you.
Page 42, my lord, kindly see the today,
Yes.
my lord, fourth pair. Today on 16, I visited the branch. And my lord, whatever I was told, I had given according to my instruction. My lord, if today, my lord, if my learned friend says, I will go today itself, I'll resolve the issue. But my lord, according
You are appearing for the bank.
No, I appear for the bank.
Or the other way around.
Yes. I am for the writ petition.
So very well, fair enough. Then you are not fair. He is fair. Anyway, so you go to the bank, comply with this. I'll refer to this page. I'll refer to the letter date so that you can, it will be easier for.
13 March 20.
Mr. Mujumdar, give me a time. By tomorrow, it can be done.
Yes.
So today we are, tomorrow bank is open or closed. Let us check that first.
Saturday.
First Saturday. First
Tomorrow,
Saturday.
Monday.
Tomorrow is first Saturday.
No, tomorrow, my lord, tomorrow we will do.
Tomorrow, first Saturday, Mr. Mujumdar will direct. At around, say, what, 12 noon? 12 noon. Learned counsel appearing for the bank submits on instruction that if the formalities intimated to the petitioner by the letter dated March 13, 2024, annexed with the affidavit, annexed at page 40-41 of the affidavit in opposition to Can 1 of 2024 in WPA 8999 of 2020 are complied with by the respondents in the application, comma, there cannot be any impediment in the formalities being complied with, in the formalities being completed, and the respondents being permitted to open a fresh account, Mr. Mujumdar.
She wants to close
the account.
To close the account standing in the name of the deceased predecessor in interest of the respondents, and anything else? Only that, to close. Close and go away with the money.
To operate also, man, to operate.
Then you have to open a new account. If you close, how can you operate a closed account? Oh.
Man, there are two accounts. There are FD accounts and saving accounts. But I'll close and take back the money. I'll take
to close the account jeta bollam, and at their option, comma, to reopen such accounts with the petitioner bank afresh. Full stop, next para. In order to obviate further service of notice, comma, the respondents are directed to be present at the concerned branch of the petitioner bank on tomorrow, that is on May 4, 2024 at 12 noon, full stop. Upon such, upon the petitioners, upon the respondents so attending, comma, the petitioners shall cooperate with the respondents and see to it that the formalities are duly complied with in the light of the above observations. Full stop. The matter shall next be listed on May 10, 2024 for passing further orders. 5 minutes. 21, 22, should I pass separate orders or same?
Covered both.
Then the affidavits have to be, no, the page number is same. No, I have referred to particular page numbers. That
in
has to
view of
change.
order passed in item 21, no order is required to be passed further.
আচ্ছা, very well. পরের 22 তে in view of the order passed in WPA আগেরটা 8999 যেটা বললাম, comma, the parties are to comply with similar formalities as observed in the said order. Present writ petitions shall also be listed along with 8999 of such and such on May
The
10,
matters-
2024.
In both the matters, accounts are same. So, not in view of the order passed in item 21, your lordship may not have to pass a fresh order in 22 or separate order in 22.
Very well. তাহলে সেকেন্ডটা যেটা বললাম সেটা কেটে দিন। In view of the order passed in WPA number 8999 such and such of such and such, no further order need be passed in the present matter.
Item number 23.
My application, my lord.
Yes.
There are 4 applications that are coming up together. Can 4 and 5, these are the affidavit in oppositions. And replies have also been prepared. We had given an advance copy on the last occasion, my lord. Since these had been not received by me from Delhi, I had given advance copies, my lord. And my lord had also recorded that investigation has been completed and report has been placed before the central government.
Yes.
But it is for the central government now whether they accept it or not.
Correct.
Once the central government accepts it, then it becomes a formality is achieved.
Only thing is, my lord, can 3, 4, 5 and 6 are appearing. 5 in all likelihood has become infructuous. 6 is in aid of 5. 5 was for them to not continue to harass me by calling me and to finish the investigation. Now they have done.
What had you challenged? Just remind me.
My lord,
SFIO investigation you had challenged.
SFIO investigation, 2 parts to my writ petition. My lord, the SFIO and the liquidator, the company has gone into liquidation in 2018.
Right.
The crux of the issue is that when the company goes into liquidation and the SFIO investigation starts, the SFIO in tandem with the liquidator goes and makes a search and seizure in my office for 4 days. And though the company under investigation is Gujarat NRE Coke, they go ahead and collect documents with regard to a lot of other unrelated companies where I or some family member is a party. So there were 2 parts to the writ petition. One is for an expeditious completion of the investigation. That's in the main writ. Second was that with regard to this investigation that had happened, they could not have relied or taken custody of these documents because under the Act, the SFIO nor the liquidator has any authority to do a search and seize and collect documents. With regard to the first part, I think now they've submitted that this is investigation is over. So Can 5 was in aid of my first prayer. Now Can 5 goes. Can 6 is in aid of Can 5, where under section 212 subsection 13, I am entitled to apply to a court, or rather the court, to have a copy of this investigation report which is submitted to the central government. Can 6 is only with 2 limbs to Can 6. That I don't think they can really oppose here. One is that investigation report be made over to me. And secondly, by my Lord Justice Bhattacharya's order, the preceding coordinate bench that was hearing this matter, there was a direction to preserve the CCTV footages of everything that was going on. This should not be understood, or this direction by the court passed earlier be not understood to be restricted only during the investigation, but this preservation should continue. They should preserve the CCTV footage. I can show those 2 paragraphs. That is just Can 6, my lord. I believe Mr. Bhattacharya had come and requested me that he wants to take an adjournment.
Lordship, I would like to add, I'm appearing on behalf of respondent number 7, Your Lordship.
That's
on the earlier occasion, Mr. Anuj Singh was briefed in the matter, but unfortunately he had to recuse because he was appointed as special officer. I was praying for an adjournment to grant us some time to brief a counsel and to appear, because our application is Can 3, Your Lordship, for rectification of an order dated 21st June 2023, Your Lordship. Lordship, might I add something? Can 5 and 6 has not been served upon us as of yet, as per instruction from my clients, Your Lordship. Like Mr. Banerjee and my senior learned friend said.
They got it, yes.
I have not had we have not received it as of yet. So
Can 5 has become infructuous in view of the conclusion of the SFIO.
Nothing really.
Can 5 I'll record that you have filed your opposition and reply, and it has become infructuous in view of the conclusion of the investigation. And Can 6, what is your take on, would you like to take instruction on that, or you
take instruction, my lord?
Take instruction, because there are 2 limbs. One is handing over of the report and CCTV. He has a point there basically, but you can meet that on the next.
My lord, the only other aspect is in respect of Can 4. This is where I'll just take 2 more minutes. My lord, there is a ball playing happening between the between the liquidator and the SFIO regarding who has the documents. In one affidavit, the SFIO says, I have not given the documents to the liquidator. In the same application connection affidavit, liquidator says, I have taken all custody of documents from the SFIO.
We'll decide that next week.
Yes, Can 4 is only, but only, Can 4 is only with regard to this particular respondent to explain how he is in custody of certain documents. They have taken time to file their affidavits. Till today, that has not been done. So if can
I'll
4,
not extend the affidavits for the time being. I'm not extending the
Fine.
time for filing affidavit.
Very
Let us hear them next week, then we'll decide.
My lord,
Yes.
Lordship, may they be permitted to serve upon us a copy of the Can 6, Your Lordship?
Can 6, please, Mr. Banerjee, whatever copies they don't have, ask your Lord Junior to serve copies on them.
I don't think it's been served.
Yes, Mr. Kundali.
he probably forgot talking about mentioning about one of the proceedings that Mr. Banerjee's client had already gone ahead with. He had challenged the investigation in Gujarat High Court, where he failed.
Huh.
Not only he failed in the
Before filing this writ petition.
While the writ petition was going on, they had again filed before the Gujarat High Court. There was a judgment passed against them.
Huh.
Thereafter, the division they went before the division bench. Division bench also affirmed the judgment that was there, which was against them. My lord.
So in the main writ petition, apart from the challenge to the investigation, anything else is there? In this writ petition, anything else?
In this writ petition, apart from the investigation, there is nothing else.
Then the writ petition itself will become infructuous, Mr. Banerjee.
No, I didn't forget.
Have you disclosed that in your opposition?
Yes.
In this opposition?
Well, the writ I checked in the morning also. The writ has not become infructuous. There are certain
on that.
Yes.
5 I can right now hold it to have become infructuous in view of the investigation.
Yes, 5.
But you can make your arguments regarding 6 by relying on your affidavit.
4 and 6 remain, then we can
Correct. Learned counsel for the parties content. Now, learned counsel appearing for the Respondent Union of India. You are for SFIO. Learned counsel appearing for the SFIO submits that the investigation in respect of which Can 5 of 2024 was filed has since been concluded and is awaiting formalization from the central government. Full stop, next para. Accordingly, Can 5 of 2024 has been rendered infructuous. Full stop, next para. Affidavits in opposition filed in connection with Can 4 of 2024 of 2023 and Can 5 of 2024 as well as replies thereto today be kept on record. Full stop. In view of the above development, Can 5 of 2024 is disposed of as infructuous. Full stop. Insofar as Can 6 of 2024. Oh, sorry. The affidavits are in respect of 5 and 6.
No, affidavits are in respect of 4 and 5.
4 and 5. Very good. Insofar as Can 6 of 2024.
Can 6, in fact, I got today only.
Can 6 of 2024 is concerned, learned counsel for the SFIO submits that he has only got a copy of the same today and seeks some time to take appropriate instructions on the same. Full stop. Learned counsel appearing for the liquidator also seeks an adjournment. Full stop. Accordingly, let Can numbers which remain 3, 4 and 6. Can numbers 3 of which year? Can 3 of 2023, Can 4 of 2024 and Can 6 of 2024 be listed together for hearing on May 17, 2024. Come back next.
Records of Can 5 may also be kept because it might be required for the purpose of.
Yes. It won't go down because the main writ petition is before me. Can 5 এর বাবু Can 5 এর ইয়েটাও থাকবে Can 5 টা এখানে থাকবে
on 17th, my lord.
17th, any other date if it suits you? 17th, yes. 17th. Next Friday, application day.
Grateful, man.
Lord, next Friday is 10th.
Item number 24.
Grateful to you.
Should I take it on May 10th, your matter? I will
No,
give you 2 weeks.
Somebody has a difficulty on May 10th.
So May 7th.
It's all right.
Good. Yes.
Lord, I appear for the private respondents.
Right.
Application was just application was nothing of much substance. It was for expeditious hearing of the writ petition, otherwise affidavits are complete. Now,
no question. What is the writ petition about?
The writ petition is about
If he said Dhar was not appearing, I could have taken up the main writ petition. But since he's there, there must be something serious. Because WBSCTCL, CSC in normal course they appear. But he's not for the regulatory authority. Let me hear you. Yes. What is the writ petition?
This is not a complicated matter.
Not. Yes, Mr. Bhattacharya, what is the writ petition?
Well, what happened, Millard? There were initially a joint property. Now, Millard, it was partitioned. Now, Millard, what happened?
First, tell me what relief you have sought in the writ petition.
Millard, for shifting of 4 meters from the.
Very well. Now proceed.
Yes. Now, Millard, what?
So, Mr. Das, can I take up the main writ petition along with the application on consent? I'll record that.
Application.
Right.
Yes.
Right.
Now,
right.
Millard kindly takes up, Millard, few orders, Millard, first in this matter, Millard.
So you ask for shifting of 4 meters.
4 meters.
All belong to you.
No. Petitioner and private respondent.
You ask for their meters to be shifted also.
Yes, Millard.
From where? Your bedroom?
No, Millard, there is a shop room. Millard,
The bedroom is the usual refrain in these matters. It's in my bedroom.
Millard, kindly. Oh, yeah, order ta dao, jeta tomake pathalam.
Tell me, Mr. Bhattacharya, make your submissions first. Then I'll look at the paper.
No, Millard, Lordship's order. Millard, kindly see your Lordship's order. Millard, dated Millard 31st March 2023. যেটা তোমাকে পাঠালাম যেটা WhatsApp করলাম কালকে Millard, kindly Lordships.
You could not find any suitable alternative accommodation.
No, Millard, kindly see, Millard, this portion of the order. Millard, may I place it? Learned Counsel of the CSC Limited at the outset and his usual fairness submits that although the report of the CSC Limited says that the partial shifting of only 4 electric meters in isolation amongst 11 meters is not technically feasible, the report further shows that the parties were unable to show any technically suitable position for shifting of the existing service meters. However, such observation was made in the context of the factual scenario that the entire meter room would have to be shifted, for which there is no technically suitable position. However, Learned Counsel submits that that a further inspection may reveal an alternative suitable position at a feasible distance where the 4 meters of the private respondent out of the total 11 meters at present housed at the residence of the petitioners may be shifted. From this from the exception to the report filed by the petitioners, it is seen that there is a gap between 2 premises. Learned Counsel for the private respondent contents in the affidavits in opposition as well as the report. The CSC Limited had repeatedly said that partial shifting of only 4 meters in isolation among 11 meters is not technically feasible. As such, it is contended that as the meters are existing in their present position for more than a decade, there is no immediate necessity to shift 4 out of 11 at the present juncture. Upon hearing the Learned Counsel, it is revealed that the property was originally a joint property and subsequently the parties amicably settled to partition the property by meets and bounds. As per the submission of CSC Limited, the premises are now separate holdings. The next paragraph is very important. As such, giving a consideration to the entire factual matrix, it is evident that 2 separate holdings should in all propriety be housing their own respective meters. Then we will kindly see the next page. The report of the CSC Limited merely suggests that the parties were unable to show any technically suitable alternate position for housing all the service meters, but it is not reflected in the report as to whether the 4 meters of the private respondent can be shifted in isolation and not together with the 7 meters of the petitioners to a separate suitable position with the premises of the present occupied by the private respondent. Hence, CSC was directed to hold a further inspection upon prior notice. Millard, this was done. Now, Millard, before Lordship had rejected their earlier report by this order, kindly see, Millard, the one.
When I called the report,
10th February 2020.
should be done again. That is
10th
why Lordship
February.
had written the first line of this order.
10th February 2023, Millard, if your Lordship would kind enough to see the report, Millard, that's a single page report.
Previous report. Why should I look into
Very well. Then, Millard, after this order, Millard, CSC had filed, Millard, conducted a joint inspection and had filed another report. That report, Millard, আছে তো? দেওয়া আছে তো? 17th April 2023. The report was, Millard, it has been affirmed by one Krishanu Shaha.
It was by way of an affidavit?
Yes, Millard. Yes, Millard.
Inspection was held on 12th of April and the report was.
I found the 2 exceptions, but not the report. Anyway.
Extra copy আছে দাও না?
No, need not to give any extra copy. I'll just find them. এই রিপোর্টটা খুঁজে দাও তো একটু। No, no time being. I'll may have to mark it. এটা অরিত্রকে দেখিয়ে নাও, নয়তো বসে আছে কেন ওখানে? হয়তো তুমি চুপচাপ বসে থেকে
Ishanu Saha, Milord, affidavit.
নো নো নট দিস, এটা তো আমি আগেও পেয়েছি, এফিডেভিট ফর্মে আছে বলছি তো। Mr. Das, served, there is no difficulty. Did you file it in court? That is what. If it is on record, then I'll be having two copies. One will be marked. I won't be able to locate. এটা নয়। No. That has not been filed, sir.
Well, this there is.
Let me check up my orders whether that has been filed. Whether it has been filed. What is the date of that?
12th of April, and it was affirmed and filed on
19th
April order
19th of April 2023.
Kindly see your lordship's order dated 19th April 2023.
সে অর্ডারটাই তো নেই এখানে।
Website, Milord, we have.
I'll check up. Yes, absolutely you have filed. Mr. Das, I'm sorry, you have filed. File হয়েছে, তুমি ছিল। Yes, I have recorded in my order. Chitu.
6 pages, so maybe that's the reason.
Yes. No, but must have been misplaced in some other. I'll take a copy of. I'll take the. But you don't have a copy then. Yes.
I can give my copy, little marking, but no difficulty. Let him.
Thank you. Yeah. Your report, but his copy. Yes, let us proceed. Yes. Mr. Bhattacharya, what is there?
It's thoroughly marked. Kindly excuse me.
I'll look into the markings then.
But this one is lesser marked, and the marking portion is only on the back page. Document.
I'll do this. I'll take your report when he submits and vice versa. So that you can submit your
Only
relevant
marking on the page where Lordship won't be seeing at the back page.
Since you say that, I'll be seeing that first. Human psychology. Yes, Mr. Bhattacharya, proceed.
Kindly, Milord, see the annexure to the report. It starts with the word report. The annexure to the affidavit. Yes, may I kindly. Annexure is.
Auditro. Yes. Sir. This is a 5-6 pages.
Yes.
Yes. The affidavit is not there, but the report is there.
Now, Milord, kindly comes to Milord. Let me place the report, Milord. It will be necessary.
Yes.
Kindly see, Milord, first, Milord, para 1. During inspection at the subject premises, we found the premises in question to be comprised of two structurally separate G+2 establishment, the admitted case, CSC also found that. Standing there to be two separate holding numbers, 50 and 51 respectively. The same was confirmed by both the parties by way of submission of mutation certificates. Both the holding numbers are also mentioned in the instant read. A detailed scap match is annexed. Then we will kindly see the establishment under holding number 59. 79 SK Dev Road, Kolkata 48 is situated in front portion and positioned on the main road and the three shops on the ground floor. The petitioner resides in the establishment together with his family on the other floors. Then Millard kindly see Millard the next page, para 3. The details of the 11 meters are given in para 3. Now Millard ultimately kindly comes to page 6. What is the finding?
You reside at 50 or 51?
51.
And they reside at 50?
Kindly see Millard, then 5, the para 5,
yes.
However, we gather that the establishment having holding number 50 does not have a separate service. Hence, shifting of the aforesaid 4 meters can only be possible subject to installation of a service, separate service in favor of the respondents, provided a fresh application is made by those concerned and all compliances have been duly met. Then, Miller, paragraph 6, kindly see, this is their ultimate finding. In spite of our request to the private respondents, Shri Somnath Ghosh and others, they were not willing to identify a suitable position for installation of a new service connection with their establishment. However, in strict adherence to the solemn order and with the view to resolve the issue once and for all, we have proceeded to identify a technically suitable position in holding number 50 where a new service connection could be installed and the shifting of the aforesaid above mentioned 4 number of meters of the private respondents could be possible. The proposed service connection is identified in annexure A attached herein for kind reference, please. Therefore, they have.
Mr. Bhattacharya, you had a partition amicably.
There is
was it in writing?
Partition deed. Partition deed.
Unregistered.
No. Registered deed of partition.
Registered deed. Does it provide anything regarding shifting of meters?
But that I have to check up. Provided will not.
Because you had the property partitioned. If there was no specific provision, are you entitled otherwise in law to have this enforcement? Because no legal right is infringed. Equity, I understand. If there was a consensus between you, I could have understood. Maybe I could have directed you to pay also if you so much want it. But if there is no consensus, then Mr. Bhattacharya, what legal right is being infringed?
No, first of all, my lord, the observation of your lordship in 31st March 2023 order.
We were trying to explore options.
Options. No, my lord, this paragraph.
Since the two houses are there should be two separate connections.
The prima facie observation of your lordship, my lord, was
definitely
there, my lord, that has attained finally.
Could be two.
No, my lord, appeal has been carried out from this order.
Prima facie means prima facie. No appeal need to be carried out. It can be revisited at the time of final hearing.
Otherwise, my lord, there is no problem because CSC has already identified a my lord place in.
Achha, let us hear Mr. Dhot. Then what is his difficulty?
Very well.
This is the crux of the matter.
Only there, my lord, my learned senior friend had filed an exception to this report.
Yes.
Only, my lord, kindly see their exception, my lord. It is affirmed by one Mita Ghosh.
Yes. Containing those photographs.
Containing those photographs.
Yes.
Milord, kindly see, Milord, paragraph 5. There, Milord, only Milord objection is they will be dispossessed from the suit property subject to correction. My learned senior friend knows better than me. Milord, this is not a suit for eviction.
No, there is no other problem pointed out.
Milord, other problems are regarding merit of the writ petition false fabricated. Milord, this is
that is different.
Paragraph 5 is, Milord, their only objection, what I could gather.
Very well. So the photograph, anything to say on the photograph?
These two are separate premises, Milord. Kindly see, Milord.
HON'BLE milk is their property. The entire thing is theirs.
No, Milord, kindly see, Milord, the sketch map at the report of the CSC, Milord.
No, I want to corroborate that with this page 6 of their, yes.
Photographs. Yes.
Page 6 of the exception.
Very good.
I have two side by side, the sketch map and the photograph.
Yes.
What are the corresponding portions?
Kindly.
Should I keep it like this?
Yes, Milord.
Which portion is yours?
Kindly see, Milord, there is a shop
page
room.
6, page 6, yes.
Yes.
Shop room?
Shop room, and there is a 2-feet passage.
Yes.
That is also corroborated, and this is.
Where is your property? 50? 50, you are in 51, sorry.
I am in 51.
Which is 51?
Milord, shop room. This is the shop room, Milord, where I am there. But the shop room is being run by the Milord private respondent.
Then they're rightly apprehending for disposition.
No, Milord, disposition for relocation of electricity meter.
You are there in the shop room, but they are running the shop room.
I am there, the 51, the shop room is in 51.
You are residing in 51.
51.
Where is you? I mean, where are you located? Then it's not a separate premises. It's
No,
the same
there-
premises.
No, 50 and 51, there is a gap of 2 feet. There is a passage.
Which one is 51? Where do I find it from the photograph?
Yes, kindly, if your lordship kindly sees the sketch, Milord, of the CSC's report.
Colored photograph আছে
এটা কোথায় part of?
Do I see that the page 7 shows the photograph at page 7 shows the electricity meters. That is apparently inside their
Inside.
whose shop room? Their shop room.
All 11.
Inside their shop room. Then you remove your meters.
No, Milord, that is there, Milord, but
What do you propose to do with these? Their meters are in their shop room.
no, all 11
You remove
are,
yours.
all 11 are there in the shop room.
All right.
11 are there.
So you remove yours.
Raji,
How many do you have there?
7, remaining 7.
Remaining 7 are yours. You are the consumer. But your client is saying otherwise probably. Not theirs.
May I just clarify, just factually? No.
Also taken out an exception to the report of CS.
I'll look into that.
May I just clarify the factual position, my lord? Kindly have a look at page 6, the photograph.
Yes.
Thereafter, page 7.
Yes.
Now, page 7, there are 11 meters. His allegation is from 1994, I am running the shop room illegally.
That is different, Mr.
Now,
Farah.
that's what I'm saying. Now, 11 shop room, meters are there in my shop room. There is no difficulty. He can make a case that, look, I don't want my meter. It should come to my place where I am having possession.
So there was a partition between you two.
Well, what happened? This property, there was a partition.
Particle partition, 50 and 50.
No, there was an understanding. Well, there was an understanding in writing that my father gave money for construction of the pillars. With the understanding, then I will have front portion shop room, and that's why shop is being run.
Yes.
But I would be living outside. Now I have no difficulty for all the 11s being there inside the shop room.
So which is 50 and which is 51? This is 51.
This is 51.
51 is their residence,
Yes.
but you are running your shop there.
Yes.
And you're living in 50,
And there
which
is
is
a-
different.
Right.
Which is not reflected in the photograph.
Correct. Correct. What he wants is, he wants
Your shop rooms being run at 51, those meters should be removed to 50.
to separate place, and that place
At
not to
50.
his place.
No, your place.
Yes.
Your place must be adjacent, but
50.
And
all right.
my lord, what is lordship make? In fact, if I can, my lord,
So,
clarify.
Mr. Bhattacharya, there is little or no scope of doing that because this is already there. If they don't have a right regarding running the shop rooms, have you filed a civil suit?
No,
There is a notice to quit.
notice to quit is
They file that and do whatever you have.
that is there, Milord.
No, till they're running their shop room, they are running their shop room in 51 and the meters will be in 50.
Subject to correction, shifting of meters does not mean disconnection of electricity.
No question of that. That will be extremely inconvenient for all concerned, including the distribution licensee. Shop room is being run here, meter will be there in a different premises. Please ask your client not to respond to every question of mine. Please ask him to go behind. Yes, if you did not have your instructions, you can't get them now. Yes.
No, kindly appreciate, Milord. 50 is a place where my learned
Mr.
senior
Bhattacharya, these are notional. 50 their place, 51 there. But they have a right in 51 also. Their existing shop rooms are there.
shop room, Milord, relocation of meter is not eviction.
No question of relocating the shop. Why should the shop? What legal right of yours have been infringed?
No, Milord, kindly.
Your premise, the premise of your case was entirely that you have separated between yourselves. They are living in 50, you are in 51. But now I see their shop room is being done in 51. And the meters are catering to the shop rooms only. They may have their residential connection separately at 50 if they want.
Milord, residential connection is also in the shop room.
That is what he has said. Their residential connection.
Yes.
Anyway, Mr. Bhattacharya, no question of any shifting.
Milord, their residential connection is also there in the shop room.
Maybe their residential connection in the shop room, which is occupied by them. So what difficulty you are suffering? What is your cause of action at all?
No, Milord,
Your cause of action because my premises he is having his meters. Can this be a legal right which has been infringed, Mr. Bhattacharya?
That is, my lord, but kindly, my lord, the lordship's
They are in
observation-
occupation of the shop room, their residential as well as their shop room meters are located there.
There is otherwise no.
If your meters are there, please remove your own meters. You can apply. I'll give you that.
I have no problem from that.
There is no,
Obviously, no.
there is no technical, my lord, problem, my lord. CSC in the report has said there.
So, Bhattacharya, they could have moved it, move a petition and say that your meter should be removed from there.
That they have not done, my lord.
And then they should not also be on other ground also because you are of 51. You are deciding there.
My lord,
Let it be as it is.
No, my lord, only one thing, my lord.
What
Kindly
one thing?
appreciate, my lord. CSC, my lord, says there is a, my lord, alternative place to remove.
Yes, but there is a question of moving there.
No, my lord, if it is otherwise technically feasible, my lord.
Even if it's technically feasible, they run a shop room in a particular premises and have their meters in separate premises. Why?
On their own premises.
I'll dismiss the writ petition on because of lack of locus standi. You don't have any locus standi just because it's your house. It's located in the shop room. Being occupation is important, Mr. Bhattacharya, under section 43.
Well, I have
Only occupation, occupant or owner.
Position.
Possession. They have possession. They have their meters in their own shop room, which is not disturbing anyone.
Well, Lordship has clarified in Lordship's judgment,
Yes.
relying on a full bench judgment. I have brought that also.
No, that is settled.
That is
That is settled.
There are many judgments on
That is settled. Yes. Yes. I'll pass that order. I'll grant you leave to apply for shifting your own meters from there if you want.
That, my lord.
Doesn't.
Well, only one sentence.
Yes.
While Lordship passed order on 31st of March,
Yes.
Lordship may kindly come to order of 31st March.
Is that observation which Mr.
No,
Bhattacharya-
not observed. Paragraph, sorry, page number 2,
Yes.
fourth line.
Yes.
That's an incorrect statement made by them. They said that meter rooms were at present housed at the residence of the petitioner. If that had been the case, of course, everything is right.
That is the premise of
Yes,
that
that's the
order.
premise. That was incorrect.
Mr. Das, I have heard you. Heard learned counsel for the parties. Full stop. Heard learned counsel for the parties. Full stop. From the report of the CESC Limited, comma, it transpires that there are 11 meters housed at the existing meter room. Full stop. Next para. It is further reflected from the report and corroborated by learned counsel for the CSC Limited that although the private respondents were not willing to identify a suitable position for installation of a new service connection within their establishment, within bracket, at premises number 50, bracket closed, comma, in strict adherence to the order of this court, comma, the CSC Limited proceeded to identify a technically suitable position in holding number 5 and has demarcated the same in a sketch map annexed to the report of the CSC Limited. Push up next para. It is seen from the photographs annexed to the exception to the said report filed by the private respondents that all the 11 electricity meters are at present contained in a particular meter board. Push up. The said meter board, comma, however, comma, is located inside one of the shop rooms being run by the private respondents from the premises of the petitioners at premises number 51. Push up next para. Although there is apparently a dispute regarding the position of the private respondents in such shop rooms, comma, it is an admitted position that as of today, comma, the position of the shop rooms is with the private respondents, comma, where all the meters are located. Push up next para. Thus, comma, the picture which comes out from the pleadings, comma, the report and the exceptions is that there are two adjacent premises, comma, premises number 50, where the private of which the private respondents are at present the owners by amicable partition with the petitioners, and premises number 51, comma, of which the petitioners are the owners by virtue of the same partition. Full stop. although the private respondents reside at premises number 50, comma, their shop rooms are being operated from premises number 51, although the same belongs to the petitioners. Push up next para. Thus, comma, it cannot be disputed that the private respondents are in occupation of the shop rooms where the all the meters are at present located. Push up. Thus, comma, for the purpose of considering the prayer of the petitioner for shifting of the private respondents' electricity meters from the said shop room to the residence of the private respondents at premises number 50, comma, the same is not at all justified by the factual premise of the case. First up, it would be absurd to expect that the private respondents would run their shop rooms from premises number 51, but the electricity meters which catered to the said shop rooms would be located in a different premises where the private respondents reside. Push up next para. As settled occupants of the property, comma, the private respondents are entitled to electricity connection at premises number 51 within their shop rooms as well. Full stop. Next para. In any event, comma, by the peculiar position of the location of the meters within the shop room being operated by the private respondents, comma, no legal right of the petitioners can be said to have been infringed. Full stop. Next para. If the petitioners have any grievance regarding continuance of such possession of the shop rooms by the private respondents, comma, it is in any event open to the petitioners to take recourse to due process of law for eviction of the private respondents. Full stop. However, comma, as of today, comma, there is nothing to show that the petitioners are suffering from any inconvenience due to the current location of the meters, of all the meters in the shop room of the private respondents, comma, irrespective of the fact that the shop rooms are located at premises number 51, of which the petitioners are the owners. Full stop. Next para. In such view of the matter, comma, the writ petition, comma, seeking such shifting, comma, cannot be entertained. Full stop. Accordingly, WPA 22584 of 2022 is disposed of by granting liberty to the petitioners to seek removal of their own meters from the said shop room of the private respondents if the petitioners so choose, as well as for the petitioners to institute appropriate proceedings before the appropriate forum / civil court for eviction of the respondents if they are otherwise entitled to do so. Full stop. Nothing in this order, comma, it is made clear, comma, touches the contentions of the private parties regarding their respective rights with regard to the present position of the electricity meters. No address to cause urgency.
Only one thing, Milord. Their residential meters is also, Milord, seizure in 51.
No difficulty. Their shop room, they are running it.
No, that is, Milord, the shop
Evict
room.
them, get the entire thing, get the
Their
meters disconnected.
residential meters is also in, Milord. That's the whole difficulty.
Yes. Can such and such are also disposed of according.
Item number 25.
Yes.
Item number 25, my lord, I am praying for only 1 day accommodation.
Why?
Because, my lord, some points has been raised that FECA, the first candidate knows FECA, but my lord, FECA is included in the syllabus of, my lord, that is Fajr. But for that reason, my lord, some approved syllabus is required. My client has sent, but that may not be accepted by your lawyer, honor.
So when should I take it up? Tell me.
Next Friday, because he has collected that today.
Learned counsel for the review applicant seeks an adjournment. Whoso accordingly let the matter stand adjourned till May 10, 2024.
I am deeply obliged.
Please come.
Smile. Item number 27.
My lord, I am for the applicant.
Yes. What is the application?
Read petitioner.
Please take the microphone closer.
My lord, I am for the applicant and the opposite party number two in the read petition.
Right.
My lord, the application, the matter was previously sent to mediation. The issue was resolved and the learned mediator filed a settlement report. And my lord kindly comes to the report once, page number 29. 8A. Only not later than 45 days from the execution of the settlement, Sri Molloy Ghoshal, that is the
I'm
husband.
sorry, what is the page number?
29. Para 8.1.
Para 8.1, yes, yes.
Only not later than 45 days from the execution of the settlement, Sri Molloy Ghoshal, that is the husband, writ petition, opposite party number 2.
You.
My lord, me. Shall ensure payment of 39 lakhs directly by debiting new joint non-SBI savings account, where the mandate would allow Srimati Orpita Ghoshal, that is my wife, to withdraw the total settlement consideration of rupees 42 lakhs. Now, my lord, 39 lakhs has been paid. I was out of time. That is why I have made the application.
Has been paid.
I have to take instructions from the bank as I'm appearing.
If you did not have instruction till now, you would not ever have.
I am appearing on behalf of Devashish Shah, Advocate Learned Counsel Devashish Shah.
Devashish Shah is appearing for whom?
For the respondent number, yes, the bank.
Respondent number 1.
Respondent number 1.
Petitioner herself.
No, she is the my lord, she is appearing
You are
in
Ms.
person.
Orpita Ghoshal. You are agreeable to this. Devashish Shah is appearing for the bank.
For the bank, yes.
You are agreeable to that. Very well. I'll dispose of this application. What is the writ petition for?
Writ petition for because my
Now the writ petition has also become
writ
infructuous.
petition already my lord disposed of.
Oh,
I was out
Very
of
well.
time.
I
That
get
is
it.
why I have filed
Right,
the
right.
application. And my lord, one humble submission, my lord, in the learned mediator had filed the terms of settlement along with the my lord kindly comes to my prayer.
You are Ms. Ghosh.
My lord.
Yes. Pair.
My lord kindly comes to page number 6.
Yes. What addendum means?
Addendum, my lord, the matter was settled on 6th January.
Right.
After that, there was some dispute. That is why
It was in our mediation center, High Court.
my lord.
Yes. Then. Yes.
Mr. Vipul Kundolia
Yes,
was
I've
the
seen
learned.
that. Yes. Yes.
My lord, after that, there was some correction. That is why again a date was fixed and a minute was held, a minute was passed. And my lord, that is the addendum. But my lord, difficulty, my lord, the addendum is not with the file, my lord. And whenever I have applied
Which
for
department? Department. Which department? I don't know.
Courts department.
Courts. What department is it with? I have to specify.
Department.
তুমি গন্ডগোলটা বাকি দিচ্ছ।
And whenever I have applied for the certified copy, I have only got the
I'll
terms
put in a line that the department shall provide the addendum to what? I have to specify that.
addendum to the terms of settlement.
How did it go to the department? I don't understand. Please let me understand that. I don't understand.
That
Initially, there was a settlement.
settlement was done.
Yes.
There was some
The report of the mediator is also there. The settlement report. There was an addendum to this settlement report.
my lord.
That was incorporated there.
That was incorporated. But whenever I
Where
have
do I find that it is to be incorporated?
in the
Have you annexed a copy of that addendum?
kindly see my lord's order. Whenever my
No, you show me a copy of. Do you have a copy of that addendum?
I have.
Have you annexed that?
Have. No, I haven't annexed.
Very well. I'll give you. I'll say that if you approach the department with a copy of that addendum,
My lord.
they'll. What should they do? Tag that along with the main file.
My lord.
That will suffice.
My lord.
So you cooperate with them. I'll direct
lord,
them
my lord.
to cooperate with you. Very well.
Grateful man. And my lord, one last submission, my lord.
Any other or further orders? That is the last prayer.
No.
Yes.
Pardon. My lord, earlier occasion affidavit of service was filed, but that was not recorded. My lord, kindly let it be recorded.
Yes. At order record.
Grateful, my lord.
Since affidavit of service has been previously filed, comma, no further service is required, full stop. In any event, comma, the writ petitioner is present in court in person. Full stop. Next para. Learned counsel for the present applicant stroke husband submits that in terms of the settlement report of the mediator, comma, an amount of rupees 39 lakh has been paid directly by debiting new joint non-SBI savings bank account, where the mandate would allow the writ petitioner to withdraw the total settlement consideration of rupees 42 lakh. Full stop. Next para, it is submitted that although such direction was complied with, comma, the timeline fixed by the mediator could not be adhered to for reasons beyond the control of the present applicant. Full stop. As such, comma, the present application seeks an extension of the said time. Full stop. Next para. On query of court, comma, the writ petitioner stroke wife appearing in person submits that she has no objection thereto, comma, since such amount has actually been deposited by the present applicant husband. Full stop. Next para. Learned counsel for the applicant also submits that an addendum to the original settlement report was not tagged with the main settlement report, and a direction to that effect be issued to the concerned department of this court. Full stop. Next para. Since the writ petition has already been disposed of by virtue of mediation, comma, no further order need be passed in connection with the same. Full stop. Next para. Can 1 of 2024 is disposed of by enlarging the time for compliance with the direction incorporated in the settlement report annexed at page 24 of the application till the time on which the same was actually complied with. Full stop. Next para. The concerned department of this court shall, you have prayed for providing the addendum to you. What do you mean by that?
I have the mediator, learned mediator have given me a copy of the addendum,
Then
but that is not annexed with the department. So if
you have said provide the addendum anyway. The concerned department of this court shall, comma, as and when approached by the applicant or his learned advocate with a copy of the addendum, comma, tag the said addendum in its original with the main settlement report. Full stop. It is expected that the said tagging would be done within a week from such approach being made on behalf of the applicant. Full stop. No orders to cause urgent certificate copies. এই অর্ডারটা না একটা আমাদের Ghosh, can you furnish a copy of that addendum during the course of the day?
during my lord, during the course
একটা লাইন অ্যাড করে দিন তো। Ms. Ghosh, learned advocate for the applicant, is requested to supply a copy of the said addendum to be tagged with the present file during the course of the day. ওই addendumটা এতে অ্যানেক্স করে একটুখানি But you also make your approach in your independent. Thank you.
grateful, my lord.
Correct.
Item number 28.
Addendumটা দিলে শুধু এতে ঢুকে যাবে। Addendumটা দিয়ে যাবে মেয়েটি এতে ঢুকে। Yes.
Appearing for the respondent.
Yes, so
I am
yes.
writing my reply to the opposition filed by the
Opposition has been filed already. Your file.
not filed but exchanged.
Opposition and to the can or the
Can.
What is the can about?
Can is about that after passing of the stay order by your lordship,
Yes.
they are not allowing the petitioner to attend his duty. And they are saying after SBO will advise.
I passed a stay of the cancellation of your caste certificate.
That is on 5th December 2023. Thereafter, my lord, on 6th, after the order was uploaded in the website, I communicated them, that the petitioner communicated to the my lord, headmistress and the secretary of the school to allow, but at my lord 6th.
Administrator and secretary at the originally the parties to the petition.
Thereafter, it was well added response.
So yes.
My lord, kindly says.
My lord.
And thereafter, what happened, my lord, even after persuading them,
yes,
allowing me, and they are saying that unless the court passes order, man, in Can 1/24, they would not allow me.
I'll fulfill their wish.
My lord.
Yes, Mr. Akut.
One
Sorry.
thing, they have suppressed one vital information that I have communicated them on 6th December 2023 at 6:52 p.m. That they have suppressed.
6 December. When was the order passed?
But
Right.
that was uploaded on 6th.
Very next day you communicated. What do they say?
They did not utter anything about that order, communication.
They are not denying that either.
Yes, they have not neither denied nor admitted.
Keeping it vague, conveniently. Let me hear. Yes.
My
You
lord,
are for the headmistress.
4 and 5. Let's
Four and
just
five.
send the secretary. My lord, there's one thing that I would like to submit at the outset. My lord, in the last order had granted liberty to the petitioner to amend the prayer section because the termination to amend the prayer section of the writ petition and to transmit a copy thereof to the respondent. It has not been done. It says
You have given a copy.
Yes, the amended copy has been, my lord, served.
Where is the receipt?
Upon the 5 and 6, my lord.
No.
You should have given to their advocate.
No.
Advocates are appearing.
Advocate or parties. It was the order, man. I have got a communication, my lord, sent to the parties. They have also affirmed affidavit. They have filed opposition to that application, my lord.
No.
After receipt of that application, my lord.
No, they say the amended copy has not been given.
Yes, amended copy has
Amendment is only the adding of the parties.
No, my lord, this is the
prayer portion.
that has been supplied.
Anyway, Mr. Chakraborty, you know what order was passed. Yes. What is your stand on this?
My lord, the stand is that the petitioner is arguing that on the basis of the cancellation of the caste certificate,
I've stated
we
that.
have terminated. However, this entire episode of the caste certificate being valid or not,
Stay does not mean, I admit that stay does not mean cancellation has been set aside. Definitely not.
My lord.
But since the operation is stayed, let him work in the meantime. You are working in what? You are a teacher.
Laboratory assistant.
Laboratory assistant. How much do they earn? Let them work. Let him work.
My lord, the allegation is that the caste certificate is not genuine and the appointment was secured on the basis of the
I'll
caste
fix
certificate.
the writ petition next year for hearing
My
and
lord.
till then you let him work.
While-
If you take that attitude, I'll fix it in December, sometime in December this year. The main writ petition, till then the stay order will be operating. You have to let him work in the meantime.
They are saying, man, this is forced certificate, my lord.
No, that is the stand. They have a right to say that.
Maybe irregular, but not forced. They are saying forced. How they can say this? SDO has not even.
Anyone can say anything, Mr. Bhagat. They have to prove it in a court of law. So I'll dispose of the application, Mr. Chakraborty.
My lord pleases to dispose of the application. My lord disposes of, but only one submission, my lord. The petitioner was given an opportunity to produce the certificate where he has stated he does not have the certificate. It is in the BDO's or in the SDO's office. It is not with him.
2020.
No. The cancel before the cancellation of the caste certificate, you did not produce it at all.
Yes, produced, my lord.
I don't understand you.
My lord, they are saying produce the digitalized. I have not got any digitalized certificate. I have produced the original certificate issued by the SDO concern.
Whatever. I'll dispose of that.
Disputed, ma'am.
The present application, it is Can 1 of 2024. The present application has been filed by the writ petition on the strength of an order of stay passed by this court in connection with the writ petition, whereby the operation of the decision cancelling the petitioner's caste certificate was stayed. Push up next para, it is submitted that despite the operation of such stay order, the respondents 4 and 5 in the application, that is the headmistress and the secretary of the concerned school, are not permitting the petitioner, who is a laboratory assistant there, to do his job. Full stop next para. Learned counsel appearing for the respondent numbers 4 and 5 in the application submits that no amended copy of the application has been served on the said respondents, which is refuted by learned counsel for the petitioner, who contends that such copy has been served directly on the respondent numbers 4 and 5. Push up next para. Be that as it may, since an affidavit in opposition has been used in connection with the said application and the respondent numbers 4 and 5 are well aware of the purport of the of such amendment, no further service is required to be directed in the matter. To sub next para, learned counsel for the respondent numbers 4 and 5 in the application also argues that the petitioner failed to produce a copy of the caste certificate despite being repeatedly asked, full stop. However, comma, since at the inception, comma, when the petitioner got the job, comma, he must have produced such certificate to get the job in the first place, comma, such insistence of the respondent numbers 4 and 5 is not understood by the court. Full stop, next para. Despite the standard legal proposition being that an order of stay does not have the effect of setting aside the cancellation of a caste certificate, but merely puts such cancellation in hibernation mode, comma, even if such legal position is accepted, comma, as of today, comma, the cancellation certificate is not operative, full stop, as such, comma, until and unless the writ petition is dismissed or the stay order is vacated, comma, the respondents cannot take a stand that such caste certificate cannot be lent credence to. Full stop, next para. Hence, comma, the respondent numbers 4 and 5 are directed to permit the petitioner to carry on with his services in the concerned school, subject to the outcome of the writ petition. Full stop. Can 1 of 2024 is accordingly disposed of in the light of the above observations. Full stop. However, comma, it is made clear that the contentions of the parties in the main writ petition are kept open for being argued at the time of final hearing of the writ petition, and the merits of the writ petition have not been touched by this court while passing the above order. Full stop. The writ petition shall be listed in the monthly combined list of cases for the month of May 2024. Acha, have you used your opposition in connection with the main writ petition?
No, my lord.
I'll extend that time.
I have also applied to the opposition to the can madam today.
Can opposition আর reply কিছু বলেছি? আচ্ছা ঠিক আছে, একটা লাইন প্রথমে অ্যাড করে দিন, affidavit in opposition and reply filed to the can be kept on record. আচ্ছা, লাস্টে যেখানে ইয়ে করলাম, মে মাসের না করে জুন মাস, জুনের মান্থলি লিস্টে, in the monthly common list of cases for June 2024, full stop, the time for filing affidavits in opposition in connection with the main writ petition is extended till May 17, 2024. Full stop. Reply, if any, shall be filed by June 10, 2024.
One thing, madam. Now this school is closed, madam. They should allow me to sign the register so that I can continue my service, madam, because it is now on vacation, madam.
No.
When
Whatever is the rule, I mean, I have directed them to permit you to work in the school. Nothing further at this stage, Mr. I have not yet set aside the cancellation, only stay of operation.
Salary for December till date, madam.
No, no.
My lord,
That will abide by the outcome of the
my lord, one
not at this stage. If I ultimately set aside, how can they recover from you? You will be permitted to join now, and as and when you work, your salary will be paid to you. But regarding the previous salary, when I finally dispose of the writ petition, if you win, Mr. Bhagat, I'll just remind me, I'll direct them to put in the entire back wages, back salaries.
I give them so that I can attend the school immediately. Today is my Friday, so that
I pass my direction. After line at Kudin, the parties shall act on the basis of the oral order passed in court today for the purpose of compliance, because you are present. Next.
Item number 29.
My lord, I am for the writ petitioner, my lord.
Yes.
Appearing virtually, my lord.
The can is meant.
Can is yours, all right.
I am the private. I am the private in the writ petition.
Yes.
Now, a peculiar situation has arisen. I applied with the my lord, particular officer under the Right to Information Act, my lord, after seeing that, my lord, in the year 2002, in respect of a land in question, my lord, the government wanted to requisition it. I was given notice. Thereafter, nothing happened. Suddenly, in 2023, I find
you're given notice of what?
For my lord, compensation and for requisition. That was not proceeded with. Now, at that point of time, the record in the BLRO says, my lord, that my predecessor in interest was the owner of the property. Now this is an admitted position. Suddenly, why I say this is an admitted position?
What is a prayer?
Sorry to interfere. I am the lead petitioner. Kindly allow me 2 minutes to clarify what.
My prayer is, my lord, that pendants. I wanted the information from the authority concerned. Now they filed an application saying, while the matter was in progress, the authority concerned has issued a notice to them because their name appears instead of my name in the records. I said that how is it possible? Because I was not given any notice from 2002 to 2023. One line. Now they appeared on the first day, second day they appear and say that I will not appear. Now in the writ petition which is there, they say the authority concerned doesn't have any power to issue notice to them. Now what has happened is that the authority concerned, instead of giving me the information, is showing the pendants of the writ petition to prolong the hearing before the authority.
So what is the prayer in the
Clarify position, my lord.
For information, but under the act concern, within a particular time frame, whatever information they have to give me. Now
that is beyond the scope itself, Mr. Rai. What have they challenged the writ petition? They have challenged the issuance.
Yes, and showing
how
that,
can your application be allowed in connection with that writ petition?
No, because I am a party. I am the private party.
This can only be decided along with the writ petition, Mr. Rai.
My lord,
No can application has.
my lord, this is a very short point, my lord.
The
Very short point.
can along with the main writ petition, Mr. Rai.
My lord, the writ petition can be disposed of herein now, my lord. It's a
There
very
is
short
half
point.
copies. I'll dispose of the writ petition along with the can.
Sir, now we are getting additional copy.
My lord, the writ petition, my lord, I am complaining of only as regards to the
Yes, I'll
notices.
not like this. Learned counsel here for the SPIO.
Not XPIO, I'm second appellate authority. The information coming.
Learned counsel for the second appellate authority submits that no copy of the writ petition has been served on the said of the application has been. Who are you?
State respondent.
Very well. The state respondent as well as the second appellate authority submit that no copy of the application has been served on them. Full stop. Learned counsel for the petitioner refutes such contention, be that as it may, comma, let further copies be served on learned counsel appearing for the said authorities to enable them to properly contest the application and the writ petition. Full stop. Let the application be listed under the same heading on May 10, 2024. If it is possible, I'll take up the writ petition also along with it. That is the purpose of the application, actually.
Grateful, Lordship.
Grateful. Grateful.
Item number 30.
In this, before my learned friend begins for the petitioner, not only the application has been served, the writ has never been served on. I'm for West Bengal Financial Corporation. The writ has never been served on us. The application has also been served on a different office, but because
it has not been served.
No,
What
it has
about
not been
that?
served on us.
It has come back, my lord. The writ petition
was
was returned, addressee moved. That was the endorsement.
Serve a copy on the learned advocates for the respondents. They are here now. I mean, serve a copy will come back next week. Whoever has not got a copy, please catch your learned friend. Yes. So please supply copies to all of them so that you can have a fair hearing of the application itself. You are the one. Very well. Since some of the respondents have apparently not received copies of the writ petition, although the application has been served, let the matter stand over till May 10, 2024, when it will be listed under the same heading. Full stop. Learned counsel for the petitioner is requested to circulate copies of the writ petition as well as to ensure that the copies of the application has also been served on all the respondents in the meantime.
Great.
Thank you. Whoever has not received, please just ensure that.
Item number 31.
Yes, Mr. Shahara.
The day before yesterday, Lordship heard this matter and an order has been passed kindly.
Or for work done by you. You are for the respondent.
2 and 3.
2 and 3. You are to pay.
No. The Britannia Engineering Company, who has been engaged by the development authority for the entire job, and they have paid 90% has already been paid also. Kindly turn up page 14.
Yes.
Page 14 is the work order in my favor. Kindly see 11 crore 99 lakhs and odd. Then page 16 is the completion certificate issued on 11th of February 2021. But kindly see last column, project status has been successfully completed on 10th of September 2020. Then my lord, kindly turn up to the bills I have submitted with the authority.
Have they ever denied the bills?
No, never. 90% payment has also been made. Again, I have served a notice
So you
to
have come for the
office.
rest 10%.
Yes, kindly come to the bill that I have annexed, my lord. At page, my lord, 24. The total dues, total last bill.
Yes. 24, I'm sorry. 24, yes.
11 crore and 89 lakhs after tax. It comes down 11 DTS. Payable 97 lakh 88,000 odd plus security deposit. Total.
So this is the amount to
Yes.
plus security deposit.
97 lakh left hand side and 23. Total 1 crore 21 lakhs. Payable. Kindly see, my lord, the head first left hand side. 97 lakhs and security deposit, my lord, that money. So total comes around 1 crore 21 out of 11 crore. 10 crore, almost 10 crore has been paid.
Yes, Mr. Kale, pay the rest of the 1 crore.
I am not the answering authority, my lord, because the Britannia will have to pay this lordship.
Britannia is 2 and 3.
Yeah, for this.
They are the authority, they will, because our development authority already paid to them.
Who paid you on the last occasions?
Entire Britannia, respond number 4, 5.
4 and 5, the lordship. This they are having, my lord.
They have assigned the job with money by the development authority. We have served again, and again, my lord, that order has been passed through email, my lord. Yesterday.
Day before yesterday, when your lordship was pleased to pass an order, my lord, I took the initiative to, my lord, to inform them that since you are having a separate panel lawyer or whatever, to you give it. Behavior was very, very, my lord. I should not say, my lord, whatever, my lord, but we are not the authority because our authority has written one letter, I find, my lord, that to the HDA, that is the my learned friend is appearing for, that you take steps for taking up the issue. But here I find
the 4 and 5 have to be directed. 4 and 5
yes,
will
lordship,
pay you. That.
Yes, lordship.
I'll pass the direction by non-drivers. Your allegations are admitted.
Lordship.
Learned counsel for the petitioner contends that the petitioner did work for the respondent authorities and was entitled to the payment of the bills raised for such work. Full stop. Next para. Although a substantial amount of the dues of the petitioner has already been paid, an amount of rupees 97, 344 is still payable,
and
along with the secure
Earnest money.
earnest money deposited at the inception. Total amount is this:
1 crore 21 lakhs 58,000.
push up. The total amount due, comma thus, comma comes to rupees 1, comma 21, comma 58, comma 110. Push up next para. The authority which is to disburse such amount is respondent number 4 and 5. Push up. It is found from the records that despite service, comma on the previous occasion as well, comma the said respondents were not represented by counsel. Full stop. Learned counsel for the petitioner further hands over a printout of an email communication dated May 2, 2024 to the said respondents. Full stop. Since the respondent numbers 4 and 5 choose not to appear, comma the allegations made in the writ petition insofar as the said two respondents are concerned, comma is deemed to be admitted by application of the doctrine of non-traverse. Full stop. Next para. Accordingly, WPA 11279 of 2024 is disposed of by directing respondent numbers 4 and 5 to pay to the petitioner the amount of rupees 1, 21, 58, 110 within 8 weeks, within 6 weeks from date. 6 weeks from the date of communication of this order to the said respondents. Full stop. In default of such payment within the said period, comma, on and from the date immediately succeeding the date on which the said period of 6 weeks expires, comma, the respondent numbers 4 and 5 shall pay an additional amount of interest at the rate of 8%, 12% on the total dues as quantified above, comma, till the date of payment of such amount to the petitioners. The parties shall act on the server copy of this order without insisting upon further production of certified copy for the purpose of compliance. No rest to cause.
Lordship, may I be allowed to place this my instruction on record, Lordship?
What is that instruction? What does it
say? Milord, it's a letter, Milord, which is written by the Milord Secretary to Government of West Bengal Urban Development to the Chief Executive Officer of Haldia Development Authority.
You are for respondent numbers?
Milord,
You are for the state?
only one, Lordship. Only one. Respondent number 1.
The written instruction filed by learned counsel for the state be kept on record.
Lordship.
Thank you.
Okay, much grateful. Thank
you. New motion heading, item number 32.
My lord, I'm appearing for the respondent bank.
Respondent bank, yes. You are for the
Lordship,
petitioner?
I beg to appear under the petitioner.
Yes, what is that? Bank is the main contesting respondent.
Lordship, bank is the main
yes, what did
answering
do
respondent.
this
Lordship,
time?
that
yes.
Lordship, in a surfacey proceeding, Lordship,
yes.
bank is trying to take possession of one of my property which is not mortgaged to bank, Lordship.
Which
Lordship, is not mortgaged to bank, Lordship. That is the only thing.
You are the borrower.
I am the borrower, Lordship. What is if I
you have taken up the point before the DRT.
Lordship, that
you know that before me, before I say that.
Lordship, that difficulty is that Lordship, the last Lordship, that cause of action arose on Lordship 3rd January 2024, Lordship. Lordship, may I submit one thing, Lordship? What is happening is the Lordship, the property mortgage is just, it's a land and there is a
court cannot go into this.
No, Lordship, just to give a visualize of the Lordship situation, Lordship. What they are doing, Lordship, because even I go to the BRT, Lordship, because I have that limitation, it's already over, Lordship. Even if your Lordship may kindly give us that liberty also, that will serve my purpose, Lordship.
It will not serve your purpose. You cannot condone the delay.
Lordship, may kindly Lordship consider, Lordship, because the Lordship, in any day, if they take my possession of my residential property, which is not mortgaged to them, they are affixing all the notification and Lordship, all the requisite Lordship notification they are affixing on that residential property which is not mortgaged to bank, Lordship. And more importantly, my other family member co-sharers also residing in that premises, Lordship, which is totally illegal even, Lordship. Yeah. We lodged the complaint to the Lordship DM also. Which
DM cannot do anything.
Lordship, because the DM is the authority to give the permit, I mean that for the police protection and all that, Lordship.
Can he adjudicate?
Lordship?
Can he adjudicate? He does not
No,
have
Lordship, but
adjudicate
still, Lordship, because that I have no other remedy because this is on.
Let me hear the bank. Yes.
My lord, their cause of action in this writ petition is the letter dated 3rd of January 2024, my lord, which is the second sale notice. Lordship will kindly see that the sale was fixed on 1/3/2024. The sale did not materialize. And so far as the other points are concerned, your lordship, no essay has been preferred till date, and the property is under the symbolic possession of the bank from the year 2018, your lordship. So, my lord, if there is any other measures which are taken by the bank, my lord, it is very open for them to challenge before the DRT.
Lordship, one more thing is that, Lordship, what they are doing, they have taken physical symbolic possession of my property, which is also not mortgaged to the bank.
That can be challenged before
That's
the
my
DRT.
residential.
Did they take symbolic possession? When did
2018, Lordship. It is mentioned in the letter.
she knew from then?
Lordship, they're again and again they are
Lordship,
doing
it
the
is
same.
written that
Lordship,
from 4/8/2018, my lord, it is under the symbolic possession of the bank.
Lordship, may only one line, if Lordship may kindly, if that.
No, you don't have that liberty now. 2018 notional possession was taken, symbolic possession.
Lordship, the
You knew
subsequently
from
they
there.
are publishing the sale notice and trying to take the possession of the
Does not
property.
furnish a new cause of action. The petition, learned counsel for the petitioner argues that the respondent bank is seeking to take possession of the property of the petitioner, which is not part of the secured assets, comma, divorce the law. Full stop, next para. It is contended that other co-sharers of the petitioner reside in such properties whose rights shall be adversely affected if such possession is taken. Full stop, next para. It is argued that the cause of action for the present writ petition arose only in the month of January this year. Full stop, next para. Learned counsel appearing for the bank submits that the remedy, if any, of the petitioner lay before the debts recovery tribunal, which having not been exhausted, comma, has become time barred. Full stop, that apart, comma, it is contended that the immediate cause of action of the writ petition, that is the sale notice issued by the bank, has not fructified, comma, since the sale has not gone through. Full stop. In any event, comma, the bank has taken symbolic possession long back in the year 2018. Full stop, next para. Learned counsel for the petitioner submits that such symbolic possession has also been taken by including the property which is allegedly beyond the secured assets. Full stop, next para. However, comma, since symbolic possession was taken as long back as in the year 2018, comma, the remedy of the petitioner, the cause of action of the petitioner arose from such date. Full stop. A subsequent sale notice, comma, even if issued by the bank, comma, cannot confer a new lease, LEAC, lease of life to the petitioner insofar as the cause of action of the present challenge is concerned. Full stop, next para. In any event, comma, the writ court is not the appropriate forum for deciding such factual disputes. Full stop, since the petitioner has already lost his remedy by permitting more than 3 years, more than 5 years to pass in the interregnum, comma, no remedy as prayed in the writ petition can be granted. Full stop, accordingly, WPA 11491 of 2024 is dismissed on contest without acknowledgement.
Grateful to your lordship.
Sorry. If you are sorry. Next.
Item number 33.
Item number 33, I appear with the CSC. My instruction is, my lord, we have not been, the copy is not yet with us.
No copy?
I will serve.
You will serve after the matter is over. Let me dismiss your matter, then you will serve. No copy of the writ petition has been served on the CSC Limited. Full stop. The learned advocate for the petitioner is directed to serve copies on the respondents. Full stop. The matter shall next be serve copies on the respondent and file a proper affidavit of service in that regard on the next date of hearing. Full stop. The matter shall next be listed on May 10, 2024. Under this, shall next appear in the list on May 10, 2024.
No,
Please serve copies or not.
Instead of 10th, can it be the Monday? On a 10th, I have got
10th na kore tale May 13th. May 13th.
I am obliged. my lord.
Item 34.
My lord, I am
You are for the petition?
I'm for the petition. My lord, I am led by Mr. Chakraborty.
Mr.
Arijit Chakraborty.
Please use the microphone, Mr.
Mr. Arijit Chakraborty.
Okay,
He
what
is code room number 12, my lord.
What is
Kindly
the
give me
start the matter?
My lord, it is a TMA matter, my lord.
Have you got a copy of the affidavit of service? Otherwise, you cannot take the matter.
So far, this matters are concerned by appear for the Union of India. This issue has been decided by your Lordship, my lord, in other 8 writ petitions.
What is the issue?
The EMA notification they have challenged by which, my lord, the benefit has been withdrawn.
Subsidy scheme.
Lordship will get it where at page 74. And the matter is, the Lordship was resumed order that has been, Lordship states that order for 1
74 is this notification has been challenged here.
Yes. P9.
Yes. Yes, 74.
Lordship, I have a copy of the order judgment passed by your Lordship in other matter.
No, you have by this notification you have closed the scheme.
Yes.
You don't have any right. There is no legal right which has been infringed.
Thereafter,
The government has the authority to close a scheme.
My lord, notification was challenged by 8 other writ petitioners earlier.
My lord already passed this order.
Against that, my lord, the authority of preferred appeal act is pending.
Oh, I decided that it is.
Yes, on the favor of the petitioner.
How did I pass that order?
My lord, order passed on month.
All right, I'll allow the appeal and.
My lord, already
This is that order. That order.
Yes, my lord. Lordship order.
The order passed by
No, did I hold that they had already acted on that previous
Yes,
subsidy?
yes, my lord.
The appeal. What is the stage of the appeal, Mr. Bhattacharya?
Appeal orders, my lord.
Page 80. In the list, there are other appeals. It is to be
Page 82.
I'll keep it in the when should I keep it? Tell me. After the vacation, I'll keep it.
After the
My lord, appeal order 84 is 84.
it has been stayed.
It is administered.
This order has been stayed.
Yes, my lord.
By the division bench.
Well, then I'll record that. I'll record that and learned counsel for the petitioner. Learned counsel for the petitioner argues in support of the writ petition which has challenged a particular notification which was upheld in previous writ petitions by this court. Full stop. Learned counsel for the respondent authorities submit that appeals have been preferred against the said order of this court. You are saying that is. And an order of stay of operation of the said order has been passed by the appellate court. Full stop. Since the appeal are still pending on the self-same issue, comma, it would only be prudent if the matter is adjourned for some time to enable the parties to canvass their cases before the appellate court, appellate bench. Full stop. Accordingly, let the matter stand adjourned and shall next be listed in the monthly list of June 2024.
My lord, one indulgence, my lord.
Yes, yes.
My lord, there is in monthly list item number 1059 and 1063 is similar issue pending before your lordship.
Item number?
Item number monthly list 1059 and 1063.
If those are called, those will in any event not be called on before June monthly list.
Oh, great.
Whoever will be engaged in those matters.
Yes. But no, whenever it is called.
Item 35.
35 also similar.
35 also same order? Yeah. Okay.
What are the benefits?
36.
Item 36.
No, 36, this is my matter.
You are for the petitioner?
Yes, my lord.
All served?
Yes, my lord.
Move the matter.
The only prayer is that I made a representation. I praying for consideration of that representation because on a self-same footing, I am a Kaji. My lord, I praying for regular. My lord, I kindly comment annexure, my lord. P2, that is page 14. I pray for my regularization. That should be considered in accordance with law.
Regulation in what appointment?
Because my lord, this is a appointment.
Home and Marriage Register?
Yes, my lord.
You are a temporary.
My lord. I just like to draw my lord kind attention upon why my lord I am seeking such prayer. P5. My lord, one person, my lord, getting an appointment.
What is the page number of P5?
20. I seeking such relief. My lord, 68 years. I just praying, my lord, that relief has been granted to the this.
No, that is their discretion.
Yes, my lord, in accordance with law, keeping my lord that.
So I'll direct them to consider your representation and dispose it of in the light of this.
Yes, my lord.
I'll do that. The petitioner has Now, the petitioner is functioning as a temporary Mohammedan marriage registrar and has made a representation to the respondent authorities for being appointed as a permanent marriage registrar. Full stop. Next para. Learned counsel for the petitioner relies on a communication dated January 8, 2024, annexed at page 20 within bracket annexure P5 bracket closed of the writ petition, whereby similar relief as the petitioner was granted to a different person allegedly on equal footing, comma, till she attains the age of 68 years. Full stop. Next para. In view of the innocuous nature of the prayer, comma, WPA 12163 of 2024 is being taken up for hearing and is hereby disposed by directing which respondent should consider?
My lord, law minister in this.
Law minister.
My lord, IG.
Law minister has no other business. If he's still there after the election.
My lord, respondent number, my lord.
Why not the chief minister? Impede the chief minister will consider directly.
Respondent number.
He'll give you a hearing and consider it.
Respondent
if you want
number
that.
2, my lord.
Well, he has not up to the.
No,
And
copy has been sent.
P to law minister.
Yes, law minister.
Because
Law
I
minister
made a-
is not so
made a-
sacrosanct. Maybe made a party, but I should not direct. Which one of them should consider?
Two, my lord.
You are for the state. You
Respondent
say.
number 2, my
Who has
lord.
to consider?
Respondent number 2.
Who is the law minister?
My lord, no, sorry, my lord. Respondent number 3, my lord.
Inspector General of Registration.
Yes, my lord.
Directing the respondent number 3, that is the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, to consider the representation of the petitioner within bracket annexure P2 at page 14 of the writ petition, bracket closed, and decide on the same, preferably within 6 weeks from date. Full stop. Immediately thereafter, comma, the respondent number 3 shall communicate the outcome of such consideration to the petitioner in writing. Full stop. The said consideration, while making the said consideration, comma, the respondent number 3 shall also take into account annexure P5 at page 20 of the writ petition. Full stop. Next para. The petitioner shall communicate the gist of this order and a further copy of the writ petition to the respondent number 3 for the purpose of compliance of this order.
Kindly see respond. There are two respondents. Page number 2. Kindly see law minister as well as Inspector General.
Inspector General.
Page number 2. Kindly
That
see.
is my lord. Typography. No.
He's not the respondent.
I just made a character, my lord, typographical error, my lord. Because 2, my lord. That is.
Without leave of court.
My lord, I pray seeking my lord's leave, but that is my mistake.
No, my copy it's all right. 2 is law minister, 3 is Inspector General.
But in my copy also, my lord, that copy, my lord, corrected. In the my copy also, my lord, 2.
The court copy is correct. So I will give you leave to correct your own copy.
No, that is my mistake. My lord, pardon me.
Yes, hard.
I just, my lord,
Next.
Yes.
probably.
Item 37.
37, my lord,
Yes.
for the petitioner made to your lordship. My lord,
Yes.
I am an owner of a premises, my lord.
Yes.
But I had a tenant at one point of time who was using an electricity connection, my lord. But that tenant left, issued a letter to the electricity office, surrendered the meter, and goes away, my lord. Subsequently, my lord, sometimes around
It was in the name of the tenant.
that tenant, my lord.
Then
Just
surrendered went away.
surrendered, went away. That letter is annexed, my lord. The bill has been paid off. Suddenly, my lord, the electricity board comes in 24 April and wants to install a new meter. Says that that tenant has given us a permission. We are saying, my lord, that tenant has gone.
When did the tenant go?
My lord,
approximately.
My lord, as per my lord, letter, my lord,
yes,
more than year back, my lord, she had surrendered. But she had
2023.
surrendered it, my lord, on my lord, no. Lord, kindly see, my lord.
Which page?
My lord, page number annexure P1 14 is, my lord, the surrender of the meter, my lord.
This may be a fictitious document.
My lord,
your client might have manufactured it.
My lord, she had.
This is
Like, she is no
date that-
more a tenant, my lord, in that premises. She admits that. My lord, there is a letter by her to the officer in charge of the police station saying that she has not applied for any fresh meter, my lord. That letter is page number 18, my lord. But my only grievance is if the electricity board has to install a meter there has to be a proper application. They have to follow a proper procedure.
They're installing. What are you doing in the tenanted premises? Have you given it on lease again?
No, my lord. I am the owner, my lord. I am staying there.
Of their own, they're coming and installing a meter. Take the meter.
No, my lord. I don't want that meter. I have a meter, my lord.
Yes, Dr. Sir, what is this?
Absolutely suppression of material fact. At the outset, I must submit.
That is very forceful.
What happened?
What is the material fact?
I tell you. On 25/4, Lordship, kindly take a note of that date. On 25/4/2004, a complaint has been received from
25/4/2000?
2024. 2024. A complaint was received from Gautam Banerjee that there is no power in the said premises.
Who is Gautam Banerjee?
Yes, here is the question. Gautam Banerjee is one of the occupier in that premises, and there was an injunction order taken against that Bula, that is Shobita Rai. This Shobita Rai, according to him, she is a tenant, but here it has been specified she is the owner of that flat, and on that basis, there was an injunction order not to disturb the possession of Gautam Banerjee. And on that basis,
Gautam Banerjee filed the suit in the capacity of a tenant under that Bula.
Shobita Rai.
Who is Shobita?
Shobita is one of the, according to this, may I place that order? Mother of Bula Rai.
Oh, all right.
Mother of Bula. What happened? They want to make the situation very complicated. Now, what happened? This Gautam has already applied for the new meter.
So and you say, as per the suit, Bula's mother Shobita is the owner.
Because
and Gautam is his tenant, her tenant.
Because suit is specifying that. Because
according to suit.
Yes. Because we are not there to determine.
So what injunction was passed?
Yeah, injunction not to disturb the possession of the Gautam.
Not to evict the petitioner with
that is Gautam. And on that basis, Gautam has applied for the meter. And we have gone for giving the connection and they are registering. But this is a precarious situation we are facing. That has been suppressed. Gautam has not been made party here.
May I just say one thing?
Yes.
Lordship will kindly consider this document of mutation. In whose name the property is mutated.
No, I cannot look into the document.
And who's the petitioner before your Lordship? The petitioner is one Chanda Jain. There is no Bula or there is no Shobita. So, if the mutation authority, the West Bengal government has admitted myself, the petitioner, to be the owner of the premises.
Mutation certificate is not, that is not a ownership document. Mutation is not ownership document.
Even if they are the owners, whatever they say.
What is this?
There has to be.
I have not heard you as it.
There has to be a no objection or a permission by the landlord.
We cannot decide titles here.
I'm not saying that for the electricity connection. I'm saying. I am saying for the electricity connection also. There has to be some amount of documentation by the landlord. He is admitting that he is a tenant.
No, let them file an affidavit in opposition. Then this cannot.
And the Gautam is.
You have already installed that electricity.
No, we could not because they are registering, and the Gautam is to be implemented as a party here, Lordship.
Give the details to him.
They have got the details, center details. I will.
In
the sales and premises, Gautam is staying.
You are saying that they are not saying. But they are totally denying it.
I will give them the detail. On the sales and premises, this is the address. I will give them because we are being throttled by this petitioner as well as.
At present, he is being throttled by you.
May I just say one thing, May I just say one thing? Subject to correction, but all I am saying is, if they want to come and install the meter on a request of a trespasser, even, all I am saying that they should follow the procedure of law.
First, Gautam has an injunction in respect of this property in his favor. One. Secondly, Gautam has applied. So you cannot say anything on that.
Kindly see.
This biofishy shows that Gautam is in occupation in whatever question.
Kindly see whether Gautam has applied or not. Kindly see whether there is a document to show whether Gautam has applied or not.
That an affidavit is.
That is my case, because Gautam, the complaint against Gautam.
Let them file their affidavit.
Falsifies the signature of an erstwhile tenant and applies.
Now what were you saying? What is the state to say? I mean, I don't understand what the state can say here.
It will be assist to your lordship something.
Tell me, why keep the suspense? They let them know also.
My lord, in the report, it has been said that Bulara has left the place.
And state, since when was this? Did the state become a civil court? Who is the state to say Bulara has left or not? How are you bothered even? Who has authored that? Whose report? Who has written that?
Authority report, my lord.
Police authority has the right to say Bularai has left, somebody else has come. Police authority has no business here.
So far they have said.
Learned counsel for the petitioner contends that the petitioner is the owner of the subject property, where the WBACDCL is attempting to install a new electricity meter without there being any application on the part of the petitioner. First up, it is contended that one Bula Rai was previously a tenant in respect of a portion of the property, who has since left the premises and surrendered the electricity connection in her name long back. Full stop, next para. As such, comma, in the absence of any application or consent on the part of the petitioner, comma, the WBACDCL, comma, it is argued, comma, has no authority to install such meter or give a new connection. Full stop, next para. Learned counsel appearing for the WBACDCL controverts such allegations and submits that there is gross suppression of facts by the petitioner. Full stop. Learned counsel for the WBACDCL argues that the electricity meter is being sought to be given by the WBACDCL on the application of one Gautam Banerjee. Full stop. Learned counsel also hands over a photocopy of a certified copy of an order dated October 21, 2020, passed in title suit number 504 of 2020 by the Civil Judge, Senior Division, Second Court at Barashat, within bracket in charge, whereby apparently the defendant therein, that is one Shobita Rai, comma, was restrained from evicting the plaintiff, within bracket Gautam Banerjee, bracket close, from the B schedule property therein without due process of law till the next date. Full stop, next para. Learned counsel for the WBACDCL further argues that the said Shobita Rai, comma, the mother of Bula Rai, comma, is the owner of the property. Full stop, next para.
As it appears from that order, we are not going to
your submission, Mr.
My submission as it appears in the order.
Whatever. Acha, very well. As it appears from the order which is handed over in court today. Full stop, next para. Learned counsel for the state seeks to file a report authored by a police official and seeks to argue that the said Bularai has left the premises in question. Full stop. However, comma, it is not within the business of the police to adjudicate on a similar footing as a civil court as to who has left possession or who has title or legal possession in respect of any property. Full stop. Hence, comma, such contention of the state cannot be accepted at this juncture. Full stop, next para. Be that as it may, comma, since serious allegations have been made on behalf of the parties against each other, the respondents are directed to file their affidavits in opposition within a fortnight from date. Full stop. Reply, if any, shall be filed within June 14, 2024. The matters shall be listed for hearing on June 17, 2020.
One prayer, Marshal, then let the Gautam be implemented as a party.
No, at this stage,
I will supply them because the main issue is against.
I cannot direct them
because I cannot because they have made an application and on that basis we have gone for installing the meter, Lordship.
Dr. Shari, you know what you have to produce. If you can produce an application.
Yes, I will produce. But so far the title and everything that cannot be ascertained by this WBC.
Why are you shying away from impleading Gautam Banerjee? Actually, I mean, why not?
Yes, that's.
May I just say, even if he is there, but I am not recognizing him.
Okay.
And the fact,
lawful occupation is
I
not
understand,
required.
but the fact is, the allegation is that he forges the signature of a person who's given the property to me. My property is mutated in my name.
That is a different proposition altogether. No, anybody in occupation, despite the lawfulness of the occupation.
Even, may I just say, let them produce an application. May I just say, like Lordship, what fell from your Lordship, let
that
them
will
produce
delay
an
the matter.
application.
No,
That
but
will delay the matter.
But no, then I'll give you leave to implead Gautam Banerjee.
Yes.
And I'll mention it that if ultimately it is found that Gautam has an interest in this litigation, then I may reject your writ petition on the ground of non-joinder. Because you are taking a risk on that. Gautam cannot be brushed aside altogether since he has made an application.
May I just say, that's my content. Subject to what falls from your Lordship. My contention is the application is made absolutely on a false pretext, and that he forges the signature.
Gautam is a necessary party. Implead him. I'll direct you. Since since the WBACDCL has taken a specific point that one Gautam Banerjee has applied for getting electricity connection at the premises comma, although the writ petitioner disputes the veracity of the claim of such Gautam, either in respect of possession or title in respect of the property, comma, the proper and complete adjudication of the writ petition requires that the said applicant be made a party to the writ petition. Accordingly, the writ petitioner is directed to implead Gautam Banerjee as a party to the party respondent to the writ petition and serve a copy of the writ petition on the said added party at the earliest and file an additional an affidavit of service to that effect on the next date of hearing. The learned advocate appearing for the WBACDCL shall furnish the particulars of the said Gautam Banerjee as available to the WBACDCL to his counterpart appearing for the petitioner during the course of the day.
Lordship. But this
Complete the
petition is bad for non-joinder of party also.
No,
I have not
let
taken that
Gautam be
view.
added. Everything will come.
Forges a signature and applies.
That
Why
cannot
will
be
that-
determined in this writ court.
I am saying that. I am saying that application is only wrong, my lord.
Who knows that your client has not forged this signature in the writ petition?
My lord, because my lord,
Writ
I am
court
in
cannot go into
position-
that. Cannot go into that.
My lord, may this affidavit of service be kept with that?
Yes, yes. That definitely.
I am grateful.
Record definitely.
Item number 38.
Yes.
May I file?
Yes, sir. What is the matter?
My item number.
You are for the bank.
38 and
for State Bank, my lord, but in the same party,
sir.
rate is pending. Item number 366.
See, both can be heard together. My lord, subject.
I'll direct that to be heard along with this.
366, my lord. This read copy today it came to a notice at 12 o'clock. The another read in the same party is there. I checked up with the branch. They said they did not receive the copy of the writ petition. Then I checked up with them after 12 o'clock. They said we have served it on 30th. On 30th of April.
Give a copy of that and
I'll serve them a copy. I can.
at the outset, learned counsel for the bank submits that. What is the number of that writ petition?
The read number is
9096 of 2000.
WPA 9096 of 2024.
24.
24.
লিখেছেন?
Item number 366.
Yes. And the WPA such and such is on a connected issue as the present writ petition. Accordingly, let the said writ petition be listed along with the present on May 6, 2024. When should I give it? Tell me.
After 8, 9, my lord.
Very well.
10,
On
10, 10, my lord, 11.
13th?
My lord.
On May 13, 2024. Next para. In the meantime, the learned advocate for the petitioner is requested to serve a copy of the other writ petition on the learned advocate appearing for the bank as well.
But I will make retain its position. That is my only humble.
Cannot assure.
Retain its.
Item number 39.
Well served.
39.
Deeply obliged.
And I appear on behalf of the CSC.
Over or above? Submersible or
CSC.
Splitting.
Splitting?
So although I have not received the letter, but
As per
application.
I record his
as per my instruction on 22nd
You have
of
given the
December
letter.
2023, we have given a letter. He is deriving supply from his father, having meter number 5445272.
So specific. Learned counsel for the petitioner argues that the petitioner applied for electricity connection, but the CSC Limited has not yet given the same. Learned counsel for the CSC Limited submits that a communication has already been made to the petitioner indicating that the petitioner is already enjoying electricity from an existing connection at the premises belonging to his father, and where the consumer number has also been specified. Be that as it may, since an objection as to
consumer number is not
what has been mentioned.
Only in respect of deriving supply and for splitting of load.
Acha, where
Which is
the
only
consumer
for-
number has also been mentioned, এটা বাদ দিয়ে দিন মাধববাবু। ওটুকুনি কেটে দিন। Full stop দিয়ে দিন। In any event, since an objection as to splitting of load has been taken by the CSC Limited, the concerned grievance redressal officer is the appropriate authority under the WBERC regulations to decide such issue. Hence, WPA 12285 of 2024 is disposed of with liberty to the petitioner to approach the concerned grievance redressal officer having territorial jurisdiction in the area for resolving the dispute as taken herein. No orders to cause urgency.
I'm good.
Item 40. At a line add করে দিন. If so approach, Madhababu. If so approach, the grievance redressal officer shall decide the same, preferably within 6 weeks from the date of such approach.
I'm good.
Item number 40.
Appear for the pitch.
Yes. What about service? Please file your appeal.
No.
All have been served.
Yes, all have been served.
You're here for the state, right? What is the matter, please?
Lord, what happened? Lord,
Please come a bit closer to the microphone or take it a bit closer to you. You're taller than that, so you have to put it up. Yes.
My Lord, I participated in a tender and I got an order from the Department of Health, Government of West Bengal, for supply of medicines to various government stores in various districts of West Bengal. My Lord, I completed supply and I raised invoice to the respondent authorities. My Lord, the invoice amount was 1 crore 18 lakh rupees. My Lord, after deduction of TDS and other charges, I was to receive 1 crore 13 lakh rupees. My Lord, surprisingly, I received only 1 crore 2 lakh rupees, deducting an amount of rupees more than 10 lakh 50,000 without any intimation to me. My Lord, I immediately inquired by filing letters and reminders that why this deduction was made. Thereafter, my Lord, I filed an appeal according to the conditions prescribed in the tender against that illegal deduction, but no intimation has been made to me till date, my Lord. So I have
appeal is to their superior authority.
to the secretary, my Lord.
So what is your present grievance? You
who is the
wanted an adjudication of that appeal.
My Lord, according to the conditions of tender, if I am aggrieved by any of their decisions, then I have to file an appeal before the
We have
appeal
filed that, but they have
I
not
filed.
yet intimated the
No,
outcome.
no hearing, no intimation, no reply, nothing else, my Lord.
That appellate authority is also a party here.
Yes, my Lord.
Which respondent?
Respondent number 2, my Lord.
Yes, Mr. Debra, why are you not deciding his dispute?
First of all, my lord, I am deciding. My lord, I am coming, my lord. My lord, he is not a.
Mr. Bandhavadda, something happened. Thank God. Yes. Yes, Mr. Debra.
He is not a bidder, first of all. Bidder somebody else.
You have already paid one like 1 crore something.
He is the only distributor, authorized distributor.
I am entitled, my Lord.
He has been paid.
He has been paid. The authorized distributor.
No, the appeal has to be decided. Decide that so that he can challenge before this court.
I am not disputing.
I'll direct that to be decided within 4 weeks. Maximum 4 weeks.
Yes.
Learned counsel for the petitioner contends that the petitioner did work for the respondent authorities at the juncture of payment, although substantial amount of the dues of the petitioner was paid, an amount of a little more than rupees 10 lakh was not paid to the petitioner, prompting the petitioner to approach the appellate authority in terms of the tender document. Next para. However, till date, the said appellate authority, that is the respondent number 3, within brackets, respondent number 2.
Yes.
Acha. Respondent 2, that is the secretary, within bracket H and FW, bracket closed, NHM.
Health and family welfare.
Acha, very well. The secretary, within bracket Health and Family Welfare, bracket closed, NHM, Government of West Bengal, has not yet decided the issue and or given an intimation to the petitioner on such count. Full stop. In such, upon hearing learned counsel for the parties, it transpires that the challenge of the petitioner ought to have been decided by now on merits. Full stop. Accordingly, WPA 12300 of 2024 is disposed of by directing the respondent number 2 to decide the challenge preferred by the petitioner regarding alleged non-payment of his total dues as expeditiously as possible, preferably within 4 weeks from date, in accordance with law, and upon giving an opportunity to the opportunity of hearing to the petitioner. Full stop. It is made clear that the merits of the claims of the petitioner has not been gone into in the present writ petition. No address to cause, urgent certificate.
Grateful.
Thank you.
Item 41.
Yes.
41, I beg to appear for the petition.
Right.
My affidavit, sir, this minute.
All served?
Yes, my lord, possibly.
Checked up because no one is appearing.
The State Bank of India is a party, my lord, answering respondent. A small issue, my lord.
What is the issue?
But 2017, I take a loan. Undoubtedly, I become a defaulter. But in 2019, they serve us a notice that since I'm a defaulter, they auction the gold loan. They don't intimate us about the auction. After we send them a letter, they come up with a notice, my lord, if your lordship kindly takes up page 21. The initial page 17 is the letter of auction, a letter of defaulting of a borrower. 60,000 was the loan amount. And they had stated that 12 months will be the tenure of loan. I become a defaulter undoubtedly, must pay 21. When we write a letter to them, they come up with a answer that the small amount of gold is left. You may take it within 30 days along with rupees 100 and the GST amount.
The rest has been auctioned already.
Yes. Now, my lord, what I'm saying, my lord, when was it auctioned? How was it auctioned? Nothing was intimated to us. And I being an illiterate person, my lord, I had taken the loan and by mortgaging my gold of my wife, my lord. Number my humble prayer is, my lord, the report we called for the State Bank as to why and how that gold was auctioned without my intimation. No consent was also given to us.
I'll direct them to file an affidavit in
Yes,
opposition. The petitioner raises certain questions which are required to be answered, comma, thereby necessitating a final hearing of the writ petition on merits. Full stop. The petitioner took a gold loan from the respondent bank, comma, allegedly by mortgaging his wife's ornaments. Full stop. Subsequently, comma, behind the back of the petitioner, comma, the gold, a substantial part of the gold ornaments were apparently auctioned. Full stop. Although the petitioner admits that the petitioner was in default of payment of the loan, comma, it is contended that no opportunity was given to the petitioner to make his representation prior to the said auction being held. Full stop. Next para, upon the petitioner seeking information regarding the same, comma, by an intimation dated, it is undated?
Yes, my lord, undated.
By an intimation as annexed at page 21 of the writ petition, comma, the bank informed the petitioner that most of the gold ornaments have long been auctioned and loan account closed off after serving due notice, and that the petitioner was suitably advised. Full stop. Next para. Since a dispute arises as to whether any notice was given to the petitioner, comma, the respondents are directed to file their affidavit in opposition, disclosing all relevant facts in respect of the allegations made in the writ petition within June 14, 2024, full stop. Reply, if any, shall be filed by June 21, 2024. The matter shall be listed for hearing in the monthly list of July 2024. Full stop. The learned advocate on record for the petitioner shall intimate the gist of this order, comma, preferably accompanied by a server copy to the respondent bank at the earliest in order to ensure that the affidavits are filed in time.
Grateful, my lord.
Prathame affidavit of service filed in court today be kept.
Item number 42.
For the petitioner, the services upon the respondents have not been completed, madam.
You are for some of the respondents.
Some of them.
Kindly takes it up on
Next June monthly list after summer vacation.
Kindly,
Next month.
any after 15, my lord, we are voters. We have vote on 13, my lord. We will not be available, my lord.
You are working in the election?
No, my lord. I have to cast my vote.
On 13th?
Yes, my lord.
So why not before that?
But my lord, we have to engage some senior. Only yesterday evening the copy has been served upon us.
Engage a senior today. Find out in the corridors if you can find any senior. You are sufficiently competent. Why don't you yourself move?
My lord, any day after 15.
But on
No, not after 15.
9th or 10th, madam, because it may take 2 more days to complete.
9th or 10th, then let it come up after the vacation.
So, madam, then any day, madam, kindly.
The counsel for the petitioner submits that service has not yet been completed on all the respondents. Full stop. Let the matter be adjourned till May 16, 2024.
Item number 43.
Yes.
Lordship, in this matter, I'm appealing for the petition if the service is not complete.
Service is not yet complete as submitted by the counsel for the petitioner.
Next week, your Lordship.
Not next week. Accordingly, let the matters be listed in the monthly list of June 2020.
Kindly, your Lordship, there is some urgency in this matter, your Lordship. The
private respondent shall elope from India, Your Lordship. This is regarding
Shall?
he shall leave India.
What did you say first?
Elope from India. Your
Elope with whom?
Lordship.
Anyway,
I'm saying-
তাহলে monthly list of June না করে monthly list of May 2024, which is on next Monday. It will be in the monthly list now.
I'm grateful, Your Lordship.
Thank you.
Item 44.
Item number 44, Mr. Moyuk Mukherjee is appearing for the petitioner. I'm praying for a short passover.
No, either you start the matter or it goes to the next monthly list. An adjournment is sought for the petitioner. Let the matter be listed in the next monthly list.
Madam.
Next.
My lord, a very short passover, my lord.
Item number 45.
Yes.
For the petition, Lordship.
In this matter, my lord, I am appearing on behalf of all the respondents here.
Very good.
Lordship,
Yes. What is that?
petitioner applied for connection for submersible pump. Quotation has been issued. Petitioner deposited the quotation, Lordship. I have annexed.
Why not given?
Thereafter,
It is not given as because the father of the petitioner is accused of electricity hooking, your lordship, and the petitioner is an ally to him, your lordship. Well, I am just submitting my instructions given
we have
by
not
the
received
respondent,
any
your
letter,
lordship.
Lordship.
I kindly appreciate the annexion number 1, your lordship. My instructions. It is addressed to Shafiqul Alam, your lordship, the petitioner hearing. Reference to the aforementioned subject, it is to notify you that you applied for 2 number of new STW connections against above mentioned application numbers. You also deposited quotation amount on 17/10/2023 and 22/9/2023 respectively, suppressing actual fact. But as per our available record, it is detected that for theft of electricity, FIRs were lodged
You are
against
Mr.
your father.
You are Mr. You?
I am Anirban Pal, your lordship.
Mr. Pal, so if he pays these amounts, then the connection can be.
Exactly, your honor.
Lordship, may I submit? My instruction is that the petitioner's father case is pending in a different plot of land, not in this plot of land. And
No,
they
your
are
lordship.
tagging-
No, your lordship. No, your lordship. My
They
instruction
will
is
file your
it is
affidavit in
con-
opposition. Put it in your affidavit in opposition.
Lordship, I will file an affidavit.
A separate
No,
plot
your
of
lordship.
plots of
It's
land.
it's in connection with
disputed
the
question.
same plot of land,
Learned
your lordship.
counsel for the petitioner argues that despite having applied for electricity connection, the petitioner has not yet got such connection. Push up next para. Learned counsel appearing for the WBSCDCL hands over a set of documents which contain communications and a final assessment bill.
Two final assessment.
Two final assessment
final
bills.
assessment
Pushed
bills,
up next para. Learned counsel for the WBSCDCL argues that the petitioner has applied for 2 electricity connections and has already deposited quotation amount.
So we
Pushed
have-
up, however, as per the available records of the WBSCDCL, FIRs were lodged against the petitioner's father in respect of the same premises where the connection is sought to be taken by the petitioner against the police cases as mentioned in the communication dated October 30, 2023, which is made to the petitioner. Push up next para. It is argued that the final assessment bills have not yet been paid, and as such, in view of the nexus between the petitioner and his father and the property, the premises being the same, the connections cannot be given to the petitioner unless the entire outstanding dues are paid by the petitioner. Push up learned counsel for the petitioner controverts such allegations and submits that the alleged premises where theft occurred are a different premises than where the petitioner seeks connection. Push up, since certain disputed questions of facts have arisen, the respondents are directed to file their affidavit in opposition within May 17, 2024. Push up reply finish shall be filed within June 14, 2024. The matter shall next be listed on June 17, 2024. The documents handed over by learned counsel for the WBSCDCL today be kept on record.
I'm grateful to your lordship.
Thank you.
Item number 46.
Lordship, I am for the petitioner.
Yes.
Kindly. Sorry.
I'm for the
Kindly.
respondent number 6.
Yes, move the matter.
Lordship, kindly fix it by next week.
Either you move it or I dismiss for default.
To correction, this is the fair price shop matter. Kindly see the prayers.
That is essential commodity, Mr. Chok.
His representation This page 40, kindly see the last paragraph, page 40, last paragraph.
I don't have any.
Right. An adjournment is sought by the petitioner, full stop. Learned counsel appearing for which respondent, Mr. Chakraborty? Learned counsel appearing for the state submits that the dispute in the present writ petition pertains to a fair price shop and as such should be classified as an essential commodity matter. Full stop. In view of this court having no determination to take up such matters, comma, let the matter go out of my list due to such lack of determination, with liberty to the parties to mention for enlistment before the appropriate bench having determination. Full stop. The learned advocate on record for the petitioner is granted liberty to carry out necessary corrections in the A form of the writ petition, comma, if so required, comma, to that effect.
Right.
Thank you.
Item number 47.
Bank.
For 47, I am for the petitioner.
You're for the petitioner, yes.
Service is complete.
Right. What is the matter?
Lordship, the respondent number 6 called for an e-auction through public notice, through paper publication dated 13th October 2023. Accordingly, the auction was held, e-auction was held, and the petitioners were the highest bidder in that auction. Consequently, they paid.
The notice was dated 13th October.
No, the paper
Auction sale. With paper publication.
The paper publication and e-auction was held on 13th October 2023.
Then
the petitioners made the payment of the consideration amount. Thereafter, the bank, the respondent number 6 issued sale certificate in respect to that.
You have not got possession, you are asking for refund.
No,
I hope not that. That is a
I have
formula.
got the possession. I have got the possession.
Achha.
But they after getting the possession, I found out that there are some movable articles lying over there. And I have requested for several times for removing that movable articles. But the best reason known to them, they are not removing. Even then, even though they took the undertaking from me for a temporary arrangement for them, and after certain period of time, they will remove. But not.
They give an undertaking to you?
No, they have taken my undertaking that I will take care of that movable articles for some temporary period.
Where is that undertaking?
45, page 45. May I help?
Kindly take page 35 first, Your Lordship.
Achha.
The sales certificate.
No, sales certificate, no. Sales certificate does not contain anything regarding the movables.
Thereafter, the deed of conveyance was
Yes,
executed.
that is not disputed.
Yes.
Let us come to page 45, declaration.
Yes, Your Lordship.
We Vijayamedi means you. Yes, right.
I further undertake, last line, Your Lordship.
Yes.
I further undertake to hand over the said movables to you or to some other persons, your instructions only.
So you have left it indefinitely. Why not take the movables?
Right.
Why saddle them with this liability forever?
May I beseech you,
Yes.
my lord? I am the bank. I have sold the property, my lord, by way of and handed over the person to him.
Put it on, please, microphone. Yes. Yes.
So I have handed over the person to him, along with some movables are there. Now, my lord, very innocuous to me to submit this, my lord. My lord may allow his player A. I don't mind that. There is the only one grievance by him, that is the only movables to be removed. Now, may I beseech you, my lord, why I did not do so till now?
Why not?
Why not? So there is a alleged tenant who claimed that he is a tenant there. He was a tenant there, although there was a leave and license agreement for 11 month only for a 1 month. So he filed the subsidy application in DRT below. So essay is pending. And in that essay, I have filed an application also praying that, kindly allow me to remove those goods. Well, may I hand over the copy of the application? May I hand over the copy to him?
Yes, sir.
Kindly see the prayer.
But he has been disposed. That
No. Only the movables only. Can you see the prayer?
No. The tenant has preferred an application under section 17.
The alleged tenant, that application will go in drain.
He is not in possession anymore.
No.
Acha, let us see the prayer.
Can you see the prayer?
This application is kept pending.
Kept pending. And there is one more hinges, my lord. This alleged tenant has filed FIR also, complaint against me also and my officers of the bank, saying all these things. Can you see, have a look on that also?
Lordship, such facts
Give
were
me a
suppressed
second. Have your
from prior to the sanction.
May I hand over copy to him? This is the complaint filed by the alleged tenant. Maybe it may be noted that the alleged tenant and the borrower may be hand in gloves, my lord. So I am ready and willing to remove those movables from the premises. Can I allow that?
Thank you. Yes.
Can I allow that? And my lord,
and there is no injunction.
No, nothing.
From
nothing. Now, may I beseech you only one request, my lord. May I take help of the concerned police station also if required, my lord. That's all. I'm grateful.
But that will be at your cost.
Yeah, of course, yes.
Absolutely. Fair enough.
I was appearing for Union of India and Mr. Bhattacharya.
If you appear for Union, I'll direct CBI to render assistance to them in removing the mobile property. Why is the Union of India party here? Just to make the writ petition maintainable.
Finance secretary.
No, to make the writ petition maintainable. It's an understanding between us. The writ petitioner submits that the writ petitioner purchased a property from the respondent bank in an auction purchase held on October 13, 2023. Full stop. The bank duly issued sale certificate and also gave possession to the petitioner. Full stop. However, at that juncture, the bank extracted a declaration from the petitioners whereby the petitioners undertook that they would safekeep the movables as per inventory enclosed therein within single inverted superdari, SUPERDARI, inverted close, and would hand over those movables to the bank or to some other person upon the instructions of the bank only. So it is submitted that till then, the bank has not removed the articles, thereby saddling the petitioners with the unnecessary burden of having to look after those movable properties. First up, the writ petition seeks a direction on the bank to remove such articles from the subject property. First up, next para. Learned counsel appearing for the bank hands over certain documents, including an application filed by the bank in connection with SA 266 of 2023, which is, according to the bank, an application under Section 17 of the SABYASACHI Act filed by an alleged tenant in respect of the self-same property. Full stop. Next para. Learned counsel for the bank submits that although there is no restraint order impeding the bank from removing such property, for the sake of fairness and in order to avoid unnecessary allegations on the part of the applicant in SA 266 of 2023, the bank has made a formal application before the tribunal inter alia seeking to remove the movable goods from the subject movable property, from the subject immovable property, and to sell the same and adjust the sale proceeds of movable assets in the loan accounts of the borrower. Next para, it is submitted that the said application has not yet been disposed of by the tribunal. Next para, learned counsel for the bank also submits that the bank apprehends criminal action at the behest of the applicant in the said SA, since already complaints have been lodged against the bank officials by the said applicant. Next para, upon a perusal of the materials on record, it transpires that admittedly a sale certificate has been issued in favor of the petitioner, thereby finalizing the sale of the secured assets stroke subject property in favor of the petitioner. Possession of the property has also been handed over to the petitioner. Hence, it is now the responsibility of the bank to relieve the writ petitioner from the continuing liability of looking after the movable properties which are still lying in the property. Next para. Even if an application under Section 17 has been preferred by a third party, in the absence of any restraint order from any competent forum, nothing prevents the bank from removing such movable assets. Full stop. Accordingly, WPA 11723 of 2024 is disposed of by directing the respondent number 6 to remove the movable properties as mentioned in the petitioner's declaration annexed at page 45 of the writ petition from the subject property at the earliest, preferably within 6 weeks from date. Full stop. Next para, it is made clear that such movable assets, after being taken over by the bank, shall be subject to the orders, if any, in that regard, passed by the Debts Recovery Tribunal in connection with SA, ওই যে নাম্বারটা বললাম, SA 266 of 2023. No rest to cause certain certificate.
My lord, one more thing. I'm entitled to reimbursement from the bank.
As per the declaration, no.
Only one request.
Not as for the declaration, but as your lordship, I have requested through legal notices for the several time that for them I have to keep 2 watchmen there, and I'm paying that.
That is on account of bailment. You have to invoke the principles of bailment then. As a bail or bailee relationship, but then you have to go to the civil court.
Yes, your lordship. One line that I may approach civil court.
May I
give you that?
Only one line, my lord. The local police station, Lirua police station is.
That's right. দুটো লাইন অ্যাড করে দিন, একজনের প্রত্যেকের একটা করে লাইন. Learned counsel, the petitioners, it is made clear, shall be at liberty to approach the competent civil court for any claim that the petitioners may have against the bank on account of having retained and looked after the movable properties for so long. Full stop. আরেকটা লাইন অ্যাড করে দিন. The bank, the respondent bank will be at liberty to seek appropriate police help from the local police station in the event any obstruction is faced by the bank of bank employees at the time, bank employees stroke agents, at the time of removing such movable assets from the subject property. Full stop. If so approached, the local police station shall grant such assistance at the cost of the respondent bank.
I'm deeply obliged. I'm grateful.
Thank you.
Yes.
Thank you. এইটা কি ওরা
May I be permitted to mention item number 53 of today's list, madam?
Why?
This is an extreme urgent matter, madam. You should also kindly text on Monday, madam. Because
no, I'll continue in due course. Many of the matters today have been taken up. Maybe I'll reach it on Monday.
Monday month list will be issued, madam. Really.
This order remains unless new matters come, new motions are filed.
This order remains, then nothing will happen.
Has to remain.
Madam.
If it does not retain its position vis-a-vis today's filings, then just point out to me.
Milord, I have a very short matter, Milord.
No. I'll take up the original set. Already
Original
7 minutes
matters?
have crossed. Yes.
Any mentioning? Item number 1 to be mentioned, Anirban Raichaudhuri and others versus the state of West Bengal and others, with 2, Anirban Raichaudhuri and others versus Ramkumar Jha and others.
You are appearing, sir. What is the matter?
Milord, this is the matter, Milord, where I was to come back with my written notes.
Oh, that housing.
Housing.
Yes, file it.
May I file it before the time of rising, my lord? If your lordship rises,
I'll give you that liberty. I'll close argument.
Please, ma'am.
You are for which respondent, Mr. Thakkar?
1. The review, the petitioner, writ petition.
I am the review applicant in a writ petition,
Yes.
Milord, filed by Ramkumar Jha. Milord, your lordship was pleased to allow the writ petition.
Must have to be argument.
Your lordship was pleased to allow the writ petition
Yes.
filed by Ramkumar Jha, where Milord
By
he had-
complicated matters, file your written notes.
Yes, yes, my lord. Otherwise, we'll be re-arguing the matter
Don't
again.
start from Mr. Jha. No.
With the state facts.
Yes. The written notes of arguments filed by the review applicant and the state be kept on record, full stop, on the prayer of learned counsel for the respondent number 1 stroke writ petitioner, the said respondent is granted leave to file their written notes, its written notes of arguments during the course of the day. Full stop. Hearing is concluded in the matter and judgment is reserved. Thank you.
Grateful.
My lord, in item number 1, this is. There is
Only
a-
one.
One.
Two
Very
is, my lord,
Two
an
will stand
independent
over.
matter.
To stand over, my
Hand
lord.
over, my lord, your lordship will kindly, my lord, direct two to.
Huh? Was the review?
2 was the review. This is the order made in the review application.
Not WPC.
What is pending?
My lord, 1 will remain pending.
The writ petition itself.
My lord, I won't say it will depend on the result of 2. It is an independent writ petition praying for 16B2 exercise under the Apartment Ownership Act. That is 1.
So when should I take it up?
My lord,
After your
I'll
lordship
leave it to your
pronounces
lordship.
judgment in this matter.
Because, my lord, pronouncement of judgment.
16B2.
After puja vacation.
Yes.
My lord,
Yes, my lord.
Item number 1 একটা order record কর। Since the subject matter of adjudication in the present writ petition may have a connection with the outcome of RVW RVWO 7 of 2024, comma, let the matter stand adjourned till I cannot do it this side probably. There are several. I'll put it on 20th May. Let us see. Till May 20, 2024.
Grateful.
আজকে কত তারিখ? 3 20 মধ্যে হয়ে যাবে। Oh, sorry.
Review application to SABYASACHI. Item number 3.
Yes, Ms.
Apex
Supposed to adjourn.
Traders.
My lord, I am for the petitioner. My lord, I have served, my lord, both the respondents. My lord, may I file my affidavit of service?
They're consistently not appearing.
Yes, my lord. Yesterday also the matter was called.
Right.
My lord, I have served.
Anyway, let us say. You have checked up. Everybody has been served
My-
properly.
my-
Let us hear the matter. Yes.
My lord, here, my lord, what has happened? My lord, the writ petitioner is a company before my lord. My lord, listed with the, my lord, only with Calcutta Stock Exchange. My lord, it has, my lord, a paid up capital of only 20 lakh. And my lord, this company has, my lord, no turnover since, my lord, COVID pandemic. My lord, it's a very small company, my lord. 144 shareholders are there. Out of that, my lord, 120 shareholders, they are holding only 100 or, my lord, less than 100 shares in the company. And, my lord, there has not been any, my lord, transfer or, my lord, change in the shareholding pattern for the last 15 years in respect of the, my lord, writ petitioner company. Now, my lord, what has happened? My lord, on and from 23rd of April 2019 till, my lord, 14 July
23rd of
April 2019.
Yes.
And, my lord, till, my lord, 14 July 2022, the company, my lord, did not have, my lord, a whole-time company secretary. My lord, for that purpose, my lord, the my lord, respondent number 1 issued a show cause notice saying that there has been a violation so far as section 203 of the Companies Act is concerned. Now, my lord, that show cause notice we have received on 24th of June 22. My lord, page 21 of my petition. My lord, I have, my lord, immediately upon, my lord, receipt, my lord, responded to, my lord, the my lord, show cause notice. And in my representation, I have also stated that on and from 15 July 22, we have, my lord, a whole-time company secretary in the company. My lord, the company secretary we could not retain because, my lord, the size and, my lord, the factors with regard to the business of the company. So, my lord, no full-time company secretary was.
What has been done now?
Now, my lord, we have a company secretary since July 22. Despite that, on the, my lord, without considering my representation in 23, my lord, 23rd May 23, my lord, the first respondent has, my lord, imposed a penalty of rupees 10,58,000 on the, my lord, company and the second respondent who is a director in the company. My lord, we have, my lord, gone up in appeal. My lord, before the regional director, which is the respondent number 2, my lord, the regional director has, my lord, dismissed our appeal without any, my lord, reasoned order. My lord, it has just confirmed, and, my lord, with a premeditated, my lord, view, my lord, it has confirmed the ROC, my lord, order. My lord, that happened.
So, for the first you are challenging that here.
My lord.
I'll first see 203
My lord, kindly.
I'm not very well acquainted.
My lord, the thing
Companies
is,
Act is that.
in the show, my lord, if I may hand over, and my lord, in the show cause notice also, my lord, the relevant provisions are set out.
Let us look into that provision.
Very well. My lord, if I may place 203,
Yes.
appointment of key managerial personnel. My lord, this key managerial personnel is defined under, my lord, section 2, subsection 51,
All right.
which includes a company
Secretary, right?
Yes, my lord. My lord, may I place subsection 1?
Yes.
Every company belonging to such class or classes of companies as may be prescribed shall have the following whole-time key managerial personnel: managing director or chief executive officer or manager, in their absence a whole-time director, company secretary, and chief financial officer. Then, my lord, provisos are also there. My lord, my lord,
You do not fall within any other. Otherwise, you don't fall within any exception. You ought to have a compulsion.
My lord.
What is the penal provision?
My lord, the penal provision is, my lord, subsection 5. My lord, if I may place,
Yes.
if any company makes any default in complying with the provisions of this section, such company shall be liable to a penalty of 5 lakh rupees, and every director and key managerial personnel of the company who is in default shall be liable to a penalty of 50,000 rupees, and where the default is a continuing one, with a further penalty of 1,000 rupees for each day after the first during which such default continues, but not exceeding 5 lakh rupees.
When the show cause notice was issued to you, at
My
that
lord.
juncture, you already had a company secretary.
My lord, that was in June. My lord, from July onwards, my lord, next month, I had a, my lord,
After getting the notice, then.
Yes. But my lord, both the orders, my lord, did not consider that. Both the orders are after, my lord, appointment. And my lord kindly appreciates, my lord, from 2000, my lord, this is for the financial year 2019-20 onwards. Because, my lord, 23rd April 2019 onwards, my lord, till, my lord, 14 July 22, I did not have a, my lord, company secretary. My lord, this is...
But the language is if any company makes any default in complying. So you have to have a company secretary. But even if you did not have for a past period, this applies squarely.
My lord, for that, my lord, I wanted to show, my lord, rule, my lord, kindly sees 8 of the company appointment and remuneration of managerial personnel rules. My lord, I can...
What is the year of the rules?
My lord, this is 2014. Or, my lord, it is set out at page 21, my
I'll
lord.
look into that.
Yes.
Let us come to page 21 then.
My lord.
Yes.
My lord, at page 22, my lord, the first paragraph. My lord, if I may place,
yes.
Rule 8 of the company's appointment of and remuneration of managerial personnel rules 2014 provides inter alia that every listed company and every other public company having a paid up share capital of 10 crore rupees or more shall have whole-time key managerial personnel. And my lord, Rule 8A is, my lord, if I may also place, a company other than a company covered under Rule 8 which has a paid up capital of 5 crore rupees or more shall have a whole-time company secretary. My lord, Rule 8A is not applicable for us. My lord, we are coming under Rule 8 because it says every listed company and every other public company having a paid up of 10 crore. Now, my lord, I am only listed with Calcutta Stock Exchange.
You have a paid up share capital of more than 10 crore.
Only 20 lakh. My lord, only 20
Why do you
lakh.
say you come within 8?
Because it says every listed company and every other.
And right.
Yes,
I'm sorry.
So, my lord, technically I am a listed company, but my lord, the listing is with Calcutta Stock Exchange, which is, my lord, lying defunct. My lord, I do not derive any liquidity benefit, my lord, from that platform.
Let's see whether the appellate authority's order lacks reasons.
My lord.
Where is that? Which page?
My lord, page 126, my lord, is the appellate authority's order of 1st January 24. It's in the second volume, my lord.
Yes.
My lord, it starts from, my lord,
There is no mitigating factor for you. Apart from, yes, you may have a share, put up a capital of 20 lakh only, but that does not mitigate your circumstances. I mean, you are not exempt from the act.
my lord, the thing is, my
Because within
lord,
their jurisdiction, they've done it. Where is the jurisdictional error?
my lord, the thing is, my lord, the jurisdictional error being, my lord, I have, my lord, given a representation. My lord, kindly considers, my lord, the fact that I am a very small company. My lord, in name, that is only, my lord, in name, I am, my lord, a listed company. I do not derive any benefit therefrom. My lord, had it been, my lord, any, my lord, stock exchange like Bombay Stock Exchange or National Stock Exchange, my lord, then, my lord, this could have been, my lord, the compliance, my lord.
Please show me your representation, Ms. Chakraborty.
My lord, page 24, my lord. My lord, if I may place from, my lord, paragraph 1, and, my lord, this is received by them, my lord, no reply. My lord, paragraph 1, particulars of the whole-time key managerial personnel in compliance of section 203 of the Companies Act read with rule, my lord, it should be rule 8, my lord, of the rules of 2014 are as follows. My lord, Mr. Such and Such is the Chief Executive Officer of the company, and Mr. Such and Such is the whole-time Secretary and Chief Financial Officer of the company. This appointment was made on 15 July 22. Now, my lord, if I may place the, my lord, the paragraph starting with, it is pertinent to mention that the company, although listed at Calcutta Stock Exchange since 1980, has had a small capital base of rupees 20 lakh, including since the period prior to it was listed. The CSE itself has been practically defunct for almost a decade now and does not provide any benefit of liquidity to the company's shareholders. The total number of shareholders at 142 is very small. That about 120 said shareholders, that is 82%, they hold 100 shares or less, and there has been no movement in their shareholding during the past 15 years.
Ms. Chakraborty, very well. Let me see the ROC order once.
My lord, that is at page
Yes.
25. The adjudication.
The first authority.
My lord.
25.
25, my lord. 23rd of May 23. My lord, our representation, my lord, is at page 27, para 4. And thereafter, my lord, page 28 onwards, my lord, they also, my lord, took note of the fact that the company secretary is now there along with full-time financial CEO. Thereafter, my lord, the ordering portion says, if I may place, the applicant company and its officers who have defaulted. The provisions of section 203, read with 2035.
Chakraborty, that is not a mitigating circumstance. Even if you previously defaulted, you are liable to, I mean, you come under 203.
My lord, three things.
It need not be a continuing at the juncture when the order is passed. It need not continue till then. Default means a default.
My lord, three things. My lord, the default is from the financial year 2019-2020. My lord, that is COVID period, my lord.
Yes, COVID period has not been, although it has been stated, relaxation of period of limitation due to such and such, that does not cover you. You go beyond that period.
My lord, I have, my lord, the thing is, I have challenged, my lord, this show cause notice.
No, your thing, there not being a CS continued till 14th of July 22, much after the COVID period.
My lord, because, my lord, no other company secretary was also willing to be part of, my lord, our company, which has a very small capital base. And, my lord, it is practically, our company is also practically, my lord,
Very well, I'll pass it out. I'll disposing of the requisition. Despite service, none appears for the respondents. First up, it transpires from the previous order that on the last occasion as well, the respondents were not represented. First up, the affidavit of service indicates good service, and as such, the writ petition is taken up for hearing on merits. First up, the grievance of the petitioner is that the petitioner is a small company, comma, although coming within the purview of within single inverted listed companies, single inverted clause, as contemplated in the Companies Act 2013. Full stop. The petitioner has a small capital base of rupees 20 lakh only, and the total number of shareholders of the petitioner company is merely 142, comma, out of which about 120, that is 82%, comma, hold shares or hold 100 shares or less, and there has been no movement in the shareholding during the past 15 years or more. Full stop. Next para. Learned Counsel also points out that there has been no movement in the capital of the company since a long time, also more than 15 years. Full stop. The company is listed with the Calcutta Stock Exchange, which has been practically defunct for almost a decade now. Full stop. It is contended that despite the above mitigating circumstances, comma, the adjudicating authority under section 203 of the Companies Act 2013, comma, imposed huge penalty on the petitioner to the tune of rupees 10 lakh 58,000. Full stop. Next para. It is submitted that when the petitioner approached with a challenge against the said order before the regional director, comma, the regional director affirmed the order of the first authority without taking note of the detailed representation highlighting the circumstances as narrated above, comma, but mechanically confirming the order of the first authority. Full stop. Next para. It is argued that as such, comma, the orders of the appellate authority as well as the first authority is the registrar of companies, and the first authority, that is the registrar of companies within bracket ROC bracket closed, are vitiated for non-consideration of material facts. Full stop. Next para. Upon a perusal of the language of section 203 within bracket 5 of the Companies Act 2013, comma, it is clear that the same confers a discretion on the ROC to impose penalty. Full stop. Next para. The said discretion also includes the converse, comma, that is the discretion not to impose penalty or to impose lesser penalty. Full stop. Next para. The language of subsection 5 of section 203 is that if any company makes any default in complying with the provisions of the section, comma, such company, তারপর double inverted মধ্যে, shall be liable to a penalty, double inverted clause, of the amount as stipulated therein. Full stop. Thus, comma, there is no mandate in the said language. Full stop. The liability to pay penalty is subject to adjudication by the concerned authority, that is the ROC. Full stop. Next para. Such discretion has, comma, associated with it, comma, a responsibility of the adjudicating authority to take into consideration any mitigating or alleviating circumstances which might have visited the company in question before imposing such penalty and or deciding the quantum of the penalty. Full stop. In the present case, comma, several substantial alleviating circumstances were placed before the ROC by the petitioner company by way of its representation. Full stop. Although the representation has been substantially narrated in the order of the ROC, comma, in the ordering portion thereof, comma, it is found that the ROC mechanically observed
Page 28.
that the applicant company and its officers have defaulted the provisions of section 203 within bracket 1 read with section 203 within bracket 5 of the Act for non-appointment of whole-time company secretary and is accordingly liable for penalties under subsection 5 of section 203. Push-up. Next para. Apparently, the ROC also took into account the factors therein above and considered the relaxation period of limitation due to COVID-19 pandemic. However, the ROC merely paid lip-service to such consideration, since there is no reflection as such in the order of the ROC of any material consideration of any of the factors which were portrayed by the petitioner as mitigating circumstances. Insofar as the appellate authority, that is the regional director, is concerned, the said authority mechanically affirmed the order of the ROC on the premise that no infirmity in the order of the ROC could be shown to the appellate authority. Such mode of adjudication indicates non-application of mind on the part of the appellate authority, that is the regional director, to the facts and circumstances of the case while considering the imposition of penalty on the petitioner company. Next para. Thus, in the absence of any real consideration worth the name of the mitigating circumstances of the petitioner company and the size of the petitioner company, including that of its number of shareholders and share capital, as well as the fact that the company secretary has already been as well as that a whole-time company secretary has already been appointed by the company since July 15, 2022, the impugned orders of the appellate authority as well as the ROC are vitiated for non-consideration of material facts. Accordingly, WPO 349 of 2024 is allowed, thereby setting aside the impugned order of the regional director
and the ROC, Malad.
Yes.
Page 15, Malad.
Dated December 21, 2023, as well as the order of the Registrar of Companies dated May 23, 2023, whereby penalty was imposed on the petitioner company under section 203 within bracket 5 of the Companies Act 2013. The Registrar of Companies shall reconsider the representation of the petitioner and upon giving an opportunity of hearing to the petitioner, decide the issue of imposition of penalty under section 203 within bracket 5 of the Companies Act afresh. It is expected that such reconsideration shall be concluded within a reasonably expeditious period, preferably within 6 weeks from the date of communication of this order to the ROC. No orders to cause urgency.
Deeply obliged, Malad. Malad, the order date has gone down as December 23. Malad, it will be 1st January 24, Malad. RD order, Malad.
সেটা সেট করলেন যে অত আগে কি দেখছো?
একটু আগে।
Such and such First January 24. ওইটা ডিসেম্বর December. This only, yes. হয়ে গেছে? নামো। Thank you.
Item number 4, Anil Kumar Jain versus Union of India
Yes,
and others.
for the petitioner. Yes.
Lord, this is a matter, my lord, where the LOC was issued, my lord, at the request of the
Bombay High Court has set aside
Yes,
for 57 pages judgment.
yes. We have the last portion of that, my lord, not the entire.
Mr. Trivedi was appearing in that matter.
My lord, I am constrained to my mother High Court.
No, you are challenging the LOC, Mr.
This, my lord, what happened is on an earlier occasion, my lord, same LOC, my lord, which was at the request of the bank, your lordship has, my lord, set it aside against one person. Now that request and the memo of the Bureau of Immigration, my lord, mentions 13 persons. So request, my lord, is the same. So, my lord, I have come before your lordship, my lord, I am similarly placed. And this request, your lordship has already...
That order has been annexed?
Yes, my lord. Kindly takes, my lord, the second volume. I'll have to show, my lord, two orders. Kindly takes page 160. This is the day when the request was, my lord, disclosed. 12th March 2024. Kindly, my lord, takes paragraph 3, 4, 5 and 6. Today, when the matter is called on for hearing, learned advocate for the bank hands over a copy of the memo dated such and such, issued by the Bureau of Immigration on the subject of opening of 13 regular LOCs. In the memo, it has been recorded that in respect of one Mr. Sureka and 12 others, LOCs have been opened. Said memo also quotes the MHA guidelines. Counsel for the bank submits that the 12 others, along with Mr. Sureka, includes the present petitioner. However, it is evident that a copy of what is handed over, the same is not the request. Now, my lord, kindly takes page 163. I'm not reading the balance portion, my lord. 163, my lord, 14th March. The request, my lord, then is handed over to your lordship, which is the basis of issuance of all these 13, my lord, LOCs. I am, my lord, one of them, my lord. And your lordship, my lord, has set it aside, saying that, my lord, the grounds are very high and therefore, my lord, should not have been issued. Kindly takes, my lord, paragraph 2 onwards. It transpires from the documents handed over in court today that there is no specific...
Yes.
Yes, so that, and my lord, row 17, paragraph 3 of your lordship's order.
Mr. Trivedi, how does this go? I mean, the bank requests to the immigration authorities directly, and then you issue the LOC.
That is issued, my lord, and
Now, one more thing, my lord.
Here, as
Sorry.
this petition is concerned, my lord, we are not the answering authorities because Union of India. Because here, CBI is not a party. CBI has registered an RC in respect of this case.
I have disclosed that.
I know that. I also came to know from that only because I am not omniscient. Now, my lord, so under those circumstances, what I am submitting is answering respondent either is the state bank against whom all the prayers are.
State Bank has answered already on the previous.
There's a distinction. I'll
Oh,
my lord, what the orders have been placed, which has been passed by my lord on the identical footing, my lord, I understand that they had already answered, they were parties. But my lord, CBI should be there because they are the investigating.
CBI has also sent a request.
No.
CBI has not sent, but they are investigating authorities who are investigating this particular.
Immaterial. Lookout circular cannot be on the basis of any investigation. Mr. Trivedi, you know this, your own circular. You are the union, therefore MHA is under you. Your circular. Give some power to yourself also, Mr. Trivedi. I've been repeatedly saying this. Now it has been set aside. Rightly. Because it's entirely dependent on the bank who substitutes recovery proceedings by this. This is not a comment on Mr. Rai, but on the banks in general. They are doing it. All of us know that.
Lookout
Every high court is setting aside.
Lookout circulars are imperative, my lord, to certain
Mr.
extent.
Trivedi, I am not of the opinion, I'm being very candid, not of the opinion that you cannot, I mean, this circular is bad. I'm not on that ground. Because yes, the grounds are very high in this circular. MHA may issue such things because that comes within, somewhat comes within Article 19.5, 4.5. But implementation, the problem lies with the implementation. Who are you leaving the implementation to? The bank requests, immigration authorities do it. You do not come into the picture at all. Or even the immigration authorities do not, because it's the government which can have the inputs, which actually would show whether that LOC is necessary. LOCs must be on a high ground, and which is, as per your circular, it is.
What is falling from my lord?
After the request, it has
process
to be
of
screened.
issuance,
Yes,
the
has to be
screening
screened.
process and coming
Right.
to that understanding the reasons to believe to issue that
Right.
LOC should be on a higher pedestal.
Yes,
what is
the
falling.
immigration authorities have to have inputs from the maybe from the CBI or the others and then decide. It has to be in the circular, otherwise you don't have that discussion now.
Well, let us.
Yes, Mr. Rai, what?
I've seen the Bombay High Court judgment over there. It was stated that the
No, I'm not
court
on
can-
Bombay. I do not
the court
rely on
can
that.
or even the investigating agency can request for the.
I'm not relying on the Bombay. I'm only on the circular.
The circular lordship. I'll be relying only on 2 pages lordship of the FIR lordship, the page 115 lordship of the second volume. The total
115.
Yes, the total amount dues which are in question, that is 12,000 crores. That is the amount lordship, and the names of the accused persons in the first order, which Mrs. Noel was showing. In that case, that person was not an accused, but here he is an accused. He's the accused number 3 lordship. Lordship will kindly turn over to page 116. Anil Kumar Jain, the writ petitioner here, is the third accused lordship. Fourth, yes. Fourth, I'm sorry, lordship, it is fourth.
Yes.
And lordship will kindly turn to page 119, lordship. Number 13, lordship, action taken. Action taken is since the above information deals with the commission of the offence. So case has been registered, RC registered, and this is the IO. The investigation is going on. Now, lordship, CBI is not a party here. Whether LOC should be there or not, I think
Investigation
the CBI
is not even a ground. Investigation is not even a ground.
But ultimately,
if a criminal case is pending, that could be a ground.
And if the person goes away, lordship, after the investigation, then lordship, it will be difficult to bring him back, lordship.
On that ground, wherever any investigation is going on, everybody should be restrained from leaving the country.
Huge, lordship, 12,000
That is
crores.
being paranoid. That is precisely what I said on the last occasion. You are being paranoid here. Anybody against whom an investigation is initiated, he becomes guilty and he cannot leave the country. How can you interdict his leaving the country at all? Whatever may be the allegation by the bank.
Public money.
However high the bank, public money, what are you doing with public money? I mean, anyway. I'll record your submission and set aside the LOC.
Though I'm not an answering respondent here, Miller.
Then don't answer.
Miller, let me put 1 or 2 points. Miller, economic offenses there, Miller. Now, the stake is that Miller, if they leave the country, what I understand, Miller, though, if they leave the country and they don't come back, Miller, it becomes very difficult for us.
To do what?
Whether there is an extradition treaty or not, to bring them back, and we have to.
Mr. Trivedi, if they're not available, what happens? Tell me. Tell me. I'll go to the ultimate. If this person is not available, at best they can recover the amount. There is no money laundering allegation against him.
CBI has started.
CBI is not a magic word, Mr. Trivedi. CBI does not mean money laundering.
I bow down to what is.
ED is not there.
I am bowing down to whatever my lord is saying. But my lord, the PMLA aspect under section 3, if there is an FIR tomorrow, therefore, my lord,
This if is very dangerous, Mr. Trivedi. There is many a thing between an if and a but and the actual happenings.
I bow down.
We cannot go on ifs.
Lord,
At best, what they can do, they can file a recovery proceeding, Mr. Trivedi. They can attach his property ultimately.
Assumptions, my lord.
And he will be only jailed as a civil consequence. That will be civil imprisonment if the attachment does not satisfy the amount. There is no PMLA allegation, no financial offense.
Economic offenses, my lord.
This is not an economic offense. As yet, there is no allegation of economic offense. That is precisely what I am saying, Mr. Trivedi. Money laundering is on a different footing. The predicate offense cannot itself be an economic offense. Here it is not a predicate offense even. Don't go about clamping PMLA allegations now against every defaulter. The next thing that will be done is that, as per the advice of the court, this section has also been added. PMLA is added. And ED, it goes out of my determination.
Here I am representing Union of India.
Yes, you are the culprit. You have put into force this circular without retaining any control on the decision-making process. Tell your authorities you have to have some control.
My lord, after this we will surely revisit because so many
After this, super,
so many, my lord, what I'm trying to
so many courts are sitting aside.
that is what I'm trying to impress upon my lord, that because so many honorable courts are setting aside, we need to revisit the entire issue.
Anyway, yes, Mr. Roy, this is what you are saying is the differentiating factor.
Yes, because in that case, he was not accused.
Which case?
In the earlier order, which has been annexed, Lordship, in that particular case.
No, this is on a subsequent investigation that has come up. This is
No,
after your
This
request.
was already there, but against that very gentleman who was a writ petitioner there.
What is
whose
the date
order
of your request? The request is previous.
Request is previous. But since he was not an accused, we did not press for that. But here he is an accused. That is the difference.
He became an accused after the request was raised.
This is a different person, Lordship. That is Ajay.
Different person. The request remains the same.
Request remains the same.
This accusation against this person, this document which you are citing,
yes,
at page 115, I mean
104, the FIR is starting.
104. When was the FIR lodged?
FIR was lodged
29th of.
Yes, 29th.
No, the complaint was received on 29th of August 22. Date of complaint is that.
Milord, this also has been set aside by your lordship, Milord. The foundation
6th of September.
The FIR was, Milord, a forensic audit report, Milord, and on that basis it was declared fraud. That was the basis of the complaint and the entire FIR. Milord, your lordship has set aside that fraud declaration and all consequential steps. There is nothing else in the FIR.
No, the FIR, insofar as you are concerned, the FIR has been set aside.
Yes.
That order you have annexed here.
That order was, Milord, 2 days back, Milord, your lordship has passed. I'll just take it out.
This is the LOC, what was stated in the tabular sheet of the LOC, where lordship had noted that it was not an actual request, but the request is going to be made. That was the situation that is in page 166, page 4, lordship. That is para 9. Now here, lordship, actually, he has been marked as an accused. That is the difference. In this case, he was not marked as an accused. That is Ajay Shureka. This is a different person. His name is Anil Kumar Jain.
Learned counsel for the petitioner submits that on the basis of a request raised by the respondent bank, comma, a lookout circular within bracket LOC, CAPSE, has been issued against the petitioner. Push up, next para. It is submitted by placing reliance on an order of this court dated March 12, 2024, passed in WPA 2002 of 2024, comma, that the self-same request, comma, which gave rise to as many as 13 LOCs, comma, was set aside along with the LOC in the said case. Full stop. Next para. As such, comma, the present LOC issued against the petitioner, comma, being premised on the same request of the bank, which has already been quashed, comma, cannot survive. Full stop. Next para. Learned counsel appearing for the Union of India submits that since an investigation has been commenced by the Central Bureau of Investigation, comma, the said agency ought to be heard before passing any final order in the present writ petition. Push up. Learned counsel for the next para. Learned counsel for the bank points out that as opposed to the petitioner in WPA 2002 of 2024, comma, the present writ petitioner has been clearly named as an accused person in the FIR registered by the Central Bureau of Investigation on the complaint lodged by the bank. Pushed up. Next para. It is argued that thus, comma, the facts of the present case are different from the ones cited by the petitioner. Pushed up. Next para. A perusal of the order dated March 12, 2024, passed in WPA 2002 of 2024, which has also been annexed to the present writ petition, shows that the self-same request, which was the genesis of the present impugned LOC, was itself set aside by this court by the said order, along with the LOC issued in that case. Push up. Next para. Thus, comma, the very premise on which the present LOC has been issued has already been quashed and cannot retain validity as a basis of the LOC. Push up. Next para. The concerned circulars issued by the MHA, comma, Union of India, are based, provide that such LOCs shall be issued on the request made by the entities as enumerated therein, including certain high officials of the bank. Full stop, next para. The request itself having been set aside, comma, subsequent naming of the petitioner as an accused in an investigation does not itself constitute a differentiating factor. Full stop, next para. That apart, comma, it is well settled in Indian criminal jurisprudence that a person cannot be held guilty unless so found by a competent court of law. Full stop. In the present case, comma, merely because the petitioner has been referred to as an accused person in an investigation being carried out by the CBI, comma, that too on the basis of a complaint made by the bank itself, comma, which was merely a corollary of the various actions taken against the petitioner, comma, it cannot be said that the request, that the validity of the already quashed request is revived. Full stop, next para. In view of the above, comma, the impugned LOC cannot stand on sound legal footing. Full stop, next para. Accordingly, WPO 359 of 2024 is allowed on contest, comma, thereby setting aside the lookout circular issued by the immigration authorities at the behest of the respondent bank against the petitioner. Full stop, all consequential actions taken pursuant to such issuance of lookout circular stand hereby reversed, and appropriate steps in that regard shall be taken by the immigration authorities promptly. Full stop, no arrest to cause urgency.
Lordship, as regards the LOC as a composite whole, it was entirely quashed or only against the petitioner as appears in this earlier order, Lordship? If it is entirely quashed, then all 12...
Follow my order when it comes up in the website. It was the request which was quashed along with the LOC.
Request as a composite of the 12 people or only one person, Lordship? Because from the paragraphs, Lordship...
You will find from my order. Next matter.
But, I'm sorry, I should have had that order, my lord. May I indicate?
I have not referred to that. Yes.
Item number 5. Keshava Das,
Grateful.
Mundra, and
For the petitioner, Mr. Trivedi.
My lord, I am.
Yes. He's threatened. He says, I am. Yes, what is the matter? My lord, sorry, yes.
I appear for the petitioners, my lord. My lord, this is a limited challenge by the petitioners with regards to the freezing of the DP account on the basis of the Calcutta Stock Exchange complaints, my lord. My lord, I'm led by Mr. Bose in the matter. He's unwell.
Mr.
Moinak Bose. He's unwell. He's not in court today. My lord, may I request...
He has serious objection, but
no, he will.
I'll overrule that. Yes.
My lord, could it be taken up on Wednesday, my lord? That's the only thing.
If you have no objection, all of you, very well. On the prayer of the petitioner,
My lord, perhaps Wednesday is a holiday. My
oh, yes, you are right. Thursday then. On the prayer of the petitioner, let the matter stand adjourned till May 9, 2024.
Great.
Item number 6. Central Oriental.
Please, Lordship, I'm appearing for the petitioner.
Yes.
Very brief issue, my lord.
You are for the respondent.
I am for the respondent, my lord. My lord,
Authority or private?
Bank.
Oh, achha.
Bank.
Yes, I'd love to allow his petition.
No, my lord, only one.
You have been appearing against the bank.
I would be requesting for 1 day's time.
Why?
My lord, I have a leader in this matter. My lord, he has personally requested me.
Who is the leader?
Mr. Abrojit Mitro, my lord.
I've just been informed by my learned friend. So, my lord, I cannot oppose.
My lord, just 1 day's time. My lord, he requested me to make this prayer.
May I only indicate this, my lord? There's nothing much in the matter so that my learned friend...
I'll record an order, Mr. Bag.
No, it's not for that, my lord.
An adjournment is sought on behalf of the respondent bank. Full stop, accordingly, let the matter stand adjourned for the day.
I'm very deeply opposed.
I'm grateful, my lord.
Oh, affidavit of service filed today be kept on.
Item number 7. Ramchandra Mahato versus the branch manager IDBI Bank.
I beg to appear on behalf of the respondent number 1, IDBI Bank.
Oh, reversal of roles in several matters.
Mohim Shashmal appeared in this matter on behalf of
Who is appearing? Please use the microphone.
Mr. Mohim Shashmal appeared in this matter
Who?
on Mohim Shashmal.
Mohim
Appeared
Shashmal.
in this matter on behalf of the petitioner. Today he has not come to court due to his illness, my lord. His clerk informed me.
When should I keep it?
Not today, my lord. Make it not today.
Tomorrow in this weather, he may not get well soon. I mean, I'll keep it next week.
Lordship.
An adjournment is sought on the ground of illness of learned counsel for the petitioner. Let the matter stand adjourned till May 7, 2024. Next
only
Tuesday.
one thing, my lord, in this case, my lord, I think, my lord, presence of the state is required.
State is not a party.
State.
Mr. Samanthi is the state. Mr. Galib and you are the state, as far as I am concerned. You appear mostly for the state.
Concern for the state.
No, Mr. Ganguly is also there.
Concern for the state.
Right, next. Protocol.
Item number 8. Mrs. SBS Construction and
Yes, what
others
is the matter?
versus
Petitioner, my lord. My lord, this is my
Good service affected or all?
service evidence.
Yes.
Please, Lordship, I'm appearing for the port trust, my lord.
Yes.
My lord, the petitioner is the empaneled civil contractor of the concerned port trust. And petitioner has submitted 3 bills amounting of rupees 10,40,779. After the submitting of the bills, petitioner got to know that the GST registration has been cancelled. After that, the petitioner has submitted the dues in the GST registration authority along with the penalty and other charges. On 6th May 2023, the GST registration of your petitioner was revoked. After that, your petitioner approached the respondent authority to clear the dues.
No, it was revoked or revived.
Revived.
Say that. You said revoked. You have put in the dues and the penalty and it has been revived.
Yes, my lord.
6 May 23.
6 May 2023.
They were not giving you the rest of the dues due to, they have given you some amount. Nothing. On the ground that the GST registration was cancelled.
After that, GST registration was cancelled. After that, I have
revived and then went back to them for the money. Then what
demanding.
happened?
On 22nd November, I have sent a notice to give my money. But on 14th December, they have given a reply. Well, kindly come to the page number 44. Well, call 44.
Next time, give it directly to Mr. Jana. You'll get your money. Yes. What is the matter? What is the ground for refusal?
In paragraph number 4, they have stated no GST amount has been paid for the invoice number such and such, and such as GST registration of SBS construction was cancelled. However, 3 revised GST invoices were submitted for above 3 invoices after revocation of their GST registration on 6th May 2023. And only GST amount has been paid. But
no, it was revoked. You are right in the first occasion. It was revoked on 6th of May.
Yes, my lord.
If the GST registration was revoked, when was it revived?
6th May 2023. I have the
revocation and revival are exact opposites. Revocation means it's cancelled. Revival means it becomes alive again. What are you saying? Revocation of the GST registration was on 6th of May.
My lord, one.
Where have you stated that it was revived?
Well, I have annexed that letter which has been which has been sent from the GST authority, and annexure number P5 page 28. It has been restored.
Oh, revocation of cancellation of registration, double negative, and it has been stated that revoked. The registration was. So accordingly your registration is restored. This communication was made on 6th of May. So the cancellation was revoked. That is a double negative. So it was revived.
Right.
But they have proceeded on the basis that it has been revoked on such a. Yes, it was a mistake apparently.
No, my lord. May I only indicate the facts very briefly, my lord, and I'll be praying for a chance to file affidavits because these documents are required to be brought on record. My lord, I'll indicate what The facts are that the petitioner is a contractor with the port trust. We are entitled, after making the payments against the invoices, we are entitled to avail the input tax credit. Provided my learned friends, the petitioner pays the amount of GST to the GST authorities. When the transaction happened, a suo motu cancellation of registration with effect from
you say that the registration cancellation was not the mere ground.
No.
I mean, because he
The
did not pay
difficulty
this,
is,
because of cancellation of registration, he did not pay that amount.
and
During
we
that
could not
period.
avail the
You
ITC.
could not avail the.
Now the fact that we could not avail the ITC for that period.
If you
is a-
deduct those amounts from his dues,
That's what we have done, Miller. Subsequent bills, and that we are entitled to in terms of the contract between the parties. I'm carrying that clause.
Even under the GST law, probably. I mean, you are entitled to that.
Also,
they have
since
to
it's
pay.
a dispute between the petitioner and the GST authorities, that
is
the
that
cancellation
you are
of
not bothered.
registration and thereafter revocation of cancellation is between the petitioner and the GST authorities.
So you are bothered with only whether they paid the GST
ITC,
amount.
Miller. We are only bothered with the input tax rate, which we could not avail because the registration was cancelled. And that we are entitled to in the subsequent invoices. We are entitled to deduct that. That's what we have done. And that deduction, the entitlement for that deduction, Milord, is borne out by the tender document, clause 37.
Where
the
is
taxes, Milord, this is the extra documents which we have, Milord. Maybe hand over the
You
bunch.
could have annexed the tender document also, because we want to look into the clauses.
I find that the entire tender document is also not being handed over to Purutani. Only the clause, relevant clause, Milord.
Very well, I'll direct you to file affidavits.
Very good.
Annex clauses.
Only one thing, if I may indicate, the taxes part, this is page 8 of the bunch, Milord, which has just been handed over. Taxes, the third paragraph. Kolkata Port Trust. Milord,
Did
this
not.
is the
I'll
end of the
just
paragraph.
indicate. I'll just indicate.
Why not?
Learned counsel for the petitioner submits that the petitioner did work for the respondent Kolkata Port Trust. Full stop. In the interregnum, comma, the GST registration of the petitioner had been was cancelled. Full stop. However, subsequently, on the petitioner paying the dues and penalties, comma, such cancellation was revoked, comma, thereby restoring the GST registration of the petitioner. Full stop. Next para. However, comma, the Kolkata Port Trust has refuted the petitioner's monetary claim for the work done by the petitioner inter alia on the ground of revocation of the GST registration, despite such cancellation having been set aside and the GST registration being restored on May 6, 2023. Push up next para. Learned counsel appearing for the Kolkata Port Trust submits that the petitioner, that the Kolkata Port Trust would be entitled to the input tax rate in the
input tax credit, Milord.
Input tax credit in the event GST was paid by the petitioner at the relevant points of time. Full stop. However, comma, since the petitioner did not do so, comma, apparently in view of cancellation of the petitioner's GST registration during the relevant period, comma, such entitlement of the Kolkata Port Trust has been lost. Full stop. Thus, comma, in terms of the clauses of the tender document, comma, the Kolkata Port Trust has deducted the amount due to the Kolkata Port Trust in lieu of input tax credit and has paid the balance amount to the petitioner. Full stop. Next para. Learned counsel for the Kolkata Port Trust seeks to rely on several clauses of the tender document in that regard. Full stop. Next para. Since the tender document and the pleadings are not yet part of pleadings of the Kolkata Port Trust are not yet part of the record, comma, the respondents are directed to file their affidavits in opposition within June 14, 2024. Full stop. Reply, if any, shall be filed within June 21, 2024. The matter shall be listed for hearing in the month of July 2024.
Very deeply obliged.
Vishwajit, the affidavit of service filed to be kept on.
Item number 9, Gautam Dasgupta
Yes.
and another versus
Yes,
like.
my writ petition. May I kindly find the.
All have been served?
Yes, my lord. The affidavit.
You
of
are for the?
And for the respondents, Your Lordship, this morning, couple of hours back only, I have received my
This
brief.
morning?
Couple of hours back only, I have received the brief. I'm yet to file the wakalatnama. It is in the process, Your Lordship.
When should I take it up? Tell me. Monday or Tuesday? I'll take it up.
Tuesday, Your Lordship.
Your Lordship's Tuesday, if it pleases Your Lordship.
Tuesday, I'll keep it. Yes. An adjournment is sought by learned counsel having instruction to appear for the LIC.
I have received one letter, but I am yet to file for my.
That is why having instruction. I could not. You can file that. Push up the written instruction filed today. Be kept on record. Full stop.
Written instruction.
However, learned counsel for the learned counsel submits that she does not yet have the power to appear. Push up accordingly. She seeks for an adjournment. Push up. In such view of the matter, let the writ petition stand adjourned till May 7, 2024.
Your Lordship, may I seek an indulgence? Can it be Thursday instead?
Till May 9, 2024.
Grateful, Lord.
Right. The written instruction filed today be kept on record. You have a copy of this?
I do not actually, Your Lordship.
Sorry, the written instruction filed.
Grateful, Lord.
Come back on Thursday. Yes.
Order. Item number 10, Gokul Repulse and Solvent Limited.
File my affidavit of service, my lord. Order good
Yes.
service, my lord.
All have been served.
All have been served, my lord.
What is the matter?
My lord, this relates to a scheme floated by the state of.
You have checked up good service.
I've checked up good service personally, my lord. This relates to a scheme floated in the year 2008 by the government of West Bengal, saying for the purpose of promoting industry in the state of West Bengal, certain incentive will be given to a particular segment of industries under which the petitioner applied. Application was made under 2009. They have complied all the provisions. Now there are certain segments by virtue of which I'll be entitled to get back that financial benefits. That too, the same will be adjusted from the VAT paid by me during a particular financial year. But what happened up till 2012-13, I have received my entirety, whatever my entitlements were. 2013-14, but those payments, it will be pertinent to mention, those payments have been received by me on a very belated stage. 2013-14, I received some part payment. Now, prior to the payment being received by me, there is a precondition that the payment, my entitlement, has to be certified by the Department of Commercial Tax, West Bengal, as that was at that point in time, prior to GST come into play. 2014-15 onwards, neither those certificates have been favored by the department concerned to ascertain whether I am eligible for that purpose or not. I could not continue with my business due to the non-compliance on the part of the government to give my entitlement, whatever it was. My entitlement, which was due for the year 2013 and 14, was 52 lakhs. 2014-15 onwards, up till 17, my entitlements went to almost 30 and more crores. So that has not been received. In 2017, what I did, I entered into an agreement with Adani Wilmar. It's a business transfer agreement on a slump sale basis. My entire segment was transferred. The unit was still running. Now, in the interim, I filed a writ petition before this honorable court in the year 2019. I sought for certain relief. One of them is to pay my entitlement, which was there prior to 2017. Because one of the main crux of the scheme is that the entitlement of me under fixed capital investment has to be disbursed to me within a period of 8 years from when I am entitled. Now that 2017, my 8 years period have elapsed. My transfer is on 2017. Now, directions were initially given. They choose not to file their affidavit in opposition. I came up in a thereafter I came up in a contempt. In the contempt proceeding, they have been given an opportunity to pass a reasoned order based on my representation, whether my entitlements will be given to me or not. They initially passed an order. I brought it before the knowledge of the court, that is a non-speaking order. They have been further given up an opportunity to pass a reasoned order. This time they gave me a detailed hearing. The order was passed on September 2023, which is the order impugned. May I, if your lordship be pleased, then I can take your lordship to the order impugned. My lord, it's page 196 in volume 2. Page 192 onwards is the order impugned.
Two things, my lord, I'd like to place before your lordship. One is the order impugned and the parameters laid down under the scheme of 2008. Lord, if I may allow to please, my lord, the finding.
But affidavit is directed in this matter.
My lord, I believe.
Appearing for the first time or?
Appearing for the first time, my lord.
Direct affidavits in this matter. We cannot hear this without affidavits.
Lord, I bow down before your lordship, but if your lordship be kind enough to allow to place the relevant portion of the order impugned.
How will that help you? There is no scope of any interim order.
My lord, though I have prayed for an interim order, but I won't.
What interim order? The money may be
50% disbursement, my lord. This is of 2019. Kindly see the order impugned for once, my lord.
The petitioner has made out a strong prima facie case as to the impugned order dated September 26, 2023 being thereby refusing the petitioner's subsidy under a scheme floated at the relevant time by the respondent authorities is vitiated by principles of natural justice as well as by non-consideration of the entitlement of the petitioner on the basis of the scheme itself. Full stop, next para. As such, the writ petition is required to be heard on its merits. Full stop, the respondent shall file their affidavits in opposition by June 14, 2024. Full stop, reply finish shall be filed by June 28, 2024. The matter shall be listed for hearing in the monthly list of July 2024.
My lord, one indulgence instead of monthly list of July, my lord, if your lordship be pleased to fix any date, my lord.
No fixation of date.
Grateful.
Item number 11, Crown International and others versus
For
Impleadment.
the petitioner, my lord, I am
Yes.
led by Mr. Moina, Coast Learned Counsel.
He's sick, yes. When should I
Your
keep it?
lordship may kindly fix this matter on
On
9th,
9th.
subject to your lordship's convenience.
I'll keep it on 9th. On the prayer of learned counsel for the petitioner, let the matter stand adjourned till May 9, 2024.
Item 9 also, next matter also I'm playing that. Let it be called.
Should be called. Item number 12, MKN Investment Private Limited.
Same ground, same order.
I was also praying for the same relief.
Mr. Boynak Bose, yes.
Lordship, may I file
9th. This will also appear on 9th.
Lordship, may I file the affidavit, my lord?
This is what?
Affidavit in opposition.
There was a direction.
Lordship.
আচ্ছা affidavit in opposition তার সঙ্গে একটু অ্যাড করে দিতে হবে affidavit in opposition file to be kept on record 12 this is 12
lordship.
On the prayer of the petitioner 9th affidavit in opposition
reply
file to be kept on record reply
I'm filing it, man. Filing course.
on the prayer of the petitioner comma the petitioner is granted leave to file the affidavit in reply during the course of the day.
Lordship, instead of 9th, can it be on 12th? Subject to my lord.
Can be, yes. 12th is a Sunday.
13th.
He wants it on 12th. No, 9th. Come back online.
Lord, Mr. Shah is not there on. I am told that he is not there on 9th.
Who?
Mr. Shah.
Mr. which Shah?
Joy Shah.
So Joy Shah will not be there on 9th. When should I keep it, Mr. Mr. Sharma? 12, very well. তাহলে যেটা বললাম একই থাকবে শুধু ডেটটা হবে 9th 12th প্রদীপ বাবু ওটা 12th করে দেবেন হ্যাঁ
13th 12th is Sunday.
13th, sorry. Yes, next.
For hearing, item number 13,
My lord,
Dalmia
I'm
Securities
appealing
Private
for
Limited.
the petitioner, my lord.
If you're asking for time, say that now because before you
No, my
put
lord,
that bulk up on the table.
No, my lord, Mr. Ray was addressing you for the respondents, my lord.
Your Lordship, Mr. Jayanta
Our
Sharma is
submission is
appearing in
already
this matter.
complete.
He's just on his way. He's appearing just. Lordship has just arrived.
Appeared. Yes. This is a stock exchange matter.
Yes, that matter.
That's very
Well,
good. This will never end probably.
The difficulty is perhaps one good hour's time.
Mr. Rai was appearing with you. in
Yes,
this
he
matter.
was leading me and he was addressing your lordship.
So what can be done? Where is he now?
Well, on legs somewhere.
Friday 4:30 on legs somewhere.
That is something I knew a few minutes back. Now
I must be on legs somewhere, but it may be someplace else. The picture is nice, Mr. Rai's picture. Must be at least
Thereafter,
years,
I was
30
told
years.
that you were supposed to visit the learned AG.
No, 30 years back, for school days. So what? The picture is not addressing me.
My lord, the thing is, we will be needing at least an hour's time, my lord. Only the issue that we need to address, your lordship, is on, my lord, the settlement guarantee fund. And my lord, that apart,
Whatever time
the
you take, Mr.
bylaws.
Shenguta, I'll have to, I mean, whichever day does not matter to me. I'll have to take
Whenever
it up.
your lordship pleases, my lord.
I can keep it tomorrow then. Any difficulty tomorrow?
No,
They're
tomorrow
addressing.
we don't have any difficulty.
Very well. Very
You have
fair
no,
enough.
no difficulty
No,
tomorrow.
we-
But tomorrow is
Oh, I'm sorry. Monday. Uh,
The next working day.
on the prayer of the Calcutta Stock Exchange, let the matter stand adjourned till May 6, 2024.
very good. Great.
My lord, subject to your list, my lord, could it be given some priority since, my lord?
This matter cannot be given priority because so many motions are there, court applications.
The top at butter.
I'm being able to reach the court applications only because these hearing matters are down below. Only for that reason.
Much obliged.
Great.
Item number 14.
Yes,
MK
sir.
Developers versus Indian.
Your motion also goes down.
No, yes, yes. No, I want to praise my case today because I am suffering for a pretty long.
Right.
My lord, Mr. Atrup Banerjee.
ঠিক আছে, আমি বলি না, আপনি শুনুন, note
Yes,
করুন।
Mr. Atul Banerjee, complete your submission. Is coming.
My lord, Mr. Atrup Banerjee, on behalf of the Mr. Respondent, my lord.
He was there in the morning.
He is not. I phoned my lord. No, he has not response. But I don't know where is he, my lord.
That can be a submission before a court. Mr. Dattu, yes, start your
নোট
word.
ডাউন করুন না, পরের দিনে রিপ্লাইটা দেবেন।
Yes, yes, start your word.
Lord, this is the tender matter. Defense. That there is a general condition of contract. This is required for the adjudicating of this matter. এটা একটু দিয়ে দিন।
My officer is busy otherwise. Yes.
Lord, first I want to place the page number 13 of the writ petition.
Of the writ petition?
Yes. I have filed the reply today.
Yes, page 13.
Yes. Lord, kindly, this is the works order, and the last portion that is to be noticed, my lord, the SP Chaturvedi, last portion.
Yes.
SP Chaturvedi, ACSAJ, officer, chief engineer, for and on behalf of the President of India, accepting officer. Why I am showing it? As per this condition, it is compulsion for any matter of a tender.
Yes.
He has not a personal officer designated. He has to mention compulsorily he is signing this letter on behalf of the President of India.
So he has done it?
Yes.
Right.
I am coming later on. Why there is anomaly. First of all, it is correct. Absolutely, he has followed the proposition, but later on he has failed it in the termination letter. So that is the challenge of this writ petition.
You are challenging the termination.
Termination letter, but that has not been mentioned. Lord, then page number 17. There are 3 times the extension was granted. First, the date of handing over site was the 1st January 2019. Date of commencement of 1st January, your lordship got it?
Yes, yes.
1st January 2019. Completion as per contract was 27th of October 2019. Extended date of completion 31st May of 2020. That is a first extension. Next extended 30th November 2021. Third extension is the up to and including 31st of May 2022. There are three extensions in this matter, and they have, from their own side, they have extended. That is not the case. The contractor approached, because the condition is this. Next point. It is an express condition, white condition number 11A, 4 and 11D. Now kindly come to this general condition of contract. 11A, what is the condition of 11A, 4 and 11D?
Yes.
Page number 29 and 31 of this manual.
Right.
11A, B, B, 4. 11, page number 29, page number 11, clause 11.
Yes, you have marked it.
Yes, marked it.
Thank you.
The reason of any other cause First is the kindly this is required to be looked into the first one, otherwise it would be some difficulties. The reason of civil commutation, local combination of workmen, strikeout, lockdown, it is under one. Next two is the by reason of delay on the part of maintained by the subcontractor or nominated suppliers which the contractor has in the opinion of the G. And the third is the reason of delay on the part of the contractors or tradesmen. And fourth, that is applied here, the reason of any other cause, that means not above three. Neither on the part of the contractor, subcontractor, actually it is in the part of the contractee. By reason of any other cause except force majeure, which in the absolute discretion of the accepting officer is beyond the contractor's control. That means the extension granted 3 times, that is on the part on their failure to cooperate the contractor to complete the work within the time frame. So they have extended time to time. It is not in fault in my part. I am able to clear the point.
No fault on your part.
Yes. So that they have voluntarily, as per clause, they have mentioned in their letter, under this 11A4 is applied for extension of time. That is in their part.
Got it. Yes.
Yes. Next, 11D, next part. 31 page. No claim in respect of compensation or otherwise for idle labor and oblique of idle machinery, etc. and oblique of business loss or any such loss, howsoever arising as a result of extension granted under condition A and B above shall be admissible. No starting point, no, that will be no admissible. No claim starts for, sentence starts for no and admissible, no claim admissible. The decision on reason of quantum of extension shall be final and binding. That there are 2 clauses has been applied here for granting extension on 3 occasions, clearly mentioned there. Then the last point, kindly come to page number 17 once again. Technically checked. Last, technically checked.
Yes.
Point number 5. Now my opposite party will explain what is the meaning of technically checked.
But your opposite party is not picking up his phone. He said that is the ground on
from
which
my understanding, technically checked is a very wide meaning. Technically checked.
No, technical check. Then
yes.
Let us proceed after that.
Yes. Next kindly come to page number 21. There are 2 contracts between this contractee and contractor. There was a dispute in respect to the contract number 1. It is a contract number 2. In respect of contract number 1, what was the dispute aroused? That is page number 21, last paragraph. After all, there is a complaint lodged to the chief engineer. I am just citing the relevant portion. Letter starts from page number 18, addressing to the chief engineer, Hyderabad, from where this tender was floated.
All right.
After all this, I, Mata Prasad Pandey, partner of Messrs. MK Developers, went to his chamber in the evening around 7 PM and again requested him, stating my mental and financial position, and requested by begging him for the payment. On this, Mr. Masood Ali was silent for a minute and told me that he will release all the payments in March 2021, and he returned and asked a bribe for rupees 10 lakhs against it. He also warned me that if I do not do my contract will get cancelled and the PEB structure will also be rejected. That was dispute in respect of tender number 1. And
he wanted a bribe of rupees 10 lakh.
Yes.
What is your total claim?
That is in this. No, he for passing the bill.
Oh, for passing the bill.
For passing the bill. I have done the work. I have a.
So what is your total claim in the bill?
In this matter, total contract amount was 2 crore 50 lakhs like this. And
did you pay the 10 lakh?
So if it was paid, there was no dispute. In a short.
No, any internal inquiry was started on this?
In this regard, another petition I have filed. Your lordship give a direction to make a concerned police station, make a lodge a complaint, and that is going on.
Right.
I am just pointing out because there is a dispute between the 2 contracts. So there is a link. For this purpose, this is affected.
No, Mr. Dotto, before proceeding further, what is the cause of action of the writ petition? Let us start from there and go back. The termination is the challenge.
Termination is under challenge.
Correct. So you want to show the preceding circumstances?
Yes.
Which led to that?
Yes. Otherwise, if I go to the directly to termination.
No, need not. Very well. Then?
Next, we page number 30. That was the last payment, last RAR. Page number 30 is the last area due. Amount of rupees, kindly come to the last portion, 2,69,775. This is generated by the respondent authority. This is RAR, writing account receipt, that is generated by them. This is not my bill.
No.
They have generated my bill, but they have not paid the amount to me within the due time. Then one kind of extortion, one kind of exploitation, whatever you like, because I have devoted my time, I have employed my money, I have labor, but I am not getting money in return. It is their bill, they are not getting payment.
Right.
Next, we will come to page number 34.
Mr. Dotto, did I direct affidavits in this matter?
Yes, yes, yes. There is a direction.
They
There
have
is
filed
yes,
affidavit?
yes, exchange.
Right. Affidavit আছে তো রেকর্ডে? হ্যাঁ, এখানে আছে। Where to this?
ফাইল করেছে। ফাইল কর। কিছুই করো না। আগের দিনে ফাইল করেছে বোধহয় ওরা।
Yes, yes, it is there. Let us continue. Yes.
Now kindly come to page number 35. That is a termination letter.
30?
35, 35. That is a termination letter, type copy. Kindly come to page number 35. 34 is the original copy, but kindly come to 35. That is a type copy.
Yes.
Second paragraph. In spite of notice issued to you under the above mentioned reference in connection with the work to be executed under the above mentioned contract, you have failed to proceed with the work with due diligence. Thereafter, I, the accepting officer of the contract on behalf of the government acting under the powers vested in me in terms of condition 54 of the general condition of contract, IAFW 2249, and without prejudice to any other rights or remedy which shall have accrued or have accrue thereafter to the government under the terms of the above said contract, hereby cancel your contract on account of your default on the said contract shall stand cancelled with effect from 18th February 2023. On which date the letter was issued? 18th February. Kindly see the top. Immediately. 15 days time has not been given. 18th February they have issued the letter and on the same very day effected. Please note that the works as defined in the contract condition number 1 of the general condition of contracts will now be got completed by me through other agency at your risk and cost. You are accordingly requested to report the GE North Kolkata at his office in person or through an accredited representative at 11 hours on 25 February 2023. When an inventory of the complete items of the works material, if any, left by you at the site will be made and recorded jointly. In the event your failure to keep your appointment, inventory will be nevertheless be prepared, notwithstanding your absence, and the same shall be fully binding on you. This is without prejudice to any right and contention. Kindly see the last portion. Yours faithfully, Sushil Kumar, Brigadier Chief Engineer, on behalf of the President is not there. That means in his personal capacity he has written that is not binding upon me. That is my point.
No, in the termination letters to each of the contractors on behalf of the President has to
Yes, yes, yes. Kindly come to the clause. Termination clause is the condition number 50, page number 56. It is page number 69.
No, 54 probably. Termination.
Yes, yes, 54. 54. 50, yes, cancellation of contract in part on full, contractor's default. It is in contractor's default. 54, they have applied 54. Failed to complete the work, 54D, work order terms. But I want to show, my lord, that the
accepting officer may, without prejudice. That is the language you have underlined.
Yes.
Page 60. So that accepting officer has done it?
Yes.
So why do you say the President should be, on behalf of the President should be there?
That I want to, just to give it 54, 59. Condition number 69. Kindly come to page number 77. Condition number 69. Issue of notices. Subject as otherwise provided in this contract, all notices including termination notice, not is exempted. All notices to be given on behalf of the President of India and all other actions to be taken on his behalf may be given or taken on his behalf by the G or any officer for the time being entrusted with the functions, duties and powers of the G. by this clause, he was bound to issue notices at the time of work order as well as at the time of termination of a contract. That is binding upon him.
But page 60 says the accepting officer may terminate the contract.
Accepting officer, but he has to terminate the contract on behalf of the Union of India, the President of India, in not as persona designator, not as a persona designator.
Very well. So we'll continue tomorrow. You want to say something? Yes, what? আচ্ছা একটা order record করে heard in part for further hearing tomorrow.
Monday.
On Monday. কি গো?
Reply to be noted.
আচ্ছা affidavit reply file to be kept on. Yes, what do you say?
Apologies to trouble your lordship at this.
Please use the microphone, ma'am.
Lordship, apologies to trouble your lordship at this moment. Lordship, item number 44, motion stage. Lordship, your lordship was pleased to direct it to appear in the monthly list, your lordship. Lordship, I'm led by Mr. Mukherjee. He was on his legs. Lordship, kindly keeps it on Monday.
No, if I have passed an order in open court, no.
Lordship, I'll send a notice. Lordship, it's extreme urgency, your lordship. I'll notice it.
At the time of the when the matter was called, you had to be there.
Weren't appearing, your lordship. Today, the respondents did not appear. We have the affidavit of service file.
It was called on and put by me in the monthly list.
Indeed, your lordship.
What can be done? Why were you not here?
Lordship, kindly.
No, I've passed an order in open court. How can it be? Monday, you are saying?
Lordship, we were there. We were present here.
You are saying let it be on Monday.
Monday, Tuesday, Lordship.
Monday, the comment list will come up only.
Lordship, under the heading motions, your lordship. Same heading, your lordship. Lordship, the matter needs to be heard, your lordship.
What is the matter? I mean, what is the heading today?
New motion.
Side matter, I'm taking original side matters now.
Lordship, I'm mentioning of appellate side matters, Lordship. Lordship, kindly, your lordship. Lordship,
I cannot. I'm taking original side matters now. My officers are not here. And my entire setup is not here. Yes, Mr. Sharma.
Leave to file the affidavit, item number 12.
Lordship,
Sorry, ma'am.
I'll serve.
No.
Lordship, Tuesday, Lordship, kindly, Lordship.